for convening us. I'm so pleased to be here today with all of you to check in on the status of marijuana rescheduling. Thank you to the OSU DEPIC crew for inviting me to be part of this event. It's wonderful to have you on campus, and it's a joy to be your colleagues. Okay, so if you're tuning into this webinar, you are likely very aware that in October 22, President Biden directed the Secretary of HHS and the Attorney General to begin a process to review how marijuana is scheduled under federal law. Now, certain drugs and other substances are on various schedules. Schedules are a term of art, and those schedules determine aspects of how those substances are regulated. Now, marijuana is currently listed on Schedule 1, which is the most restrictive schedule, designed to be those substances with, quote, high abuse potential and no accepted medical use. And Schedule 1 drugs cannot be prescribed, dispensed, or administered. Now, Congress has the ability to place drugs on different schedules, so it's important to remember that rescheduling doesn't always need to be done within the executive branch. Congress could do it on its own. But Biden's order sparked a multi-step formal rulemaking process that's ongoing. Now, I wrote a little bit about this process when I took a look at how another drug, methadone, is scheduled. And as Matt will explain, the executive branch has the legal authority to reschedule drugs, but it also has steps that it needs to follow when it does it on its own. And some of those steps have been taken by now for marijuana, but not all of them. So we're here today to check in on the progress of Biden's order. And obviously, we have a different president now. Now, sometimes executive orders cross over from one administration to the next and continue to be enforced, and sometimes they don't. Now, to work through where things stand, I'm so pleased to have three experts join me to talk this out. Our first is Kat Packer, distinguished cannabis policy practitioner in residence here at Ohio State. She also comes by that position by way of her impressive career in this space, including roles with the Drug Policy Alliance and the City of Los Angeles. Matt Lawrence joins us from Emory, where he's a law professor and a scholar extraordinaire, as well as a former senior advisor to DEA, part of the Department of Justice. And then, of course, my OSU colleague, Patricia Zettler, the John W. Ricker Professor of Law here at Ohio State Moritz College of Law, and just back from time serving as Deputy General Counsel to HHS. So we'll have some discussion on this panel, but I want you to feel free to add questions into the Q&A window. We'll try to work in some responses to your questions along the way, and we'll hold some time at the end for your questions too. Okay, let's just jump right into it. Now, Matt, could you start us off by telling us more about the process for administrative rescheduling of substances in general and DEA's role in particular?
Yeah, thank you, Bridget. Happy to jump in. I'll say thank you to you and the Drug Enforcement Policy Center. You all, any of you joining from Ohio or Ohio State, you have such a gem. It's a national kind of leader in this space that you have there. I also want to say that I'm sharing my own opinions and views and not those of current or former employers. So then I'll jump in. So let me start right at the top. We have a system of checks and balances under which normally Congress makes the laws, the president enforces the laws, and the courts adjudicate disputes. And so the normal thing under our Constitution would be Congress would make decisions about banning marijuana or not, and that would be done by representatives and our senators through law. But very often in the administrative state, what we do is Congress passes a law that gives some agency under the president power to make those choices themselves. So instead of doing it the kind of constitutional default way of Congress writes a law that says marijuana's banned, marijuana's not, Congress writes a law that tells an agency like the Department of Justice, that's what the Controlled Substances Act does. Congress writes a law that says, Department of Justice, you, working with HHS, which Patty will talk about, you make decisions about drug scheduling, what's banned and what's not. And then in the Controlled Substances Act, Congress said, and you have to follow these very specific rules for how you get to make those decisions. You can't just wake up in the morning and tweet, marijuana is banned now, and it becomes banned. You have to follow very complicated steps. And so now I'll describe what those steps are, but I just want to reiterate, those are steps set forth in laws that we the people wrote through our representatives in Congress. And so the administrative officials are kind of doing their best to work through the instructions we gave them. So what are the rules? I'll try to be quick, but the process for the agencies to change the schedule for a drug to unban it or ban it or allow medical use or those types of things requires the agency to choose from a menu of 5 regulatory packages, which are schedules, and Schedule 1, 2, 3, 4, 5. And the agency has to go through a really long checklist to make that choice. So first, there has to be views sought from HHS about the kind of medical and scientific questions. And I'll leave it to Patty to talk a little bit more about that. But HHS, the Department of Health and Human Services, that's currently headed by RFK Jr. That agency has to provide medical and scientific kind of advice, is binding in some ways, to the Department of Justice, to the Attorney General. The Attorney General, that's currently Pam Bondi, the Attorney General has said, just like Congress said to the Attorney General, hey, we're not going to decide ourselves about marijuana, we want you to do it. The Attorney General has said to DEA, Congress asked me to decide this, but I would like you, DEA, to decide this for me. And that happened in the 70s. So then DEA gets HHS's advice, and it has to go through a process where first it issues a notice of proposed rulemaking, where it tells everybody I'm thinking about rescheduling. It seeks comments about views from anywhere in the nation. It then is required by the statute to do what's called formal rulemaking, which is almost like trial-like. There has to be like a hearing. And so then after comments are received from all across the nation, the agency has to have a hearing officer appointed, an ALJ, that's Judge Mulrooney, who's overseeing this proceeding right now. And then the ALJ has to work with the agency and the parties to identify witnesses, to set up cross-examination, to do pre-hearing procedures, and then ultimately to hold a hearing where it's like law and order or something. There's people in a courtroom and they're getting up and they're presenting witnesses, cross-examining witnesses. The decision in the courtroom is, of course, not is marijuana guilty or innocent or something like that. It's does marijuana fit these very elaborate questions that go to currently accepted medical use and risk and things like that. And then ultimately there'd be a set of findings from that hearing. And then that hearing decision would then go to the Attorney General or on delegation to DEA. And DEA, the DEA administrator would issue a final scheduling decision, either saying, yes, I'm rescheduling, or no, I'm not, which is another way of saying, yes, I'm shifting it to a different option I have where you can have medical use, when you can't now or something like that. And then finally, once that decision is reached, the statute says if people are upset by the decision, they can appeal directly to a circuit court. And they can go to a circuit court of appeals and say, the agency messed up the law, the agency messed up the facts. That's happened a lot over the years with scheduling actions. And that potential appeal is kind of the last step once we get the ruling from the agency. So that's my best 5-minute overview of the process here.
Okay, well, I'm exhausted already. That is much more involved than a lot of the ways that other agencies make rules. So when Congress gave these agencies the ability to change the way drugs are scheduled, they set up this elaborate series of hurdles that the agencies have to go through. Matt, just before we move on to Patty to talk about HHS, is there anything else that you'd point out about the specific role of DEA in this process? I mean, that's where this formal rulemaking process happens, is at DEA. Is that right?
Yeah, I would say that in the Controlled Substances Act, the DEA is not mentioned. They didn't exist. So when we have people who wrote the rules, DEA was maybe a twinkle in our eye. But then what's happened since the early 70s is DEA was created, and kind of authority for all of this within the Attorney General's office, within the Department of Justice, was delegated to DEA. So there's a regulation, I won't give the exact site, where it says all of this power that the people wrote goes to the Department of Justice. If you're Attorney General, that's going to go to DEA and the DEA administrator, and there it has sat for 50 years. So if you go read a typical blog post, let's say, explain the process, it explains the process as it's kind of operated for the last 50 years, rather than necessarily one in the statute. And the one as it operates is that DEA is running the whole show. Now there have been, it's important to make this distinction because it's going to come up later in our talk, I think, some of these differences.
Yeah, no, totally. Okay, so let's get Patty into the mix here, and so round out for us the role that HHS plays in this process.
Yeah, so first of all, thank you everyone for being here. Thank you, Bridget, for that kind introduction. And big thanks to Matt and Kat for participating. That was a great introduction to formal rulemaking, and I wish I had recorded it so I could play it for my law students when I teach about these processes in class. But as Matt mentioned, ultimately, when we're talking about the administrative scheduling process, it is DEA's decision about how to schedule a substance. But when we, the people, wrote the Controlled Substances Act, HHS was given a significant role. So under the Controlled Substances Act, before DEA initiates proceedings to schedule, reschedule, or totally deschedule a substance, the law requires DEA to request from HHS, the Department of Health and Human Services, a scientific and medical evaluation of the substance and a recommendation about what schedule, if any, the substance should be placed in. And the idea there is that scheduling is not just a law enforcement question. So why Congress wrote the law this way is that scheduling is not just a law enforcement question. It also involves these questions of science and medicine about what the substance actually is, how does it pharmacologically operate, what risks does it pose to individuals and the public health, and so on. So this is the sort of compromise in the CSA about how to balance those medical and scientific questions and the law enforcement questions associated with scheduling. So DEA requests that evaluation from HHS and that recommendation, and then HHS does its thing. There are factors in the statute that HHS is required to consider, and ultimately, as happened here in August 2023, HHS communicates a recommendation to DEA about what schedule a substance should be placed in and explains its medical and scientific determinations. Here, HHS recommended that marijuana be placed in Schedule 3. I see a question in the chat about currently accepted medical use, and I think we'll get to that later. But in terms of just understanding the process, HHS's scientific and medical determinations are binding on DEA when it proposes to schedule, reschedule, or deschedule a substance. And then they're owed significant deference from DEA at the point when DEA is finalizing its decision. So this recognizes that the HHS recommendation comes before a proposal. And as Matt talked about, there's all this opportunity for public input after the proposal, both comments on the proposal at a hearing, et cetera. So DEA's ultimate decision has to incorporate that part of the process as well. So again, it's ultimately DEA's decision, though HHS plays a strong role. The one exception to that is if HHS recommends that a substance not be scheduled at all, then DEA is prohibited from scheduling it. But here we're not in that bucket.
Okay, so that's a great starter pack on how this process works in general. Kat, is there anything that you want to add to the sort of formal process as we understand it? And then we'll get into the specifics of how it's working on marijuana.
Yeah, just to add that there are a number of circumstances in this particular rescheduling decision that were kind of out of the ordinary, and I'm sure we'll get into that. But in part, it being the Department of Justice that actually issued the proposed rule and new tests for currently accepted medical use. I know we'll get into that a little bit later. But just to say there is this complex process, and thank you, Matt, for describing it in such a concise way. You did it in 4 minutes. I often try doing that in 45 minutes. But there were some deviations from the standard process in this particular rulemaking.
Okay, so let's get into that then. Let's talk about how this has been working for marijuana in particular. So Biden in 2022 sort of sets the agencies down this path. So Matt, where are we in the process for marijuana? Basically, what's happened so far?
Yeah, and I'll say I can tell what has happened so far from public reporting and the public docket items. I actually have no insight. I did not work on marijuana scheduling when I was with DEA, but I can describe what's kind of out there in public. So I said how the process starts, where there's a HHS shares views, and then from the Department of Justice or DEA, and we'll talk more about that in a second, there is a notice of proposed rulemaking to begin the process. And what happened this past year was very interesting. The agency, the Department of Justice put out a notice of proposed rulemaking to reschedule marijuana to Schedule 3, to shift it from Schedule 1 to Schedule 3, and this is a proposal. And so then, of course, the headlines are all like, DEA is rescheduling marijuana and that kind of thing. But if you really look closely, there were a couple of interesting things that happened at that time. First, the Department of Justice's Office of Legal Counsel, which is it's like legally authoritative. When there's a dispute between agencies about what the law means, like if I dispute what the law means with an agency, I go to court. But if two agencies are fighting about what the law means, usually they don't go to court, instead they go to the Office of Legal Counsel. And we get indication of that from the Office of Legal Counsel at the Department of Justice, which is it says DEA has said that this particular term in the statute, currently accepted medical use, does marijuana have currently accepted medical use? DEA says it means a certain thing, which we can talk more about, which is fairly hard to do, or really hard to do. And then HHS, Department of Health and Human Services, says actually what that means in the statute is more, it's still tough, very tough, but it's not quite as tough. And what the Office of Legal Counsel said is we actually think that HHS is getting the law right on that. That's the first thing that was interesting. What that shows you is that, for often I think we say DEA does scheduling, because that's the way it normally happens. But under the statute, it's the Attorney General who has the authority. The Attorney General has subdelegated it to the agency, and which is DEA. So like normally it is DEA, but technically speaking, it's the Attorney General's power, right? And then like on this legal question, DEA did not have the last word. Instead, it was the Office of Legal Counsel who works for the Attorney General that had the last word. And I don't know if my head motions are making any sense, but you get to see the kind of, it forces you to kind of look inside what's happening. And then the second thing that was interesting is if you look at the notice that came out proposing to reschedule, in the past, if you look at notices, it says the Drug Enforcement Administration is rescheduling the Drug Enforcement Administration. And this one was the Attorney General exercising the authority. So at least as an outside observer, at that time I was reading that and I was thinking, maybe this is an indication. And Dave Posen has a blog post on balkanization, I think, called Reading the Tea Leaves. And then there's subsequent reporting on this. Because this actually looks like that fact that the statute gives the power to the Attorney General and the Attorney General normally relies on the DEA, that might actually be relevant because maybe here the DEA, for whatever reason, or the Attorney General had to let, the Attorney General who did it, who started that process. So that's what happened to start the process. And then that history, I'll say quickly, has followed us because then that notice comes out, starts the process, and then DEA faithfully begins implementing the process. We get DEA collecting comments, and then they appoint Judge Mulrooney, and they start picking hearing participants. DEA comes to a list of 25 hearing participants. They're in pre-hearing procedures to say, how are we going to, what are we doing, what is this? And then disputes emerge. Many participants had wanted to participate and were not listed on DEA's list of 25. Okay, and parties that were frustrated they were included wind up going to Judge Mulrooney and they say, hey, we were excluded because DEA is biased, it's trying to stack the deck or load the dice against rescheduling. So this is people filing motions with Judge Mulrooney. I don't know if this is true. I'm just saying what they file in the motions. They file motions with Judge Mulrooney and say, DEA has stacked the deck against rescheduling. And of course, the government DEA comes back and says, no, we haven't. And then they also file a motion with Judge Mulrooney that says DEA, they allege the DEA talked to or had some kind of ex-parte communication with witnesses. And that's a problem. And again, the DEA attorneys file, opposition says, no, that's not true. And then that gets you to, before the hearing was ever held in January, Judge Mulrooney takes those motions. And it's frustrated participants saying the DA stacked the deck against it, and it's had ex-parte communications, and then the government saying, no. Judge Mulrooney ruled against those motions. So he said, I'm denying these motions that are alleging problems. It was a motion to supplement the record. I'm denying that. So Judge Mulrooney denies it. But he says, but given all this controversy, I'm now going to postpone the hearing and allow the parties to now appeal my ruling up if they want to go complain to the DEA administrator about my ruling denying this motion. And then also simultaneously, there have now been a couple of lawsuits filed in federal court by people saying, hey, this is a problem. So the status quo as of today is we were proceeding towards this hearing, but then these questions emerged about DEA's perspective and how it relates to the hearing. And that's led to this denied motion, but along with a canceled hearing, a potential interlocutory appeal within the DEA. And then also we now have some federal lawsuits out there about the process. So the bottom line of all that is things have kind of stalled out fighting about process within or before the DEA hearing.
Okay, got it. So we are sort of in this interregnum between, seeing HHS did its part, right? HHS made its recommendation to DEA. The process started to move, and now we're on pause. Patty, is there anything else that you want to add from your perspective about sort of how the process has worked to date?
I guess I'm going to weigh in a little bit on the OLC opinion and currently accepted medical use and try to answer a couple of questions in the chat here on that on that question. So in the chat, someone's asked how vulnerable this new interpretation of what currently accepted medical use means that HHS used in providing its recommendation to DEA that marijuana be moved to Schedule 3. So as Matt mentioned, when two agencies disagree about how to interpret the law, OLC is generally the decider, the Office of Legal Counsel. So here, there's this specific term in the Controlled Substances Act, currently accepted medical use. And so the dispute is about, or the question is about, what does that term as used in the statute mean? And historically, DEA has generally found, and the reason that matters is because something can be in Schedule 1 or can be moved out of Schedule 1 only if it has a currently accepted medical use. So this is a key criterion for deciding whether it's permissible to transfer marijuana out of Schedule 1. And historically, DEA has used two different tests to determine whether something has a currently accepted medical use. Either the substance is FDA approved, then it's got a currently accepted medical use, or it satisfies this 5-part test that we don't need to go into the weeds of, but largely aligns with kind of the high expectations we have for drug approval. So then in 2023, when HHS is providing its recommendation to DEA, HHS, as the comments noted and as Matt noted, used a different 2-part test. So HHS asked whether licensed healthcare providers have widespread current experience with medical use of the drug in accordance with implemented state authorized programs where the medical use is recognized by entities that regulate the practice of medicine. And the second part of the test is that HHS then asked whether there is some credible scientific support for at least one of those uses, which is a much lower standard than drug approval in terms of sort of the scientific evidence we'd expect. But you can understand why we might have evolved in our thinking about what currently accepted medical use could possibly mean given the widespread state markets there are today that I know Kat will talk about. But given these differing views of the statute, OLC stepped in, and OLC, as Matt said, agreed with HHS that that the 2-part test that HHS used was a permissible read of what currently accepted medical use means in the statute. So DEA is bound by that for now. That doesn't mean another party couldn't challenge that interpretation if they had standing. And then, then I think we might get into questions of what all of the changes in administrative law doctrine might mean for how we interpret this particular provision. But so I do think there probably are questions about what would happen if another party challenged that interpretation. But just to sort of give a little more context to the OLC opinion.
Yeah, that's really helpful. Kat, are there particular elements of the process as it's worked to date that you want to comment on?
Yeah, I think part of a lot of the discussion thus far has been on determinations of currently accepted medical use. And I just want to use this as an opportunity to remind folks that, particularly folks who are proponents of rescheduling, is that there are other determinations specifically related to marijuana's abuse potential that are still kind of yet to be determined. And because of this disagreement between agencies, specifically HHS and DEA, on what's binding, what scientific and medical matters are binding, and when, and in particular, the role that DEA played in the process, I'm still convinced that the DEA is likely to argue that marijuana has a high potential for abuse. I say that in part because, as Matt mentioned, it's traditionally the DEA that plays a role in issuing the proposed rule. And as I spent lots of time looking at the proposed rule itself, I identified that the only role that the DEA played in the actual proposed rule itself, there's language in the proposed rule that specifically says that DEA has not yet made a determination. But what they do in the proposed rule is note a bunch of specific areas that they would like additional information. And if you zoom in on those specific areas in which they say that they want additional information, it's kind of clear that what they're looking for is evidence to demonstrate marijuana's abuse potential. And I think that there's a through line with the witnesses that were selected by the DEA to specifically support that evidence that DEA called out that it would need additional information on in the proposed rulemaking process. And so I know that it seemed as though it would come as a surprise to some folks later on in the process that the DEA might not be championing this rule. But as soon as, I think early on, when I had identified all of these different pieces of specific additional information that the DEA was requesting, it makes pretty clear that they wouldn't request this information unless they were trying to make sure that they had evidence specifically around marijuana's abuse potential. So I just kind of note that to say, in this process that's still unresolved and ongoing, Schedule 2 is still a possibility because there's this possibility that there are concessions, for example, that marijuana does have a currently accepted medical use, but then there's still a fight and deference. Like we give significant deference to HHS for its scientific and medical determinations. There's complete deference kind of given to DOJ in matters of abuse because those are considered to be law enforcement matters, and these scheduling decisions, as Patty mentioned, aren't just about scientific and medical matters, but law enforcement matters as well.
I will add one clarifying point, and Matt should jump in if I'm wrong here, but my understanding is actually it probably would be difficult for DEA to differ from HHS's currently accepted medical use recommendation, but DEA is bound by OLC's opinion that it's a permissible read of the statute, and DEA is bound by the scientific and medical determinations that underlie HHS's recommendation that there is a currently accepted medical use, but I don't think it's bound by the ultimate recommendation that statutory criterion is satisfied. So depending on what you think of DEA and how creative they may get to advance a particular policy goal, that may also be not entirely settled either.
And I would just add on that DEA, kind of under normal executive branch functioning, DEA would be bound by the OLC opinion, but there's precedent in the past for a new administration to come in and then its OLC might issue a different opinion or disagree. I noticed one of the comments brings up the ACT v. DEA case and some of the judicial precedent on what currently accepted medical use is. And it is, if we get to predicting the future, it's not implausible to imagine that you could see the new administration's OLC revisit the opinion that was issued, and then DEA would no longer be bound by that determination on currently accepted medical use. And then I'll actually use that to add in another comment asked about Chevron. Time-wise, if there was an ambiguous statutory question, courts would defer to an agency's judgment, but that is no longer. The Supreme Court last summer said that they would not defer. And so it's when we get to predicting the future, whatever OLC says or DEA says about what currently accepted medical use is, the position of the courts would now be that there is one best meaning of that term. And so if the meaning adopted by the agency is too strict, then that would be something that would be kind of readily subject to challenge in court now, whereas 2 years ago, it would have been a lot harder to challenge an overly strict agency interpretation, and potentially so too an overly lax interpretation.
Okay, great. I feel like we've really gotten into the middle of the tea leaf reading portion of today's program, which makes me happy. I brought my tea, by the way. So just to follow up on something that Kat raised, I mean, so Schedule 1 has within it this idea of substances that have a high abuse potential with no accepted medical use. That's right there in the category for Schedule 1. And what you were seeing in the proposed rule, and then you're saying in the witnesses that DEA put forward for the hearing, that to you signaled that DEA was focused on that question of high abuse potential. But we wouldn't expect them not to be. I mean, it's right there in Schedule 1, right? So could you say a little bit more about what that tells you about the way DEA is approaching this question? Because since it's an element of Schedule 1, I mean, of course, they have to pay attention to that element of it, right? One thing that I've never understood in this space, and part of what I study is sort of bureaucratic food fights and like interagency drama, so I'm so here for all of this. But the idea that it's only, DEA focuses on that part, the high abuse potential, and HHS focuses on the sort of medical use side, ignores the possibility that both agencies could sort of have a view on both elements of that, right? So help me understand kind of your perspective and how you're reading those tea leaves and deciding what to weigh.
Yeah, I think part of it is just looking specifically at the OLC memo. There's a footnote in there that specifically kind of describes this tension around scientific and medical matters versus law enforcement matters. And unfortunately, I don't know that this record helps us, but it clarifies that when Congress was passing the CSA back in the day, it deferred to the DOJ on matters of law enforcement in relation to scheduling. So there are a few factors, 8 factors in total that agencies are considering, but 3 of those factors, I believe, specifically use the word abuse in them. And in this OLC memo, it kind of calls out those specific factors as areas where law enforcement is the primary concern. Now, I think as a fundamental kind of issue, the Department of Justice and the scheduling apparatus consider all non-medically prescribed use to be abuse. And so even the medical use that is happening at the state level that HHS relied on to make its determination of currently accepted medical use is illegal at the federal level, and subsequently counts as, and the DEA considers that use, both medical use and adult use, to be abuse. And so I think that, in hindsight, I think I would have preferred HHS to both tackle redefining currently accepted medical use and trying to kind of reassess and modernize today's definition of abuse. But I think that the scheduling apparatus gives too much deference to law enforcement for issues that should be primarily medical and scientific in nature. But because of that, I think that there will continue to be this fight over whether or not this new test and kind of pass or fail meets this definition of currently accepted medical use, but a much more discretionary decision on what constitutes abuse that is highly deferential, if not within the whole reins of the DEA.
Okay, thank you. That's really helpful. And I think that the interagency dynamics here are so interesting. Now, this is not the only area of law or policy where, a couple of agencies are interested in similar programs, right? There's lots of areas where there's jurisdictional overlap between federal agencies. And what's interesting is sort of how challenging this area is. In other areas, for example, you see much more sort of a joint mission and sort of both working together towards the same goal. Whereas here, it really, it seems quite separate and in a very different posture from sort of from it seeming like it's a collaboration between agencies and more about sort of which agency is going to sort of have its views vindicated. So it just sets things up to be fairly fraught, which is what you can see as we get into this. Patty or Matt, anything that you want to add on this, and then we'll go to Kat to talk about, what kind of comments we saw from the proposed rule that came out.
I would just add quickly, Bridget, that the point you just made about, maybe whether it's tension between HHS and DEA or something, it's to some extent it's inherent in the statute. I mean, the very first section of the Controlled Substances Act says that a lot of these substances are essential to promote the health and general welfare of Americans. And then second sentence is, but these same substances pose risks. And Congress chose, and this is, this goes back to Congress chose to assign kind of one agency to focus largely not entirely on the benefits side, and then another agency to focus largely not entirely on the costs. And to some extent, the agencies are faithfully executing their role in this statute. Now, we can talk about whether the statute is flawed, and I think well, anyway, we can talk about that. But to some extent, they're faithfully exercising their role in the statute to kind of take the positions, and kind of focus on the interests that they focus on.
I will add quickly, I think this dynamic between HHS and DEA is not limited to marijuana or even to scheduling decisions. And part of that comes from having just very different missions, right? So when HHS works with FTC, for example, or FDA works with FTC, they both have consumer protection missions, although they're somewhat different. So their missions are already pointing them in similar directions, whereas I just think it's not the same. Even though FDA does have criminal investigators and there are criminal penalties available under FDA statute, it's not primarily a law enforcement agency in the same way.
And I'm going to slip in one more tiny thing, which is this to me, I would say this is just my own view, and I have an article with Dave Posen kind of talking about some of this, but this is a reason we want DEA, or Congress maybe wanted DEA to be focused on law enforcement, and wants HHS to be focused on access, and that's one reason that the CSA makes sense that it's the Attorney General that makes the actual scheduling decision, because they could be above that, right? And you could have voices before you advocating vigorously opposing sides, and then the Attorney General can resolve. That's one reason I think that the Attorney General's role in the initiation of rescheduling was totally appropriate and kind of fits within the statutory scheme. But anyway, so I'll just slip that in.
No, I appreciate that. And I appreciate the way that we are keeping Congress in this conversation, right? I think particularly because we're like way down deep in a bureaucratic rescheduling process, we can sort of lose sight of the role of Congress in all of this. And so I appreciate us like remembering that this was the statutory scheme that Congress created, and we can be unhappy with that, right? But that unhappiness, needs to be delivered to Congress rather than, we're kind of stuck with the process that we've got, right? Okay, so Kat, so tell us, so this proposed rule came out. I know you took some time to look closely at the comments that came in. So just tell us a little bit about what you found when you took a look at the comments that came in.
Yeah, so the issuance of the proposed rule itself back in May of 2024 included in it a 62-day public comment period. And what was really exciting about this was it was kind of really the first time for the American public to weigh in on marijuana status as an illegal drug and as a Schedule I substance in particular. And the Drug Policy Alliance and a bunch of different organizations organized under the banner of United for Marijuana Decriminalization and spent a lot of time trying to educate folks about the implications of rescheduling cannabis and get folks engaged in the public comment process. And we ended up doing some analysis of all the public comments that were submitted at the end of the 62-day period. But first and foremost, there were a record number of public comments that were submitted specifically in relation to drug scheduling. There were over 43,000 public comments that were submitted in total, particularly over a relatively short period of time, I think demonstrating how widely impactful this is for folks and how interested everyday folks are in the process. But in DPA's immediate analysis after the public comment period, we found that approximately 70% of the public comments that were submitted supported decriminalization or descheduling cannabis, a step beyond what the proposed rule was would allow for. We also found that around 40% of the public comments mentioned issues like social justice and racial disparities and individual impacts to communities and patients. We saw, for example, various states' attorney generals submit public comments during the public comment period, as well as state cannabis regulatory offices submit public comments. Many of the AGs and regulators, particularly from states that have adult use and medical programs, submitted comments in support of Schedule III. But I think we saw a wide range of comments submitted. Of course, some folks continuing to support keeping marijuana in Schedule I, but the vast majority of public comments that were submitted during that 62-day period called for a change in the status quo, and many called for decriminalization and further reforms.
Okay, got it. All right, thank you for taking the time to go through those comments. As having been on the receiving end of those myself, I know it's not a small lift to sort of get through lots of comments like that. Okay, so we've been talking about the process to this moment. I guess I want to bring us back, and I think I'll ask Kat this question. I mean, you have wonderful experience working in and with state and local governments on implementation. If DOJ was to finalize the proposal to transfer marijuana to Schedule III, what would the potential implications be for state regulators and for state legal businesses and entities operating in the current environment?
Yeah, I think the biggest impact is that the cannabis industry would be able to benefit from essentially having tax parity. There's a current code, IRS code 280E, that prevents them from making normal business deductions. Specifically, it specifies that businesses can't make those business deductions if they're engaged in Schedule 1 or Schedule 2 substances. So necessarily moving marijuana to Schedule 3 would make it so that that particular provision would no longer apply. But by and large, that's kind of the biggest practical impact of rescheduling marijuana, particularly for the cannabis industry. Now, there is this reality that if marijuana were rescheduled to Schedule 3, it would get this new category under the CSA, this regulatory package that Matthew was talking about. But part of what I've tried to identify for folks, and this is something that I think is still unknown in the process, but one of the first things that the proposed rule clarifies, it says that if marijuana is rescheduled, the regulatory controls applicable to Schedule 3 would apply. It also says that any marijuana specific requirements would apply, and any additional controls that might be necessary to implement the U.S. treaty obligations. And so, as I've talked to different stakeholders about what this particular provision of the proposed rule might mean in practice, is that while we may kind of move marijuana to a different category on paper, because of these additional rulemaking and regulatory controls that the DEA, who seemingly is not even in support of this proposed rule to begin with, because of the ability for them to issue these additional regulatory controls, in practice, we might be treating marijuana much more like a Schedule 1 drug than other Schedule 3 drugs. So we might get a new dressing, but at the same time, I think practically, depending on what happens with this rulemaking, things may stay the same. I think it's also important to clarify for folks that this would not, currently accepted medical use is kind of a term of art. It does not mean that medical marijuana programs in and of themselves will become legal overnight. There's a difference, distinct difference between currently accepted medical use, which folks are still debating around if this new two-part test meets the standard, and FDA approved drugs. And essentially cannabis and cannabis related drugs would need to be approved and prescribed in order for folks to kind of lawfully use them under the Controlled Substances Act. And so I think for the everyday American, we're talking about cannabis patients, adults 21 and older who are using cannabis businesses who are participating in the industry, and the programs that support these businesses and patients and consumers at the state level will continue to remain just as illegal and subject to criminal penalty if marijuana is moved to Schedule 3. If it is moved to Schedule 1, that is in part because although there are schedule-specific criminal penalties, marijuana is special, and so it has specific criminal penalties that has nothing to do with where marijuana is scheduled, such that marijuana could be moved to Schedule 5 and it would still be subject to these particular criminal penalties. There are certain things that I think may speculatively change. Like folks will say, well, if we get rescheduling, that may lead to congressional reform. Maybe, maybe not. If we get rescheduling, there may be increased access to banking. Maybe, maybe not. If the banks are particularly concerned about whether or not their clients are engaged in illegal activity, that in and of itself won't change. And so I do think we talk about continuing to keep Congress in this conversation. I do think that because of the limited implications of rescheduling marijuana, advocates and folks in the space who are seeking to advance further reform should continue to engage Congress on these issues.
Oh, Kat, that's so helpful. And we had a question in the chat about the 1961 Single Convention on Narcotic Drugs, which is not a treaty I'm at all familiar with. But the question was basically, wouldn't it take an act of Congress to break that international agreement? And that's if, does anyone know if that's right? I have no idea.
Well, I think Kat touched on this, that in the OLC opinion actually talks about this as well. That says like we can comply with our treaty obligations by regulation, basically, by even if marijuana is moved out of Schedule 1, there are ways to impose specific requirements specific to marijuana that would still comply with our treaty obligation.
Okay, got it. So, but what Kat just painted for us was a picture of how it's not just, if we can just if this just gets rescheduled at that, then we're free and clear, right? It's obviously much more complex than that. And if you were to go to Congress to advocate for something, it would likely be a package of reforms that would be that would include rescheduling, but would probably include a number of these other elements too, because of what you're actually trying to get towards is, sort of, a changed playing field. There's a lot of different moving pieces for that. So that's really helpful. And also sounds exhausting. Okay, so, all right, let's keep it moving. Let's ask the $1 million question. I think it's time. So what do we think is going to happen next? So for example, do you think the process will stay stalled? Do you think that it'll move forward as the rule is proposed? Some other combination of events? Just too unclear? What do you think? Why don't we start with Kat?
I don't really want to start with me because I don't necessarily have the most optimistic view, but I think it's quite possible that the process stays stalled. I kind of want to work on the hypothetical that things move forward. I do think that if things move forward, one of my concerns is what I named is that we could move to Schedule 3 on paper, but then in practice still be dealing with just as burdensome regulatory controls. I think that there are a number of new officials in the Trump administration, particularly the DEA, acting DEA, and who Trump has nominated to lead the DEA, who hasn't had favorable things to say about marijuana. And that's kind of the nicest way I can put that. And so I think that at least as I've had conversations with different stakeholders on the Hill and different organizations, there's a concern that things aren't going to move forward, largely because this just isn't viewed as high enough of a priority, not because folks have particular contentions with it in the administration at large, but there are so many other things that are happening around the world and in the country right now that I can see this just not rising to a list of priorities. For example, the Trump administration released their list of top drug policy priorities in their administration, and marijuana rescheduling was not included among them, for example. And I do think that it's probably going to take directive from President Trump himself to get some of these agency heads who in their souls are opposed to marijuana legalization and reform to take action.
Okay. Patty, what's the future look like from where you sit?
Whenever I'm asked to predict the future, I always like to paraphrase that quote attributed to Niels Bohr. It's easy to predict the future; it's just difficult to be right. So I'll blanket all of us with that statement. But I agree. I think generally with Kat's thought that this just doesn't seem like a priority right now in this moment for this administration. And it's just hard to see things moving quickly. The current nominee for administrator of the DEA has a long record of career service at DEA, which I don't think bodes particularly well for support of rescheduling. I think there's a sort of long kind of there's probably institutional norms within, and I would defer to Matt, within DEA that counsel against rescheduling. I guess I would also say, even if we think that the new leaders at DOJ, DEA, or Secretary Kennedy at HHS are against rescheduling, the easiest thing to do is nothing, right? So as Matt pointed out, OLC could issue a new opinion taking a different position about what currently accepted medical use means, something like that. But the easiest thing is to just do nothing, and then marijuana stays where it is. So it might be that things stalling out is kind of the path of least resistance forward, particularly if this just isn't a priority in one direction or another.
Mm-hmm. How about you, Matt?
Yeah, I mean, maybe I'll echo. I guess I see three. I'll say three different options, and then we can try to predict among the three. And this is just what Kat and Patty said. So first is essentially nothing at all, can kicking. An administrative update of some kind, and then that's going to allow 6 more months of administrative update of some kind. So can kicking would be path one. Path two would be something quick. Something really quick. And to get to predictions, that's probably means it's a presidential priority. And then I think option three would be in between can kicking and something quick, which would be this comes out of what Kat was just saying and Patty about treaty obligations and the like. But you could imagine DEA saying, well, if we're going to reschedule marijuana to 3, we're going to have to add controls to comply with treaty obligations, and we need to put those controls through rulemaking. So now we're going to be issuing another notice of proposed rulemaking on these proposed controls for marijuana, and we could let that stall. So maybe you even get progress. Like, yeah, we're rescheduling, but not until these new controls take effect, and that we now need to do, which would be kind of like something in between can kicking and I think the biggest thing to predict among those 3 paths is politics, and I just like is it good politics? And I don't know the answers to that, nor do I don't know that anyone knows what good politics will be after the midterms, let's say, or something like that. Like I leave that to political experts to kind of make that prediction. But if it's not a political priority, or if it's a mixed political thing, like it's a win and a loss, then you've got to assume it's going to be the can kicking kind of approach. And on that, I'll just note that you could look at DEA rulemakings for a number of really important congressional priority rulemakings that took years and years or were stalled for a long time. Suspicious order reporting, telemedicine registration, there's an ambulance matter. Like there's a number of the regulatory process can often take a long like years and years, at least the past decade. So that's another argument kind of in favor of can kicking unless there's political push.
I do want to add one just sort of clarifying point based on a question in the Q&A about how do we square do nothing with the explosion of hemp products and quote gas station weed. So one thing to clarify is that hemp products that meet the definition of hemp, and that includes intoxicating hemp products, don't fall within the definition of marijuana. So as a legal matter, they aren't affected at all, one way or another, by rescheduling. So there are lots of other legal questions about those products, but this particular question won't impact those markets as a legal matter.
A helpful clarification. Okay, and so we still have this sort of litigation going on about the upcoming hearing. So that, even if the administration is in a posture of sort of holding tight and not necessarily putting energy into this, we will continue to have to work through, or the ALJ, the administrative law judge at the DEA, will have to keep working through this question of, who will testify at this hearing. And it sounds like Matt tells us there is a federal court element of that as well. So those proceedings presumably will proceed, even if the administration isn't eager to, take the next regulatory step. Is that fair to say?
Well, as I understand it, the administrative law judge has stopped, postponed the hearing and then certified for interlocutory appeal within the agency. So then the question is, how quickly does the agency wish to move? Now, maybe the agency wants to move quickly. I have no idea. It's about predecessor, so it presumably isn't like reluctant to find problems, but I don't know. It doesn't have the usual reluctance one has to find problems with themselves, I should say. But we don't know. And there have been situations where something's on appeal to the administrator, and again, that might take several years to resolve. So that we would have to see. The federal court cases, the timeline for a normal court case is years, and you all know that. Yeah, so I think those could be sites for activity. And you could also imagine an unreasonable delay claim being brought by somebody, although that's notoriously difficult. It can be a locus for action and for attention and energy. So I think you could see efforts through the courts or through Congress, that matter, to try to push. But I wouldn't bank on groundbreaking rulings that move things forward.
Okay, just thinking about other things to be watching for, in the interim. I mean, the other thing about rulemaking, at least in general, and I don't know if it's any different in this space, but is that, you can propose a rule and it can go unfinalized for potentially several years, but it then can ultimately be finalized even with changes. And so it's not like, I mean, in most cases, I'm not aware of anything that would be different here, where, if a rule isn't finalized within 2 years or something, then it can't be finalized, right? So the proposed rule just sort of sits there until it's either withdrawn or until it's finalized, as a general matter. So just to understand that, the proposed rule doesn't disappear just because the Biden administration's over, for example, right? It will continue to be there should someone wish to pick it up, unless this administration takes the effort to withdraw it, then it would be removed off the board. Okay, there's a couple of questions in the chat that touch on criminalization, and it's not something that we've talked much about. So does anyone want to speak to the relationship, if any, between the schedule that marijuana is on and how moving it would or wouldn't influence the laws around criminal possession?
Yeah, I'll jump in. I had noted this previously, but marijuana is special in the Controlled Substances Act, and so particularly as it relates to criminal penalties. And so while it's the case for many substances where you move down the schedule and the criminal penalties change and decrease as well, there are marijuana-specific criminal penalties in the Controlled Substances Act. And so by and large, criminal penalties for things like use and possession and trafficking and things of the like are not going to change simply because marijuana is moved from Schedule 1 to Schedule 3. There's had been a lot of misinformation and I think also just misunderstanding about some of the implications. I remember tearing my hair out seeing different headlines about how this was going to end criminal penalties and folks weren't going to be subject to federal consequences in housing and employment. My concern about the misinformation, not just that it's wrong, but is that I don't want folks to one day hear that marijuana rescheduling has happened and then think that all of this activity is legal. And then they change their behavior in response to what they think are newly created rights. And then they find themselves, folks find themselves experiencing additional criminalization because folks kind of change their behavior in reaction to something that was inaccurate. That's my kind of real concern with the headlines that have been misleading and some of these characterizations of the implications of marijuana's criminal penalties. And I see another question in the chat that specifically talks about the challenges and implications to Indigenous, Black, and Brown and immigrant communities. And I'll just take a moment to comment on that as well, because we know that these are communities that have historically been disproportionately impacted at every stage of the legal process, from arrest, stop arrest to lengthy sentences, et cetera. My expectation is that so long as marijuana is criminalized under federal law, these are the folks that will continue to kind of bear the brunt of disproportionate enforcement. I think some of the challenges that this rescheduling conversation has added to the table is that there really wasn't a process or means in the rescheduling process for federal agencies to acknowledge or even consider the racial disparities and other types of public health harms that people have experienced because of cannabis criminalization. We have this whole process to consider how we change marijuana status under federal law, and not anywhere in that process do we consider how cannabis law has impacted people. And I think that frustration was felt through the public comments that the folks submitting, feeling like the process by design wasn't going to accomplish the types of reforms that folks are seeking. One of the things I point out is one of the ironies of the process, even in the 8 factors that agencies have to consider in making their evaluation. One of those factors is like the history and use in the United States. And can you imagine that this whole analysis and process talked about the history of cannabis laws at the federal and state level and never once mentioned racism, never once mentioned how Harry Anslinger, who was the guy who ran the Federal Bureau of Narcotics before it became the DEA, was racist, and never acknowledged that President Nixon, when he signed the Controlled Substances Act, was doing it in particular to disrupt and vilify Black and Brown communities. So I think that this process has left a lot to be desired, and that's probably the nice way that I can put that. But I think it also points to this impetus for there to be additional processes. If this process wasn't it, what's that process? Because that's the process that I'd like to be engaged in. I think that stakeholders are interested in being engaged in, not just the minutiae of what's technically possible under the Controlled Substances Act, but what types of reforms are actually going to be necessary to protect communities.
And I'll echo Kat's great comments, which is one of the lawsuits is brought by a Cherokee marijuana entrepreneur who was excluded. This is the Hexeth case. And they note that from the 25 participants selected for the hearing, it didn't include a single Native American tribe, individual, or organization, and no group from a marginalized community among those 25 included in the hearing. And that's one of the complaints in one of those current cases, which is the Hexeth case. If you want to, I think this point really kind of powerfully illustrates just blind spots in the whole, this is what Kat said, but blind spots in the whole rescheduling process. Rescheduling is all about the menu before DEA is just medical options. But so much of the harm about scheduling choices is related to non-medical use, and people criminalize related to non-medical use. And that's simply not even a variable. So the agency's considering 5 factors and 8 factors and this and that, and nowhere is it that like, oh, if we move the schedule, it would lead to much less disparate criminalization. It would protect these communities. It's just not even on the list. And that way, like there was somebody who went to Judge Mulrooney and said, we want to have patient testimonials about how it actually benefits them. And Judge Mulrooney said, patient testimonials, yeah, we're not going to be doing those. Like it's not even a relevant consideration. Now, how do you make it? This goes to how Kat concluded, so it's echoing, but like, how do you make it a relevant consideration? Is that congressional change? Is that advocacy? Is that like, what is it that makes really almost the most important considerations are excluded by virtue of the design of the thing?
Yeah, thanks for that. That's a really helpful contribution to this conversation, because yes, we can talk about the weeds of the rescheduling process, but there's obviously a lot more context here, a lot more history here, and we're down sort of this narrow chute, which only allows us to consider certain factors. But as Kat very elegantly just described, right, there's a lot more going on here than just those narrow factors. So there's a question in the chat about whether it makes sense to try to push for a different category, different placement on the schedule. If not Schedule 3, then perhaps make a new Schedule 6, for example. This kind of keeps us in the realm of technocracy of like, just move it here, just move it from the schedule to that schedule. Do you think that's a useful way to pivot in this interim, is to try to think about a different placement on the schedules that might have better odds of success? Or is the sort of push for rescheduling not where folks should put their energy right now?
I'll jump in and keep it quick. I think that the Controlled Substances Act is flawed by kind of design, and particularly in relation to cannabis. I would not try and create another schedule. As long as the drug is scheduled, it is under the purview of the DEA. That's kind of the shared responsibility between the DEA and HHS. And creating a sixth schedule would require us going to Congress. And if we're going to go to Congress and spend time engaging with Congress, I'd much rather have a thorough solution that works for all stakeholders. I think so long as we keep things scheduled, we're still dealing with a primarily limited medical model. And we just know that there's so many different activities and stakeholders that are engaged in activity beyond those models. And I think we need a solution for as many stakeholders as possible, everyone. And I think we can get to that through descheduling cannabis and passing reforms like the MORE Act or the Cannabis Administration Opportunity Act, even the States Reform Act, bills that have regulatory control and that try and split regulatory control between states and the federal government. I mean, the reality is that I think the federal government's thinking about this too hard. Like there are states who are actually leading the way on what responsible cannabis regulation looks like that both protects public health and public safety. We need to be in a much better position if we allow states to be the lead regulators, but have some federal and national standards, particularly around public health and safety. But DPA and many of the advocates and organizations we work with support descheduling cannabis and recognize it's not going to happen overnight, but that's the solution that we should be aiming for.
Okay. And descheduling, meaning get it just simply off the schedules, right? Just don't even treat it like a controlled substance, basically. Okay.
Yes, I mean, we regulate it like tobacco or alcohol or other consumer products that are not controlled under the Controlled Substances Act.
Got it. Okay.
And,
All right, thanks. Go ahead.
I'll put in my view, just because I have a paper coming out with Dave Posen where we say we like the idea of an additional schedule to be added that would address non-medical use in a controlled way. So if you take the tobacco controls that exist or the alcohol controls that exist, when DEA or the Attorney General is currently deciding to schedule, they don't have an option to legalize marijuana except with alcohol or tobacco style controls. For DEA, they could just take off the schedule and then there's no requirement. So from the administrative process standpoint, the only option would be for Congress to do something. And then the question is, well, could you get Congress to pass cannabis legislation that imposes, sensible controls on selling to minors or something like that? And I think, that's obviously something to advocate for. But now I'm going to be technical and wonky, but the lesson of administrative law is there's many a congressman, there's many a senator who would maybe agree there's terrible problems, but doesn't want to vote for cannabis legalization because it's a liability for them. And the easiest answer, if you want cannabis legalization, is to persuade voters and a congressperson to vote differently. You know what I mean? But they might not want to. But what often works with the administrative process, and this is part of why scheduling works in the Controlled Substances Act, why it's so popular, is you create a schedule for legal use. And a member of Congress can say, look, I'm fixing things by voting for the schedule, but we haven't decided yet what will happen with cannabis. That will be done in the administrative process. And so you create a schedule for non-medical use. You take the decision away from DEA and you put it maybe with HHS, maybe you put it with the Attorney General, maybe you put it with somebody else like the Consumer Financial Protection Bureau or someone, just a more consumer-oriented agency. But then there could be the administrative process would now, when they pick a menu of how should we regulate this drug, they would have the full range of options, including let's regulate it like tobacco or alcohol, like let's legalize it. And you could get that in the administrative process, but then you could persuade a member of Congress who was unwilling to put their political future, for whatever reason, they didn't think the politics were there, but they were willing to fix. Members of Congress want to say fix the thing, but not take credit for the problem. So anyway, I would just put that out there. And one last thing is, I love coalitions, and that kind of approach would bring MDMA legalization, like in partnership with cannabis legalization, whereas the kind of ad hoc approach right now almost divides some of these groups. But I just, this could be a longer conversation, I'm sure.
Yeah, so I will add that on a high level, I agree with Matt and Kat about sort of big picture thinking that this kind of like, should it be 2? Should it be 3? Should it be 4? Is like not that helpful, right? And so I think there does need to be big picture thinking. As someone, with a public health and FDA background, states don't do regulating medical products well. Like they don't do regulating safety and effectiveness. They don't do regulating, innovation in the biomedical space well. I understand marijuana is different, and there are sort of all these different concerns around marijuana. But I do think there are real questions about how you regulate a product, unlike tobacco or alcohol, that is marketed for medical and recreational uses. Is that the right model to have both kinds of uses marketed, to have people profiting off of making these kinds of claims in the medical space, et cetera? So, if I always encourage people to read Sean O'Connor and Erica Litton have a fabulous law review article about FDA's authority in a world in which marijuana were totally descheduled. That helps sort of understand that at a minimum, if we're in that world, FDA statute would need to be revised to create the world we want, whatever world that is. I'm open to the fact I could be wrong about all the things I just said, but I think big picture thinking about like what is the world we want, especially right now, where the world we've been living in isn't the world we're going to be living in the future. We don't know what the world we're living in the future is going to be, but it's not the one we're used to. So anyway, that's where I come out and Kat and Matt, I'm sure we all could talk about this forever, but I know we can't because we're at time.
Yeah, we're pretty close to time, but I just want to give you like 20 seconds. If there's any final thoughts before we wrap up. I'm glad that we got to a place of sort of thinking about the future in a broader way, in a more energetic way. The process for rescheduling is hard. It's arduous. It's meant to be, actually. That's the process that Congress created. And so it's natural that you might be looking for alternatives. So I'm glad that we got there into thinking about, where do we go from here? Are there any sort of final thoughts, again, just in the final, maybe 20 seconds each, if anything? All right, then I will just say thank you so much for your time. Thank you to our wonderful audience. Thank you to DEPIC for convening us. We really appreciate your time and attention. As you can see, this is a fascinating set of issues and a wonderful group of people to talk about it with. Thank you so much, and I hope you all have a good rest of your day.
Thank you for attending Balancing Act, Regulating Intoxicating Hemp Products in Ohio. The event is hosted by the Drug Enforcement Policy Center at The Ohio State University Moritz College of Law. Before we begin, we have just a few notes we'd like to share with you. First, we want to draw your attention to the Q&A function at the bottom of the Zoom window. The chat is disabled, but you may submit questions at any time. Please note, however, that there is limited time available for Q&A during the webinar. Second, automatic closed captioning has been enabled for this event. To change how you view the transcription or to hide it, click Show Caption in the menu at the bottom of your Zoom window. Finally, this event is being recorded. The recording will be made available on our YouTube channel as soon as possible following the event. A link will be shared with all registrants via email as soon as it is available. Follow us at OSU Law, the EPC, to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the discussion. Patty?
Thank you, Holly, for laying down the rules of the road. And thank you to everyone who is here for joining us today to discuss the regulation of intoxicating hemp in Ohio. My name is Patty Zettler, and I have the pleasure of moderating today's webinar. I'm the John W. Bricker Professor of Law here at Ohio State, and I'm also a faculty member of the Drug Enforcement and Policy Center. And for this semester, our acting academic director, while Professor Doug Berman, who many of you may know, is on sabbatical. I also previously served as Deputy General Counsel to the U.S. Department of Health and Human Services. And so I'm very interested in the topic of intoxicating hemp, as I know all of you are as well. So today we are fortunate to have a fantastic and deeply expert panel here to help us understand the important and complicated issues around intoxicating hemp. I'd like to invite the panelists to go ahead and turn on their videos. I will briefly introduce each of our panelists, and then I will ask them a number of questions to help us understand the landscape here. As Holly mentioned, we will leave some time at the end for your questions as well, so please feel free to put them in the Q&A as Holly instructed as we go along. So our first panelist, I'll just go in alphabetic order, is David Bowling. David is the Executive Director of the Ohio Cannabis Association. He previously served as Deputy Superintendent and Deputy Chief Legal Counsel with the Division of Cannabis Control in the Ohio Department of Commerce. And David has a long record of public service, and outside the cannabis context, he also served as an attorney for the Ohio Secretary of State. David earned his law degree from the University of Dayton and his undergraduate degree from the University of Kentucky. Our second panelist is Jonathan Miller, and Jonathan is a partner with Frost Brown Todd and serves as partner in charge of the firm's DC office. He is a leading government relations professional and attorney for the global hemp industry and serves as general counsel for the U.S. Hemp Roundtable. Like David, he has a long record of public service and a wealth of government expertise, having served as state treasurer and the Secretary of Finance and Administration for the state of Kentucky, and also as Deputy Chief of Staff for the U.S. Department of Energy. Jonathan earned his law and undergraduate degrees from Harvard University. And last, but certainly not least, we are fortunate to have Michelle Minton joining us as well. Michelle is a senior policy analyst at the Reason Foundation. Among other work, Michelle co-authored Reason's report examining how states regulate intoxicating hemp products and providing recommendations for state and federal legislation. Before joining Reason, Michelle was a senior policy analyst at the Competitive Enterprise Institute, and Michelle earned her Master of Science in Nutrition Sciences from the University of New England and her undergraduate degree from Johns Hopkins University. So we have a terrific group with a lot of expertise here. Thank you to our three panelists for joining us. And Michelle, I will start with you with our first question. Michelle, could you please talk a little bit about what intoxicating hemp actually is? How did these products develop? How did the market for these products develop? And just sort of help us understand what we're talking about today.
Yeah, absolutely. And thanks for having me on this panel of distinguished guests. So the first part of the question, what are intoxicating hemp products, could actually have three different answers: the chemistry answer, the practical answer, and then a legal answer. I won't bore you too much with the chemistry, but basically in a nutshell version, intoxicating hemp involves plants or derivatives of the hemp plant that contain cannabinoids known to produce impairing psychoactive effects, not just psychoactive effects, but impairing, and that have these cannabinoids in high enough concentration to have that effect. But as I think state lawmakers and law enforcement across the country have been dealing with, it isn't actually so easy to classify the more than 100 cannabinoids that have been identified in cannabis plants into these neat categories of intoxicating and non-intoxicating. So as I'm sure most of the guests watching this understand, hemp and marijuana both come from the same plant, the cannabis sativa L. And like I said, there's over 100, some people estimate 150 different types of cannabinoids that naturally occur in these plants. The two most well-known classes of these, or cannabinoids that we know of, are tetrahydrocannabinol, THC. Obviously, this is your delta 9s, your delta 8s, the ones that most people associate marijuana with the psychoactive effect of being high. And then there's cannabidiol, or CBD, which is considered psychotropic. It does have an effect, but it's not considered intoxicating. Then there are a whole bunch of isomers of THC, which a lot of states are dealing with now, like delta 8, that occur naturally in the plants, but typically in lower concentrations than the most common one of delta 9 THC. In addition to this, a lot of those cannabinoids go through a natural form of synthesis where they change from one form to another, just sort of the molecular composition remains the same, but the molecules just kind of get shifted around a little bit. So for example, if CBD is exposed to light or heat, it can be converted into delta 8 THC or delta 9 THC. And then there's, if anybody knows about THCA, it's a cannabinoid that's considered non-intoxicating when it's inside of the plant, but if it's heated up, for example, by smoking or vaping, it gets converted into THC. And then there's also chemical synthesis that can happen. This is how we turn CBD, in a lab by applying solvents into delta 8 THC. And then there's a whole other class of artificial cannabinoids that do not occur naturally in the plant that are completely created in a lab that mimic the molecular structure and effect of THCs. So that's your nutshell version of the chemistry answer. The practical answer is that with all these different cannabinoids that have different effects, there's also an entourage effect where different combinations of cannabinoids may make a product or plant material considered intoxicating or non-intoxicating. For example, you can have a pretty high THC concentrated hemp product, but if it has a much higher ratio of CBD, it does not exactly produce the same types of intoxicating effects as it would with lower levels of CBD. But that's practical. Now you have the legal answer. So back in the 1970s, a botanist and a taxonomist said that they were arbitrarily creating a distinction between what hemp and marijuana were, and they based this on the concentration of specifically delta 9 THC in mature leaves. And as a side note, there's far fewer cannabinoids in the leaves of a cannabis plant than there are in the flowers. And the limit that they chose was 0.3% delta 9 THC. And in 2018, the federal government adopted the standard in the 2018 Farm Bill, saying that legal hemp would be considered in all of the hemp plant materials, seeds, derivatives, extracts, isomers, any part of the hemp plant, so long as that material had less delta 9 THC concentration than 0.3%. And once that federal bill was passed, states started to adopt the same standard. And what this did, obviously, as we all kind of recognize now, is it paved the way for all of the other forms of THC and other forms of cannabinoids that are in cannabis plants to be concentrated and sold technically legally under federal and most state law until recently. So now we get into how the plants operate and the cannabinoids. How did the market itself for intoxicating hemp products actually develop? The short answer to this is supply and demand. With the 2018 Farm Bill and starting in 2014, a lot of states had their own pilot hemp programs. By 2019, there was a big glut of CBD produced by hemp farmers, and there wasn't a way to get that necessarily to the market. This is partially because of improper regulatory schemes that created a sort of mismatch. The demand wasn't there. There weren't the regulations for these processors to actually produce CBD products to get them on the market, and there was fear about the legality. So you have a glut of CBD just on the market, and it caused the prices to crash. At the same time, the legal marijuana market was accelerating, demand was increasing, and the prices for those products were skyrocketing. So you have the hemp industry And the reasons that there was a lot of unmet demand in the marijuana industry, in the legal marijuana industry, was frankly because of the way states were forced to regulate legal marijuana under federal prohibition. So, a lot of states in Ohio, for example, many localities have a moratorium on legal sales. In California, you have about half of the population in California, the biggest legal marijuana market. Half the population lives more than 60 miles away from the nearest legal retailer. So there was an unmet need, and hemp producers with their glut of CBD saw this unmet need and tried to figure out a way to turn their CBD into a product that there was demand for consumers and that they could be profitable with. Magic presto, we've had the chemistry since the 1960s to do these relatively simple conversions from things like CBD to delta 8 or delta 9. And with the federal laws being what they were, hemp operators, producers, retailers saw an opportunity to meet the demand of the legal marijuana market without running afoul of federal or state law at that time. Because hemp producers had fewer regulatory barriers, they didn't have limited licensing, fewer licensing costs, they could get these products in more stores, closer to the consumers, better hours. They were just more competitive in a lot of ways than state legal marijuana products were. So, to put it in another way, if the states had been able to regulate legal marijuana in a way that met the demand that existed, intoxicating hemp products probably would have never emerged as a real market. So that's the short answer of how this market emerged and what these products are.
Thank you. That's really helpful. David, Jonathan, do you have anything you want to add from your perspectives?
I'm happy to. What's intoxicating? That's really a huge $1 million question because different things intoxicate people differently. And there's been an effort nationally to try to figure out how we can segregate intoxicating versus non-intoxicating products. And so far, no one's come up with a really good answer. Kentucky's got a good model that I can share later. But this becomes a real challenge because you have some policymakers, such as in Ohio, using a very low level of THC to say what's intoxicating, what's not. And we believe that it excludes a lot of non-intoxicating products like full-spectrum CBD products that don't get people high, but that are somehow pushed into the intoxicating category. So this debate between intoxicating versus non-intoxicating is a huge one and might not be resolved for some time.
Well, the lawyer in me loves acknowledging that our starting premise of talking about intoxicating hemp isn't clear in and of itself. So, David, do you have anything you want to add on this question?
I just like to give like a real world comparison as to kind of what's going on here. So the one that I always like to use is let's take a potato farmer. Potato farmer grows potatoes, sells those potatoes to McDonald's. McDonald's makes French fries out of those potatoes. Those are all potatoes, right? I think we all can agree on that. However, what we have going on in the intoxicating hemp world is we've got a farmer similar to that. We've got a farmer who grows potatoes, turns that potato into vodka, and then wants to sell that vodka at retail, but still call it potatoes when it's in the retail store. That's my real world comparison for what's going on here in the intoxicating hemp.
Thank you for sharing that. And actually, David, I'm gonna stick with you and in fact turn a little bit more specifically to Ohio. And so I'm hoping you can help us understand how intoxicating hemp products, however we might define them, are currently regulated under Ohio law. Things like who can purchase the products, where can they be purchased, what kind of limitations are there under Ohio law on what kinds of products can be sold.
Bottom line, right this second, they're not regulated, period. They're not tested. We don't know who produces them. The consumer has no way of finding out who produces them. You have no traceability in this particular market right this second. The short answer, and I don't have to go too far into it, is they're not regulated.
Jonathan or Michelle, would you want to add anything? Jonathan, I know you touched a little bit on how Ohio defines intoxicating, but is there anything else you want to touch on with respect to Ohio law?
Right now, Ohio law is quite limited, and the hemp industry would like to see much more robust regulation. The problem about having limited regulation is that it advantages bad actors. And so there are a lot of really good companies in Ohio and across the country that take great efforts to make sure the products are properly labeled, kept out of the hands of kids, kept contaminants out of. That costs money, and so they're competing with hemp companies that do none of the above. And so this is one of these rare industries where the hemp industry is saying, please regulate us, because not only is it good public policy, but it helps our bottom line by advantaging the good guys against the bad guys.
Yeah, and I would add to that, and I concur with what Jonathan said, and I'd add to that, there is a lack of federal guidance too. That's in a lot of ways, with marijuana, the federal prohibition is really hampered the state's ability to rationally regulate their marijuana markets when it comes to hemp. The total lack of action from the federal government to provide certain guidance like good manufacturing standards, what kind of ingredients should be excluded, testing standards, and probably most importantly in the conversation about hemp, how some of these cannabinoids like CBD can be safely added into foods and beverages. So states have had to hold back and waiting for the federal government to act. And so you have a situation where, Jonathan mentioned, where you have hemp products that are, in a lot of ways, the industry is self-regulating. You have good actors who are following specific guidelines similar to adult use marijuana markets, and then others that aren't doing that. And you have a real kind of lack of transparency, as David noted.
Yeah, and I will add with my own FDA hat on that it does violate federal law to distribute food and beverages with CBD in it, but FDA has not been enforcing unless products are marketed with claims of disease treatment. And FDA has publicly said that it thinks, it thinks Congress needs to act to create a more rational scheme for the sort of food regulation piece at the federal level.
If I could jump in real quick,
yeah.
We disagree that CBD products violate federal law. That's certainly the FDA's position, but it's just a non-binding statement that they've made, and we feel that if it was ever tested, we would win in court. But you are very correct that they haven't tested that, except going after those bad actor companies who are breaking the law by making medical claims.
Well, we can have an offline chat about that, because the statute does prohibit adding approved drugs to food absent, regulation or other official sort of exemption, which doesn't currently exist. And of course, as you know, CBD is an approved drug. But I do want to back away from federal law just for a minute and stick with the states. And so David kindly talked with us about sort of what Ohio law is. Jonathan, I know you've done a lot of work on a lot of different state areas. And I think it'd be great to understand better how Ohio compares to other states when we're talking about intoxicating hemp. So, is Ohio an anomaly compared to other states? How do other states, including neighboring states, approach regulation of these products? And maybe you could talk a little bit about what the impetus behind regulation is, if there are states that are doing things differently.
Yeah, Ohio is very similar to most states where there's a lot of gray. And so what you've seen states try to do, filling in the gray, is to either A, robustly regulate products, or B, ban them. We prefer the robust regulation, obviously, and one of our favorite states is just south of the Ohio River, where I'm from, in Kentucky. Kentucky has a very strong regulatory model, which provides for age restrictions, testing, GMP requirements, labeling requirements, and it's proven to be quite successful. You've seen some other states, like California, move to ban products entirely. And so the governor of California just issued an executive order late last year, which says that all hemp products with any THC in them are banned, which is basically 90 to 95% of hemp products. You're starting to see those kinds of efforts be proposed. Similar proposals going on in Texas, a similar one in Illinois, but so far efforts have been successful to keep them at bay. But this is a continuing debate going on, and unfortunately for us, we have 50 different state regimes, which can be quite challenging if you think of labeling, for instance. If one state requires you to list how much THC you have in a product, and another state says you can't use the word THC on your product, you see that you can't have that same label. And so we're having folks that sell across the country have real challenges in terms of interstate commerce and complying with different state laws.
Yeah, and that certainly seems like an argument for more federal guidance. Michelle, David, do you have other thoughts to add about other state regimes outside of Ohio?
No, I mean, I would just add that I think it's interesting that more and more states seem to be taking a harder line. I think Ohio, right, the second is in the minority on limitations and perhaps all-out prohibition. It's interesting to me that more and more states seem to be going in the direction of banning intoxicating hemp.
Yeah, and I would add to that, it's very interesting to look at which states are taking the harder line versus the more regulatory-based approach, like with Kentucky and Tennessee. It's often the states that take the more regulation-heavy approach are the ones where cannabis is not yet fully legalized. Marijuana is not yet fully legalized, and the title of this panel is balancing. The balancing's in the title, and I think that in a lot of ways what lawmakers should be doing, and not just balancing consumer safety concerns with industry concerns, but balancing the ability for a goodwill industry to comply with the laws versus the will of the people to obtain these products as whatever product it is they desire. Because if they can't get it on the legal market, they will turn to out-of-state products or illicit products or a different type of product that's being sold as a similar product. So what we saw with hemp cannabinoids to marijuana, we've seen it in the opioid market with fentanyl and now xylazine. We've seen it in the alcohol market during original prohibition, where people were dying of contaminated or poorly made alcohol products. So I think it is interesting to see the different tax people are taking, and I think a lot of the states that approach it through prohibition is frankly from this fantasy that if you just ban a product, that will take care of the problem. And it's certainly easier for law enforcement, but from experience, it doesn't typically work out well.
Before we move on to our next question, which someone in the chat has already asked about, I have a follow-up question for you, Michelle, which is you mentioned that the states that are moving towards prohibition have already robust state legal cannabis markets. So I guess do you have a sense of why that existing market is pushing those states to prohibition rather than regulation?
Yeah, there's a number of reasons. For one thing, it's more difficult to regulate a larger number of products that can be produced from hemp. It's fairly easy with cannabis, just like the Delta-9, it gets to above a certain concentration, it's intoxicating. The other issue is that you have kind of fragile markets. I mentioned before that the marijuana market demand was increasing, prices were increasing. That's changed since 2022. And a lot of the markets where you have big state legal marijuana markets are suffering. They're suffering. A lot of, I think in California, it's still, 60-50% of all the sales that occur in marijuana are through the illicit market, which is huge. And a lot of this is being driven by the fact that people can't access the products they want legally, where they want, when they want, and at prices they can afford. And sometimes it's just the products aren't available that they want. So I think that's we're seeing a little bit of a protective stance to protect the cannabis markets that exist, the tax revenue they're generating, and sometimes the social equity programs and other programs that they're funding from this new competitor that's facing a lot fewer regulatory hurdles and costs.
Thank you for fleshing that out a little bit. So someone in the chat asked if we could talk a little bit about Senate Bill 86, which I love because I was already planning to ask David about that. So David, if we could turn back to Ohio and talk about the recently introduced Senate Bill 86, which proposes to regulate intoxicating hemp products. Could you walk us through a little bit of what the main provisions of this bill are, what it would change about law in Ohio?
So Bill 86 provides for a regulatory framework for really two types of products: intoxicating hemp products and another product that refers to drinkable cannabinoid products. It separates them into kind of two distinct regulatory fashions. On the intoxicating hemp side, it forces them to be sold through licensed regulated dispensaries in Ohio, which we have established that framework in Ohio. They're licensed by the Division of Cannabis Control. And then it says further that it does place limitations on what is intoxicating hemp from a THC content perspective. So part of what it does is carve out those products that are non-intoxicating to make sure that the hemp market can still flourish in that front. So it lets those lotions and things exist that we're all familiar with, but also forces the intoxicating products through retail dispensaries that are regulated, heavily regulated, and tested. Again, it does require similar testing to current marijuana products in the state of Ohio. And then the second kind of regulatory framework is the drinkable cannabinoid products, which it sets up a kind of 3-tier system. I hate saying that, but that's kind of what it is, for manufacturers, retailers, distributors to create these drinkable THC products. It sets limitations on them as well. I think the actual number is 0.4 milligrams per fluid ounce of THC. So in a 12-ounce can, 4.8 milligrams of THC is what we're going to get. And it sets up a framework where it's capped at 48 ounces. So really what we're talking about is 4 to 5 milligrams of THC per can with a limitation of 4 cans per package. And then it allows for those particular products to be sold at micro distilleries, grocery stores, bars and restaurants, and also retail dispensaries as well. It forces those folks in the 3-tier system to be registered with the Department of Commerce, and so they're regulated by some government entity. And I'll just throw in the tax provisions. It's taxed at a rate of 15%. Now we heard the other day that the way the bill was introduced is at 15%, but likely come down to 10. Senator Huffman said that in his testimony. And there's additional tax at $3.50 per gallon on the sale from the manufacturer to the distributor. All of those funds fund the general revenue fund in the state of Ohio. That is Senate 86 in a nutshell.
Thank you for summarizing it so concisely. So Jonathan and Michelle, if you have things to add about how to summarize or sort of what the bill would change, I'll let you sort of add that to your comments in the next question. But I actually want to ask all three of you from your perspective and from the perspectives of your stakeholder groups, what are the strengths and weaknesses of Senate Bill 86 and what are changes, if any, you would like to see? And David, since you were just talking about Senate Bill 86 yourself, maybe I'll start with you and then go to Jonathan and Michelle.
Yeah, I mean, aside from some various technical fixes that I don't really want to get into the weeds on, I mean, there's things that we believe testing could be beefed up a little bit in the bill, could increase a little bit on where you can source the THC from. So aside from those changes that are, like I said, they're very technical, we think the bill's in a good place. Like I said, it does establish a regulatory framework for these products, and that's bottom line what needs to happen.
Jonathan, do you want to share next?
Yeah, we strongly oppose the bill. The hemp industry is pretty united. What it really amounts to is a retail ban of most hemp products. This is better than the bill introduced before because there is a carve out, as David mentioned, for beverages. But products like non-intoxicating CBD that are a little bit above the 0.5 milligram level, even though they're non-intoxicating, would only be available in dispensaries. And frankly, people go to dispensaries to get high. They don't go for health and wellness products like CBD. So it would amount to a real hardship for a lot of consumers who rely on these products for health and wellness. But most certainly, by giving them a monopoly of the sales to the dispensaries, you're cutting out all these small businesses that have grown to sell these products, as well as hurting farmers who are trying to provide the hemp to be in these products. So we're supporting efforts. We know that the current status quo is not acceptable. There needs to be more robust regulation, but we don't think a retail ban is the right answer.
And I guess are there changes you would want to this bill specifically to address those concerns, or do you think, I guess, is your perspective, it's just scrap this one, we need something wholly different?
Yeah, we need something totally different. We've put together a proposal with some other hemp organizations in terms of what a robust regulatory structure would look like. It really is substantially different than this current bill.
Michelle? Oh, David, do you want to respond? Or
wouldn't mind responding, that's okay.
How about I let Michelle her piece and then you can respond to both.
Okay, don't forget what you're going to say, David. Yeah, so there's some things we like in the bill: age gating, testing, robust testing, packaging, and stuff that's similar to or equivalent to the adult use marijuana market. We also particularly like that it allows for just any accredited lab to do the testing, not a state-run lab, which can cause bottlenecks. But there, as Jonathan said, this pretty much, it's as close as you can get to prohibition without it actually being prohibition to move most of the products into the dispensary system, where, like I said, in Ohio, 55 municipalities have already established moratoriums on dispensaries. So you're going to be forcing people to drive farther to find a dispensary to get this legal product. Dispensaries, it's unclear, once given that particular product class, if they will modify their offerings to the group of people who want to use like high CBD, lower THC products. There are some pediatric patients out there who have particular seizure disorders who are taking up to 800, 1200 milligrams of CBD, which if you are talking about a natural full spectrum CBD product, that comes with, not an insignificant amount of THC, definitely an amount that would crest over what we would, what this law would consider to be intoxicating. Putting it in the dispensary wouldn't just kind of create hardships. It would also very likely significantly raise the cost for people who are taking those substantial amounts of CBD just through all of the barriers that increase cost for the dispensary model. And if, like I said, if consumers don't have the products they want, the prices they want, and they don't have access to them, they will turn somewhere else. And in this case, the most likely one is to out-of-state products, which is going to cause a lot of headaches for a lot of people. Law enforcement, public health, not necessarily knowing what these products are, where they're coming from, if they're, verifiable, that kind of thing. We would also like to see the inclusion in bills like this of the CBD to THC ratio, not just a simple concentration limit or a simple milligram limit in products, but as I mentioned before, the entourage effect of these cannabinoids. When you have a lot of CBD, even with more THC than you think would crest over intoxicating, it's not intoxicating. So we'd like to see this ratio to kind of give patients a little more leeway when it comes to where they can get their products. I'm glad David said about the tax, because the tax disparity between legal marijuana dispensary sales and then the 10% versus 15 didn't quite make sense. There's also a cash limitation in the bill that does not make any sense to me, where business-to-business transfers of intoxicating hemp products, specifically the drinkable cannabinoid products, could only be done in cash, which I think we can all understand with problems like the troubles that might cause for businesses. And I think those are, for us, we would like to see states take the opportunity. Their adult use marijuana markets were created under, with one arm tied behind their back because of federal prohibition and a lack of interstate sales. We would like to see states kind of start from square one and create a market for intoxicating hemp products that they would like to see for their marijuana products, a more liberated market that's still well regulated and controlled and transparent, so that if and when the federal government ever removes marijuana from the Controlled Substances Act, they could then use that as a model for both of these products to be a unified regulatory scheme.
All right, David, what do you have thoughts about Jonathan and Michelle's comment?
But clear something up on the cash transfer that Michelle's talking about. It's a framework that's stole from spirits, beer wine world. It allows for people to not sell on consignment. It's something that distributors and manufacturers in the beer wine world are fully familiar with, and it's shown to work. But to call it a retail ban is just interesting to me. We have roughly 300 dispensaries across the state, with the division's ability to increase those dispensaries based on demand. So just to say it's a retail ban is a little bit tough for me to swallow.
Thank you. Jonathan, there's a question for you in the chat, actually, that I want to ask before we move on from this topic. And the question is whether you or your stakeholders would support an Ohio bill that's modeled on Kentucky. So I think the question is basically, is Kentucky a model that your stakeholders think is a good one?
Yeah, we have shared the Kentucky model with Ohio lawmakers, and in fact have put together legislative language that's very similar to Kentucky. But so far, there've been no takers. We're hopeful that once this debate continues, that it won't be as it has in the past, basically just up or down on a ban, and that people can come together on a more robust regulatory approach. So we're hoping that happens, but we're ready to pitch in if it does.
Great, thank you for answering that. Are there any other thoughts on SB 86 that any of you want to share before we move on to talking a little bit about the federal level? Okay, so again, I'll ask this question to all three of you, and maybe I'll go in reverse order this time and go Michelle, Jonathan, David. But we have been talking about the state level. We talked about this. We touched on the federal level earlier in our conversation. It would be great to hear, I guess, two different things. One, what changes, if any, do you anticipate or expect or think will actually happen at the federal level? And from your stakeholders' perspectives, what changes would you like to see happen at the federal level? Michelle, if you're good starting, I'll start with you.
Yeah, sure. I'm not sure what kind of changes in the realm of cannabis that we can actually expect at the federal level over the next 3.5, 4 years. But one that's on the table right now that I already mentioned, which is rescheduling marijuana from Schedule 1 to Schedule 3, which would, that could be really interesting. We'd like to see what the FDA would do with regards to this. We think it could alleviate some of the concerns and some of the hurdles and barriers that legal marijuana markets are experiencing within the states, and it would open up interstate commerce, which would maybe kind of lessen some of the concerns about intoxicating hemp, but also the interest in intoxicating hemp. We'd like to see federal guidance on inclusion of CBD and other cannabinoids in food, beverages, supplements. I know FDA says they don't have the appropriate frameworks to do this and they need Congress to intervene. However that works out, we don't know. That's just something we would like to see happen, whether it's through FDA working with Congress or Congress, less likely with Congress, of course. And then, the hopeful one is we would like to see the federal government take a unified approach to these products. They're produced very similarly. They have very similar risk profiles. At the very, very least, good manufacturing practices would be something that the federal government, some kind of guidance document that the federal government could put out that the states could follow, so that at least when we have products switching between states being mailed or carried from one state to another by consumers, they know that they're at least being held to specific types of safe manufacturing procedures and labeling, so that everyone understands what they're actually getting in the bottle, so to speak.
Thank you. Jonathan, so same question for you. Are there changes you actually expect to see at the federal level? And what changes would you or your stakeholders like to see?
So you're catching me right now in the Senate Dirksen cafeteria. I apologize if it's a little noisy, but I'm in the middle of lobbying on these various issues. And so there are two different approaches that have been taken when it comes to hemp. One is to ban it. There was Mary Miller, a congresswoman from Illinois, last year introduced legislation that would basically make criminal any hemp products that had any level of THC in them, and really put a scare through the industry. Fortunately, those efforts were not successful last year, but they could rise again. So we're being very vigilant. Our approach is, again, as I've been talking about, robust regulation, and the bill that I'm lobbying for has been introduced by Senator Ron Wyden from Oregon. And that bill would provide age gating, testing, labeling, transparency, all of the various elements that we've been talking about today that would be wise for it. And it would also give the FDA the authority that Michelle mentioned is missing right now in terms, or that FDA thinks they're missing. We think they've got the authority already, but they think they don't. It would give them the clear authority to start regulating these products. So I can't give you a prediction as to whether that's going to pass. We're hopeful that by the end of Congress next year that we will see legislation like this, but there's a lot of work to do between now and then.
Right, thank you. So David, same two questions for you. Changes you expect to see and changes your stakeholders would like to see.
Yeah, I think I'll do what we'd like to see first. I don't think it was, obviously, I don't think it was ever the intent that we have this loophole in the law. So things that we would like to see would just be close the loophole. I don't think the federal government ever intended to allow these synthetic THC products to be available to consumers. Cannabis is one thing. Cannabis that's grown, naturally occurring THC is one thing. Synthetically producing it is a whole other thing because we don't know enough about it. I think changes from a federal level, obviously, I believe that the banking side of things will ultimately get taken care of, and that'll be a big help for our folks as well.
So there's a couple of related questions in the chat that I want to pose to you all and attendees. Please keep putting your questions in the chat. So one question is about what the questioner calls the 3-pillar approach. Perhaps this is what David you were referencing, and Jonathan you as well, involving 3 key requirements: age restrictions, product testing, and truth in labeling. And the question is about whether the 3 of you see this approach as a viable regulatory framework, and if not, what would be a better approach? And I would add to that question, if this is a viable regulatory approach, would you want to see it at the federal level or at the state level or both? Michelle, I'll start with you first because I see you nodding. So
yeah, I'm not sure about both or either or. I mean, I think that is definitely an appropriate stance for the states to take, right? These, David said we don't know enough about these molecules, the ones that naturally occur in cannabis, like delta 8, delta 10, et cetera, THCA, THCV. We know almost as much as we do at this point about delta 9. Like, we know that the molecules are relatively similar. We know which receptors they attach to and what kind of effects they have. For example, the one study I've seen in humans of delta 8 had a weak affinity for CD1 receptor, which is psychoactive, weaker than delta 9 anyway. So it kind of created what they would call lighter high. That's why it's called diet weed. But we do think treating all of the cannabinoids from the cannabis plant, whether we're going to call it hemp or whether we're going to call it marijuana or cannabis, I think would be the smart approach here. I think a federal age limit is fine. If we, generally what we want to do is treat cannabis products, regardless of hemp or marijuana, like they were alcohol. They are both intoxicating products with particular risks. We want to age gate them for adults, and we want them to be made safely, and we want people to know what they're getting. So yeah, I think that unified approach probably would work at the states and the federal level, so long as the federal didn't invade the states too much with their regulations.
Jonathan, do you want to chime in?
Yeah, my answer to your questions are yes, 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 and yes. We love the 3-pillar approach. There's a lot behind that, a lot more detail as well. There needs to be testing, there needs to be insurance that the products are not marketed in a counterfeit way, not marketed to children, But that is the approach we support. We'd like to see that at the federal level. We'd love to see uniformity on a lot of this stuff at the federal level, and potentially some preemption, federal preemption, particularly when it comes to labeling because of the concerns I mentioned earlier about 50 different labels. But in the meantime, since the Congress is dragging its heels and the FDA has dragged its heels, we'd like to see it at the state level.
Well, I was going to ask you about preemption as you were talking, and you answered the question before I asked it for our audience members who may not be lawyers. Preemption would basically mean the federal requirements serve as a floor and a ceiling, and the states cannot require something different than what the federal government requires.
And let me be clear: we do think states can have different approaches on certain issues, such as milligram limits. There might be higher in Nevada than they are in Utah. So we do recognize that states need to have rights on those issues, but we do believe in preemption on the limited scope of issues where there is no right or wrong or ideological position, like labeling, like packaging, because consistency is going to benefit everybody, both the manufacturers and consumers.
And David, do you have views on the 3-pillar approach?
I'll just say that it's a viable framework, and I know that because we've done it in Ohio and in the cannabis industry. It exists, and we were already working through it, and it's proven to be successful. So yes, on the federal side of things, I think there are aspects of this that belong with state lawmakers, but uniformity is always good as well.
David, I see a specific question for you in the chat about dispensaries versus other retail channels. And the question is, I think, sort of potentially related to this question of kind of what should be in a regulatory scheme, whether cannabis sales should be limited only to dispensaries or whether other retail channels are appropriate for selling cannabis products.
My answer is, I think in time, we may just not be there as a state yet. We're ready to have retail. However, seeing that we have these intoxicating hemp products in retail, I certainly think the playing field should be level. But to the extent that it's not, and going back to my framework that we already have established, this is a successful way of keeping people safe while also using cannabis. So that's my answer to that.
And I think Michelle at least has already answered her views on that question. So, but I see a couple of questions in the chat about rescheduling of marijuana. And I will take a brief aside to plug that in April, the Drug Enforcement and Policy Center is having a webinar on the rescheduling process, as Yana just put in the chat, for marijuana that will include my colleague, Professor Rescheduling here at Ohio State, who's an administrative law expert, Professor Matt Lawrence, who's formerly a senior advisor at DEA, our alum, Kat Packer, who's a former state regulator, and myself with my sort of former HHS hat on, talking about it. So if you're interested in that topic specifically, please feel free to register and join. But the questions related to rescheduling of marijuana are whether rescheduling at the federal level, the proposal is currently to move to Schedule 3, not to completely deschedule, would impact the questions about bills, but I'd say would impact any state laws, a move from 1 to 3. And then a sort of question that's unfair to ask, which is what the current wisdom is or what your prediction is about what will happen, given that the process for rescheduling started in the previous administration. So if you have any predictions about the likelihood that DEA will continue to move on this issue. So 1, any impact on state laws? 2, do you think DEA is actually going to complete the process? Does anyone want to start off?
I'm happy to. Yeah, in terms of impact on hemp, there is none. I'll defer to Michelle and David on the impact on marijuana because it is substantial. But Donald Trump endorsed moving to Schedule 3 during the campaign, and so I think that there is still that same kind of energy behind it. The challenge is in DEA. The DEA folks that really resisted Biden, dragged their feet to get to the election. There's just a lot of possibility there, and so that is going to be, of course, it all depends on one man, who's Donald Trump. That if he decides to make this an issue, then we've seen on so many other issues the Republican Party fall in line, and certainly his administration fall in line. So we're all looking to see whether this is something that he really cares about or whether it was just a campaign thing that might get lost in the wind.
David and Michelle, do you want to chime in on whether there are impacts on state laws, or if you have predictions about what DEA will do?
Yeah, I'll go first. I have no prediction about whether or not this will actually move forward. If I was like had a gun in my head and I had to choose, I'd say nothing's going to happen. I don't think the current administration is going to make this a top issue in order to push the DEA to push the rescheduling forward. And when it comes to the impacts that could have on the marijuana market and the state laws, I think it would be very significant depending on what, for one, you get the banking issue. That's great. The biggest benefit would be that marijuana companies would be able to write off normal business expenses for their taxes, which would be an enormous tax saving. Right now they're paying an effective rate that's absolutely crazy. But then it depends on how the federal government then decides to regulate these products, which I imagine if the FDA is getting involved, HHS is getting involved, then that would start to preempt or in some way conflict with what the states have already put, have established already when it comes to marijuana.
David,
I have additional thoughts because Michelle nailed it.
Great. So sorry, I'm just looking back through the questions to make sure I didn't go miss any. But so there are a couple of questions about the Farm Bill, the 2018 Farm Bill, and whether we will see a future Farm Bill that addresses some of these intoxicating hemp issues. Jonathan, I think your discussion of Senator Wyden's bill and the other federal bill that would be prohibition sort of gets at where the federal government is headed here. But do you all have any predictions about whether there will be, what the chances of success are for some of these initiatives at the federal level?
Yeah, I mean, as I mentioned before, we were able to defeat, when I was talking about the Mary Miller Amendment, it was the Mary Miller Amendment to the Farm Bill. and we were able. Well, the Farm Bill died, but we were able to get House leadership, the House Agriculture Chair, to say that he didn't think it would be attached again to the Farm Bill, either now or before. And so I'm hopeful, and I'm very optimistic that when we do finally pass the Farm Bill, whether it's 2025 or 2026, that will not include any prohibitory language. And we'd love to see something like the Wyden bill attached to it. But again, a lot of water on the bridge and a lot of decisions that we made that have absolutely nothing to do with hemp or cannabis before we even see the Farm Bill moving.
Yeah, maybe it would help to clarify what the Miller Amendment would have done, which is, I mentioned that under federal law, under the last Farm Bill 2018, they, defined industrial hemp as having under a 0.3% Delta-9 THC concentration. And the Miller Amendment would have changed that to be total THC concentration. So meaning THCA, all of the other THC isomers. So currently right now, the USDA estimates that around 20% of the harvested hemp in this country is just thrown away. It's destroyed because it's hot, because it gets above that 0.3% limit, even though it's not at all intoxicating. And this kind of gets to the problems of why hemp farmers were putting so much stock into the CBD market, because we don't really have a hemp fiber. We don't have a very well-established hemp fiber market. The cannabinoid market is the one that is the most in demand, has the highest prices. So farmers are putting the money to that. Farmers are asking to raise that limit from 0.3% Delta-9 to 1%, saying that this will allow us to destroy less crop, to be more profitable, and still to keep intoxicating hemp out of the system, to make sure that it's tracked and maintained. So we are hoping that the Miller Amendment doesn't reemerge. We're hoping that the next Farm Bill will take, something like Jonathan talked about, the Wyden Amendment will take a more rational approach to this, so that it helps both consumers and farmers and doesn't create the unintended effects that we're kind of dealing with now with Delta-8.
Thanks for explaining that. David, do you have thoughts to add on that?
Okay.
So I see a question in the chat that I'm actually very curious about. We haven't talked, we've talked about, or we've touched on the idea that children might be exposed to intoxicating hemp products, but I don't think we've talked very specifically about products that mimic children's food products. And so the question is about what the hemp industry's position is on intoxicating hemp products that mimic food products that are typically marketed to kids. I will assume that the position is it's not good if kids accidentally get these products. But what are some of the regulatory strategies? What is the industry's position on what kinds of food products are appropriate, and what are some regulatory strategies that your stakeholders think would be appropriate to address that potential issue of children being exposed accidentally to products?
Yeah, no, we feel we need much stronger protections against kids and against marketing to kids, and they need to be enforced, both in terms of what's on the package, how the products are sold to the general public, but also ensuring strict age gating. This is something that is easier to do in person and tougher to do online. So we're really focused as an industry at promoting strong age gating online. Now, that is not, are you 21? Yes or no? That obviously doesn't work. It's kind of ridiculous. But there are new technologies that come out the last few years that are able to check databases, require the download of IDs, and make sure, and they've been used for tobacco and wine for quite some time. Apply those to hemp so that we can make sure the kids aren't getting online and buying those products.
Yeah, I would add to that, the gambling industry has done a great job of kind of laying down this model where you submit your name and then you get challenge questions. What car did you drive in 1998? What's your social security number, et cetera. And then they can match you to databases to know that you are who's, and for the parents out there who say, well, my kid has my credit card, well, my kid knows my social security. That's kind of on you at that point, like there's only so much the industry can do to make sure. But yeah, I just wanted to add that.
So I'll just add that the good news is that we already have all of these restrictions in place under through the Division of Cannabis Control. And if Senate Bill 86 goes through, all of these products will be sold in retail dispensaries where we are age gating properly. We do have package limitations being constantly reviewed. Everything is pre-approved even before they start the process of packaging products. Again, it exists.
I do want to add one thing, just to say that, as with what is intoxicating, what is appealing to children is one of those almost slippery slope issues where I would like to see states adopt, and this is where the federal government can kind of come in and help and say, these are our guidelines, because we don't want what happened in the e-cigarette market to happen for many reasons with any of these other products. But one of them being is this: bright colors are considered child appealing. We don't want to necessarily have the drab gray box, that you give to adults, but we obviously don't want known cartoon characters that appeal to children or advertisements that are aimed, where children will be more likely to see it than anybody else.
It's highly likely that litigation is going to ensue at some point on these particular questions of what is attractive to children, what's not. We're gonna have to have a court tell us where the line is drawn.
It's like obscenity, you kind of know when you see it, it's unicorn poop or whatever, but if it's just Oreo flavored, is that necessarily? But yeah, I hope we get some clarity on that and some kind of principled stance from various stakeholders up to the federal government about what this means, and can adults still have fun while we don't market to children?
Well, we are right at time, and can adults still have fun while we don't market to children? I feel like is a nice question to leave us all with. I've seen a lot of comments in the Q&A thanking our panelists for their discussion and their expertise. I don't think we have the clap emoji in the webinar, but thank you all three of you for joining us. This was really informative and interesting, and we appreciate your time.
Thanks so much for having us.
Customize and save with Liberty Mutual, so you only pay for what you need.
EasyCater is the premier tech platform for ordering food for your workplace from your favorite restaurants. Here's what it brings to the table: integrated bagel logistics and ultra-scalable burrito deployment.
Get started at easycater.com. Previously on Drugs on the Docket.
In a stash house sting, you have federal law enforcement officers creating a crime and choosing individual people to commit that crime, targeting individual people on that crime. 92% of the people who the feds target to commit this crime are people of color. There's these really long mandatory minimum prison sentences attached to every single case. And it's even possible to get life in prison, mandatory life, for this entirely made up crime. our litigation shut down this whole stash house operation in Chicago. Like federal prosecutors stopped bringing these cases. And then I've also heard from a very reputable source that at this point in time, the operation has basically been shut down nationwide. And I have personally not heard of a new stash house case in a number of years. And no one has actually. We've been keeping our ear to the ground and we haven't heard of anything.
The litigation conducted by the clinic and the Chicago Defense Bar in the Seventh Circuit Court of Appeals resulted in reduced sentences for their defendants, with many being sentenced to time served and subsequently released from supervision or incarceration. But as Allison pointed out in part 1 of our 2-part episode covering the clinic's work on these cases, there were hundreds of other stash house defendants in the United States federal system serving decades-long prison sentences for similar crimes. One of these defendants was Dwayne White. The stash house stings were supposed to target violent people who were driving gun violence in Chicago, but White only had a minor criminal record. The federal agents did not target White directly. Rather, White was called last minute by a trusted friend, Leslie Mayfield. The two of them were arrested and charged. White turned down a plea deal to serve 15 years in prison, but was convicted at trial and sentenced to 25 years. Mayfield's initial conviction was reversed, and he became one of the 43 defendants in the Chicago criminal class action suit, which you could hear about in part 1. As a result of that litigation, Mayfield was released in 2018, only 6 years after his initial arrest. White, meanwhile, remained behind bars and would not be released until 2030. Mayfield asked Allison and Erica for help. Erica filed a compassionate release motion on White's behalf with a letter from Mayfield. It was me who lured Dwayne into the case. I was standing right next to him when, 2 weeks after our arrest, he was told that he had a child on the way. It's not too late for her to have her father. The motion was successful. Dwayne White was released from an Alabama federal prison in August 2021 and was greeted by his daughter at the airport in Illinois. She was 11 years old. From the Drug Enforcement and Policy Center at The Ohio State University, this is Drugs on the Docket. Each episode will tell the story of how U.S. court decisions impact drug law and policy and continue to shape the war on drugs. I'm your host, Hannah Miller. Today, we continue our coverage of the Seventh Circuit Stash House litigation and compassionate release. If you like what you hear in today's episode, visit go.osu.edu/drugs on the docket to follow the series. The 43 defendants of the Stash House litigation that you represented had not gone to trial yet or taken plea deals already or been sentenced already. So what happened to the other defendants who'd already been moved through the system and were not part of this litigation?
As Allison mentioned, there were 94 individuals who were charged in connection with the Chicago, Stash House reverse sting operation. So after our litigation had concluded and all of those, the 43 people who were part of our litigation were sentenced, we knew, because we had been reading about their cases, that there were, about 40 other people whose cases were already closed. Their convictions were final and they could not join our litigation. 40 plus people who are still in prison. They have exhausted, most of their post-conviction remedies at this point, habeas, clemency, direct appeal, and they're serving decades in prison. And so they were without hope at this point. And obviously they were hearing about this litigation that was happening, and there just wasn't anything at that point while we were litigating that we could do. But after it was over, we started to think about, was there anything that we could do? And we didn't know quite what it would be. But I think that is the wonderful part about practicing in a law school clinic and having just come off this litigation where we were really pushing the boundaries, being creative advocates. So in the fall of 2019, my students and I started a project to try to get these 40 plus guys out of prison, if we could, or at least start by trying to get a few out of prison. And the key to all of our work was the First Step Act, which was signed into law by President Donald Trump in December 2018. And this was really the first federal criminal justice reform in decades. Congress finally steps in and makes some really, monumental changes, both to drug sentencing statutes and then also to compassionate release.
Talk us through the First Step Act, because there's a lot going on in that bill.
So the first part of the First Step Act were these once in a generation changes to these draconian recidivist sentencing enhancements that had just for decades produced these breathtakingly long sentences in federal drug cases. And the way that the enhancement worked, and this applied to our the Stash House clients, if you're charged with a federal drug offense and you had a prior drug conviction on your record, the prosecutors can file a notice to enhance your sentence from a mandatory minimum of 10 years to a mandatory minimum of 20 years. If you have two of those convictions on your record, they can enhance you from a 20-year mandatory minimum to mandatory life. And these prior convictions, prior to the First Step Act, did not have to be serious. For one of my clients, his enhancing conviction was a prior for simple possession from when he was a teenager. And that was enough to take his case and take his, mandatory minimum from 10 years to 20 years. So in the First Step Act, Congress finally recognizes, these sentencing enhancements are extraordinarily harsh. So they change both the penalties that attach to them and then what kinds of convictions can actually qualify to enhance the sentence. But Congress did not make these changes retroactive.
What did the passage of the First Step Act mean specifically for the stash house litigants?
Anyone who was sitting in prison with a final conviction could not get any relief at all. And many of this, what we've called the pre-litigation cohort of stash house guys, the ones whose convictions are final and they're in prison, fell into this category. They had these 851 enhancements that could not be imposed today. So for them, on top of being in prison for a reverse sting based on these fake drug amounts, in spite of hearing that guys who did the exact same thing as them in Chicago, the same playbook, the same prosecutors charging these cases, they're hearing that these guys received sentences of on average 2 to 3 years. They are also in prison serving double the time that they would get if they were sentenced today. And Congress's message on that was tough luck. Our changes don't apply to you.
You mentioned that many of the stash house litigants from the first cohort had exhausted their options for relief. What avenue did the First Step Act provide them?
The second big change in the First Step Act is the change to what's become known in the federal system as federal compassionate release. It's a sentence reduction statute that Congress enacted in the 1980s around the same time that it abolished federal parole. And the statute is really interesting. It's not called compassionate release, even though it's come to be known as that. It is called a sentence reduction statute, and it says that judges may, for extraordinary and compelling reasons, reduce an otherwise final sentence if the reduction is consistent with the sentencing factors and applicable sentencing commission policy statements. The problem with this statute from the get-go was that Congress made the Bureau of Prisons the gatekeeper. And for decades, the Bureau of Prisons just refused to open that gate, even in cases where people were sort of the quintessential compassionate release circumstances. Someone has a terminal cancer and they're dying. Even then, the Bureau of Prisons was obstructing this congressionally mandated path for people's sentences to be reduced. The BOP's really cruel handling of this really galvanized advocates to demand reform. And Congress finally delivered by making a really, really crucial change to the statute. In the statute, it said the Bureau of Prisons had to bring these motions, and that was just causing this logjam because the Bureau of Prisons wasn't doing that. So the change that Congress made was saying, individuals can bring these motions to judges after they've exhausted with the Bureau of Prisons. Essentially, they make a request to the Bureau of Prisons. The Bureau of Prisons either doesn't respond or denies, and then you can take that motion into court. And that was a game changer.
I'm sure Congress did not have stash house sting defendants in mind when they created the standard of extraordinary and compelling reasons to justify a reduction in sentence. I'm also confident that anybody listening to this podcast knows I certainly think these are extraordinary and compelling reasons, right? That language is in fact so fitting, and the way in which the First Step Act meant now that defendants could bring such claims directly into court, so powerful against the backdrop of this whole story and the legal standard that exists in the sentence reduction statute.
The interesting, I think, wrinkle about all of this is Congress, in a prior statute from the 80s, had tasked the Sentencing Commission with describing what reasons are extraordinary and compelling in a policy statement. So that was always in the Sentencing Commission's wheelhouse. That was their role. And after the First Step Act, so this monumental statute is passed, it makes these big changes, the Sentencing Commission loses its quorum. And so they are without a quorum, and they cannot update this policy statement, which was based on the prior version of the law where the Bureau of Prisons was involved. And that created just this really interesting period of litigation around what could be extraordinary and compelling. It became like a laboratory of sorts for what kinds of arguments, were resonating. Like, could something like the circumstances of the stash house, continued incarceration for crimes that were no longer being investigated, and these, massive sentencing disparities, was that extraordinary and compelling? Seems to me that it was. So it was advocates trying out all these different types of arguments, and then district judges and appellate judges having to decide are there boundaries to what can be extraordinary and compelling if the Sentencing Commission has not defined it? And so there were circuit splits about these non-retroactive changes in the law that were passed in the First Step Act, whether those could be extraordinary and compelling. And in the Seventh Circuit, where we practice, it became a very constricted landscape for compassionate release motions and what could be extraordinary and compelling, but that was not the case in other places. So what we decided to do was we were going to bring compassionate release motions and argue that our client situations were extraordinary and compelling for several reasons. The first argument we made was that the fact that they were sitting in prison for these 25-year mandatory minimum sentences for a reverse sting operation that the government had completely changed course on, no longer investigating it, no longer charging it, and essentially had disavowed it, that in and of itself was extraordinary and compelling. The second thing we argued was that these sentencing disparities that were created, and we had this perfect illustration of how extreme and unfair the sentencing disparities were, because we had people who, it was the same playbook, the same story that they, all these people were told in the same area with the same agents, and a whole cohort are in prison and convicted for decades, and a whole other cohort get these time served sentences. They're out in their communities, they're with their families. I think the longest sentence served in that cohort was about 9 years. So just drastically lower. And that the government had
Franklin University makes it possible.
Endorsed these deals. They'd endorsed these lower sentences, essentially conceding like that's enough time to punish what was done.
Am I wrong to guess the government wasn't as keen to endorse your sentence reduction motions?
No, they were not. And they are still fighting them. I think it's actually shameful that they're doing that. Now, especially that the Sentencing Commission has issued a policy statement, they could support or not oppose these motions, but they continue to oppose them, even though many judges now have determined that these circumstances are extraordinary and compelling.
The motions for compassionate release versus sentencing reduction, are those completely different, or they also relate to Stash House cases?
Sorry for throwing out different terms. So these motions are generally like compassionate release motions is how they've been called. There's a move to call them reduction in sentence motions because it more appropriately like captures what they're about. And I think people tend to associate compassionate release with like people dying. And really what's interesting about the statute is it doesn't talk about that at all. It just talks about extraordinary and compelling reasons. And this new policy statement enumerates a lot of non-medical reasons that are extraordinary and compelling, like sexual and physical abuse in prison, extraordinary family circumstances. It now includes this unusually long sentence provision.
And I'll get on my high horse at this moment about the lingo, because, my sense is your clients are a spectacular example of people who are not asking for compassion. They're asking for justice, right? They're asking for equity. They're asking for equal treatment. They're asking for a just outcome in light of the fact that a whole cohort of others, just really as a matter of timing, got much, much lower sentences. And ultimately, they not wrongly believe here's a mechanism to tell these compelling and extraordinary stories and get justice done. That's why I'm on sort of team, let's call it sentence reduction motions rather than compassionate release motions, because I do think that labeling of compassion makes it sound like you're asking for something that's not deserved and shouldn't be expected. I understand why they're fighting, and this is a little technicality. Oh, Congress didn't make this law retroactive, so you shouldn't get the benefit of this law if you don't fit the technical categories. But your clients have that on top of this history of Stash House stings that have this pernicious racial disparity and all the other uglinesses that are part of it.
Right.
To me, that should be a no-brainer of, okay, well, this cohort at least has an extraordinary story. And I think the judges have largely agreed with you when it gets to that point, right?
Yeah. And we raised for many of our clients the non-retroactive changes, which was the issue of the circuit split, whether those could be extraordinary and compelling. And in the Seventh Circuit, before the judges decided our motions, the Seventh Circuit said those are categorically barred from being an extraordinary and compelling reason. So we really did have to lean into this combination of factors, the sentencing disparities, the pernicious nature of the stings, the fact that the government wasn't charging them anymore. We also raised other arguments relating to our clients' health issues, like anything that we felt like could really strengthen our arguments. And once, we started to get decisions, we thought these were strong arguments, but these non-medical grounds were very new. They were untested. And so we really didn't know where these were going to go, especially once we lost the case in the Seventh Circuit is Thacker, which barred the non-retroactive changes. And we were just overjoyed when we got our first grant, actually, for our client, Dwayne White, who was Leslie Mayfield's co-defendant. He was serving a 25-year mandatory minimum sentence. The judge granted the reduction to time served, which was about 12 years. And then we had two other clients their motions were granted and they were also released, both also serving 25-year mandatory minimum sentences. And so the judges were agreeing with our arguments. And so we just kept filing the motions. We had thought about, we had the whole list of people who were still in prison. We had information about whether they had these 851 sentencing enhancements. We had more information about their cases. So we just kind of kept going down the list.
I'm curious if you all saw an interplay between the judges considering the compassionate release or reduction in sentence motions and those who had heard the evidentiary hearing when the racial disparity claims were being litigated. Do you notice a difference? Do you sense that the judges who were at the heart of that litigation were more sympathetic? Or is that just one of a lot of things that they listen to because at the end of the day, they're ironically maybe concerned about releases creating a precedent and suggesting that there are all these, as you mentioned, non-medical reasons that could be the foundation for sentence reduction?
That's a really interesting question because of the judges who have decided these motions, two were sitting, the district court en banc and heard all the evidence, heard the experts and all of that. And I do think it was impactful. I think having had the background, having seen firsthand, they were also then involved in people getting these lower sentences. So they had also seen how that had happened. And I think in their own minds, one of the judges here wrote it was actually the first compassionate release reduction in sentence grant in the Northern District of Illinois after our litigation. It's called United States versus Conley. And if you read it, the opinion is just scathing. And part of it is the Judge Coleman, having seen what happened to people who were part of our litigation, and then what happened to people who were left behind, and the real injustice of that. So I do think that the work that we did on the compassionate release reduction sentence side would not have been possible, obviously, without, it was just the foundation of that was the litigation. After the first 3 releases, we had 3 more Stash House clients released since then. 2 were just released this summer. And then there was a whole other cohort of Stash House guys who were released during the COVID pandemic. So the extraordinary and compelling reason was vulnerability to COVID, but they were also in the Stash House cohort. So there's now been a total of 11 of the 40 plus people who have been released under the sentence reduction statute, and truly seeing them come home, reunite with their families, hear about all the amazing things they're doing. There's just nothing better than that for us and our students.
I'm sure you guys could tell literally hours of narratives about individual persons as well, because that's part of what makes this work both so meaningful and so challenging, as you were talking about, Erica, just seeing people come home and this is people locked in cages and having a very strong argument for why they shouldn't be, and getting courts, getting prosecutors, getting the system to pay attention. It's fascinating to hear what I know is just kind of the tip of the iceberg, but we're incredibly grateful for you all sharing it with us.
Yeah, there are so many, I think, really powerful threads and that run through all of this.
I don't want to overlook this, that only 3 men from the cohort of people who were not able to take part of your litigation. So 3 out of 94. So 91 people are out. Either they served their time, unfortunately, but many of them were released, at least a decade earlier than they would have been. So there are only 3 men.
3 men left. Many have been released within, just because they've, unfortunately had to serve their entire sentence. They've been released within the last 1 to 2 years. There's 3 people left, and we're representing 2 of them to try to get them out on the Stash House reduction in sentence arguments. So the Sentencing Commission finally got a quorum, and one of the first things that they had to do was address the reduction in sentence policy statement. Because Congress had tasked them with deciding what's extraordinary and compelling, they had this really tough job of deciding what should the policy statement look like with these changes. And so they held hearings, they received literally thousands of public comment on this issue.
And you testified too, correct?
I testified, one of our clients testified, Dwayne White, our first client, released. His story, it just encapsulates everything, both that's wrong with the Stash House stings, and then that was also so wrong with all the people that were left behind serving, these incredibly long sentences. He was somebody who was asked the day of by Leslie Mayfield to come along.
And Leslie Mayfield was part of your litigation in the Seventh Circuit. Okay.
So he had the fortuity of being part of our litigation because his conviction got reversed after trial. So it was so many things falling into place. But what we saw was Dwayne was recruited by Leslie at the last minute. I really don't think Dwayne knew exactly what was going on. So he gets to the sting, the arrest point, and the agents had never seen him before. They were wondering what was going on. Dwayne was 21 years old at the time. So they give the call to do the arrest. He's arrested along with everyone else. And suddenly he has this litany of mandatory minimum charges against him. He's got this 851 for simple possession from when he was a teenager. He got a 15-year plea offer that he turned down because his girlfriend, he found out when he was in prison pre-trial that she was pregnant, and he just couldn't get his mind around the idea that he was going to serve 15 years mandatory for showing up for this, reverse sting. So he also testified in front of the Sentencing Commission as really kind of the quintessential, non-medical reduction in sentence grant. This idea that you could have this constellation of circumstances that are extraordinary and compelling. And his panel, there were 4 other individuals who formerly incarcerated who had also received reductions in sentence. And it was the most powerful panel, just hugely, hugely, I think, impactful on the commissioners. It was the first time the Sentencing Commission has ever had formerly incarcerated people testify. And I think it really went a long way towards showing them the importance of compassionate release and reduction in sentence, and the importance of giving judges discretion to decide what is extraordinary and compelling.
So the commission ultimately expanded the grounds for release then?
They did. They expanded them in some really, I think, groundbreaking ways. So one question that the commission had to address and weigh in on was this circuit split about whether non-retroactive changes could be extraordinary and compelling. Because this was something like, if you're in the Seventh Circuit, you can't get relief if you're arguing that these, legal changes in your case are extraordinary and compelling. Whereas if you were in the 10th Circuit, the 4th Circuit, the 9th Circuit, people were getting out. So it's just this geographic disparity and injustice that the commission, had to address. And the way that they did it, I think, was very interesting. They ultimately promulgated this unusually long sentence provision. So they don't come out and say, non-retroactive changes are extraordinary and compelling. What they say is that an unusually long sentence where someone has served at least 10 years in prison, there is a gross disparity between the sentence they received and the sentence they would receive today, and the person's individualized circumstances support relief. All those things are satisfied that it may be an extraordinary and compelling reason. So it's much, much, much narrower than the legal question that judges were deciding, prior to the policy statement being enacted. Nonetheless, the government has a, I think, very disappointing nationwide litigation position of saying that the unusually long sentence provision is legally invalid, that the commission overstepped its authority in promulgating it. So that litigation is playing out, in the courts right now.
How do you feel about the outcome of that?
I think there's going to be a circuit split on this issue, and it's probably going to have to be decided by the Supreme Court. I think on the merits of the argument, I don't think the government has a strong argument. They have a policy disagreement with what the Sentencing Commission did that they are trying to litigate as a legal issue. They are saying that Congress, in spite of not saying it, really meant that the Sentencing Commission couldn't describe extraordinary and compelling reasons, or that there are these, extra textual limitations on what the Sentencing Commission could do, when in fact, Congress was very clear about what the commission could do. It said they describe extraordinary and compelling reasons. The only reason that is off base is rehabilitation on its own. So that's the only thing that Congress said. They didn't say non-retroactive changes are off limits. They didn't do anything like that. I think the reality is that some judges in the circuits where, the bad circuits, I call them, like the Seventh Circuit, where we haven't been able to bring these motions until the policy statements took effect, I think judges are going to be wary of granting these motions. They're going to want to see what the Seventh Circuit thinks. So those cases are all, making their way, or we'll see how district judges come out. In, the good circuits where compassionate release and reduction in sentence was fairly broad, we're seeing already, grants under B6, the unusually long sentence provision, for reasons that are broader than non-retroactive legal changes. So case-related legal changes. So it's going to be, what circuit people are in is going to be determinative. I hope, pray that this, that this issue comes out the right way, because what the Sentencing Commission did was absolutely legal. It's good and sensible policy reform. And I think it's beyond disappointing to see the Biden DOJ essentially go after the Biden Sentencing Commission, who really put a lot of thought and care into this policy statement. So that's one change.
It's one thing to think about just black and white, Department of Justice, prosecutors, bad guys, and then defense, good guys over here. But then that political element just does make it baffling, because you have a Biden DOJ with like you said, a Biden Sentencing Commission duking it out in this way, or at least not being aligned. I wonder, does administration changes halt DOJ efforts in their tracks? Are you afraid one way or the other that if it's a non-Biden DOJ, do you think that it's going to carry on? Do you think that the policy statement will change with a change in administration?
I think it could. I think that the promulgation of the compassionate release policy statement was divided. It was, the commissioners came out on it 4-3. And so the legal arguments that the DOJ is making right now are essentially the arguments that the conservative commissioners made when they were objecting. And they weren't objecting to the whole policy statement. I think that there were other changes that were made, like I mentioned, sexual and physical abuse in prison. The enumeration of that is an extraordinary and compelling reason, which is also very groundbreaking. It was something that was not in the previous policy statement, and was the result of a lot of advocacy by a lot of different groups to bring that to the fore. But I think the unusually long sentence provision is going to be a hot potato. I think it's going to be a hot potato in the courts. I think, it remains to be seen what might happen if there's a new, administration. There's a sentencing commission that goes 4-3, Republican. But I think it does get harder once there are more decisions that judges are making granting releases. Something that I've talked to Doug some about is the catch-all provision, which I think it's going to be extremely interesting to watch that provision going forward. So this was always a part of the Pre-First Step Act policy statement. It allowed the Bureau of Prisons to move for a reduction in sentence for other reasons. They could be related to the enumerated reasons or not. And there was a fight over whether they should keep the catch-all and what it should look like. And ultimately, the commission did keep it, and it's fairly broad. So the stash house motions that we're going to be bringing, we're bringing those under the catch-all. It's these combination of extraordinary and compelling reasons. And it's, it was really the Sentencing Commission's acknowledgement that it would be impossible to enumerate everything that judges might find to be extraordinary and compelling.
Seems like a really subjective standard.
It's super subjective and it's super individualized, both on the extraordinary and compelling reasons. And then also, I mean, that's just the first step of the process. You also have to convince judges that the sentencing factors, support and warrant release, and that your client is not a danger to the community. So a lot of motions, even if they make it past the first stage, don't make it past that stage. So I think, there are going to be a lot of grants under the catch-all. And that is also, I think, a way that judges might insulate what they're doing if they're worried about doing a grant on the unusually long sentence ground. I think many judges may say, I'm also granting under B5 because there's this combination of extraordinary and compelling reasons.
I think these motions fundamentally are motions to encourage judges do equity with the benefit of hindsight. And that's where this kind of litigation, all the other flaws and uglinesses that are in our criminal justice system get exposed. And that's among the reasons why the Department of Justice is like, no, let's not look over there. I don't want to suggest any way that they're inherently the bad guys, as much as I want to kind of highlight that this is no fun for them. Putting away the bad guys is what's fun for them. Having to confront, deal with, particularly when they're very effective advocates for prisoners, here's all the things that looked ugly in your case. And oh, by the way, there's no good reason to keep this person in prison, that they have to respond to that they have to respond to that on every possible ground, rather than can try to argue as they did to the commission, but lost. Oh, don't let somebody ever bring this kind of argument to get in the door for this kind of reduction. And so I think it's, again, to me, why it's so valuable to tell both parts of the story, the incredible work that the clinic did to explain how problematic these prosecutions have been, and then also to highlight that the compassionate release statute, the reduction in sentence statute, now provides an opportunity to highlight that, and yet creates all these challenges and depends on what the Sentencing Commission has chosen to do with its policy guidance, what the Department of Justice has chosen to do in response to these kinds of cases. And so I'm incredibly grateful. We've covered so much ground on so many hot topics in not much more than our usual amount of time. I certainly feel like we've covered so much so well. I want to make sure either of you get a chance to say a last word, or make sure you cover something that may not have been covered.
I was just going to say, thank you so much for having us on to talk about these cases, the injustices, the litigation that we and the federal defenders in Chicago and others did. I've always had so much admiration for you, Doug, and for the work that you did. I mean, back when I was a pretty new federal public defender in the mid-2000s, it was your work about federal sentencing that really helped us fight for justice for our clients, in the midst of Blakely and Booker and all of that. The writing that you were doing on your blog, I mean, it was something that on a daily basis, federal defenders across the country were reading and using to advance our arguments. And so I'm very honored to be on this program. Thank you.
I completely concur with Allison on that. And I don't honestly know how you do it, how you reduce the amount of content you do, that you teach and that you do this. But, your blog is like the first place I go when I want to know, what's happening, both with like the compassionate release reduction and sentence stuff, but everything sentencing related. It is an absolutely huge honor to be on this. And I feel like I could talk to you guys for another hour. So I know we don't have enough time, but I guess one thing, Doug, I think the last point you made about these emotions is it's just so on point. And I think there is an education process that federal judges are undergoing by reading these motions. And that's why I think it is so crucial that people have lawyers, which is not happening in the Seventh Circuit, appointed lawyers. But these are stories about what happens when federal judges sentence people to prison, stuff that none of us were hearing about. When I was coming up as a federal defender, these weren't motions we did. So I didn't hear, about Bureau of Prisons, what was happening. And it's pretty horrifying. And I think there's some judges who are never going to want to use this. The Sentencing Commission has given them you have to, but they're going to find ways not to. But I think for judges that have the humility to look and say, we may have gotten this one wrong, or even if we didn't get it wrong, the person has served what they need to serve. Any additional incarceration is unnecessary. I think it is such a valuable contribution to making our system more just and fair.
Drugs on the Docket is a production of the Moritz College of Law Drug Enforcement and Policy Center. This episode is produced by me, Hannah Miller, and Holly Griffin. Doug Berman is our editorial advisor. The music is composed by Joe DeWitt. I often imagine traveling back in time to interview Americans about a variety of issues. The closest we can get to understanding just how much culture can. Thank you for attending Implementing Issue 2, Adult Use Marijuana Reforms and Future Challenges. The event is hosted by the Drug Enforcement and Policy Center at The Ohio State University Moritz College of Law. Before we begin, we have just a few notes we'd like to share with you. First, we want to draw your attention to the Q&A function at the bottom of the Zoom window. The chat is disabled, but you may submit questions at any time. Please note, however, that there is limited time available for Q&A during the webinar. Second, automatic closed captioning has been enabled for the event. To change how you view the transcription or to hide it, click Show Caption in the menu at the bottom of your Zoom window. Finally, this event is being recorded. The recording will be made available on our YouTube channel as soon as possible following the event. A link will be shared with all registrants via email as soon as it is available. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the discussion. Doug?
Thank you so much, Holly, and thanks everybody at the center for helping to give us this opportunity to connect and hear from some terrific panelists on implementing issue 2. I am just going to do a brief introduction. I'm Doug Berman. I'm the executive director of the Drug Enforcement and Policy Center, and I've been incredibly grateful for getting participants like we have here, experts, to talk on topics like this, and also for the incredible work that our research team has done. I would highly encourage everybody interested in Ohio marijuana reform to go to the Drug Enforcement and Policy Center's pages, and especially our research pages. We've done dozens of reports both before the passage of issue 2 and since, to just try to deepen understanding of both what issue 2 has done and hasn't done in a variety of ways. That's largely what we're talking about here. I almost find it hard to believe it's been a full year already since issue 2 passed and became law here in the state of Ohio. I'm so excited to have a chance to reflect on a year in, especially because I'm not going to do much of the reflecting. I'm going to turn it over. We have the honor of having Jeremy Noble from Crane's business. He's the finance and legal affairs reporter for Crane's Cleveland business. He's also been covering cannabis issues for nearly a decade, and he's going to be serving as our moderator. He'll introduce our other panelists, and I'll just get to join the rest of you as participants. Thank you for joining us today, and thank you, Jeremy, so much for taking the moderator mic and leading us through what I'm sure is going to be a very informative discussion.
Yeah, Doug, thank you very much for having us. Yeah, we do have a pretty great panel here. So I'm just going to do some quick introductions for everybody. First, we have Andrew McCoskey, who is Chief Legal Counsel for the Division of Cannabis Control, which is the state's cannabis regulatory body. Thanks for joining us, Andrew. We have Kat Packer, Distinguished Cannabis Policy Practitioner in Residence at the Ohio State University's Drug Enforcement and Policy Center, and Director of Drug Markets and Legal Regulation at the Drug Policy Alliance, which is a New York-based nonprofit. Hi, Kat. Thanks for joining. Next, we have Shalene Title, Distinguished Cannabis Policy Practitioner in Residence for the Drug Enforcement and Policy Center, as well as founder and director of the Parabola Center for Law and Policy, which is a think tank in Boston. Shalene, thanks for joining. And last, but certainly not least, we have the illustrious Tom Herron, a partner and chair of the cannabis practice for the law firm Franz Ward. He's also spokesman for the OCAN Industry Trade Group, and y'all might know him as a key figure behind the adult use referendum that Ohio voters approved in 2023. Tom, thanks for joining us as well.
Thanks for having me. It's nice to be here.
So to get things started, I thought we'd get each of you to just share some general thoughts about the status of the marijuana program today. You know, perhaps each of you could just share your thoughts regarding how far we've come with setting up rules and regulations in Ohio, and maybe some, thoughts on priorities on that front moving forward as we look at what's left to be done. From there, we'll probably dig into some of these things in a bit more detail. Tom, I thought maybe we'd start with you as our industry representative, then maybe go to Shalene and Kat, and we'll wrap it off with Andrew. So Tom, tell us a little bit about what you think about the program, just as, in terms of where we are today, where we've come from, and what we have left to do.
Well, look, I think to level set, we are light years ahead of where we were a year ago, certainly 2 years ago at this point, right? We have an adult use program that is up and running, thanks in large part to the hard work of the folks at the division, like Andrew and his team, who have spent the last, better part of the last year and a half, writing rules to allow for the conversion of existing, licensees from medical only to what are called dual use licensees, meaning they can produce and sell for both medical marijuana market as well as the adult use market. We are in process of authorizing an additional 130-ish dispensaries throughout the state. Prices are still high, which happens in every single market, by the way. Those prices will continue to come down as supply increases, right? As cultivators build out additional space, as more of these dispensaries get online. So I think we're in a really good position here. We've had a more profitable or larger rollout by dollar value than both Michigan and Illinois when you compare sort of this stage in the adult use life cycle. So that says to me that we've got a lot of runway left from a business and industry perspective to compete with some of the top adult use markets in the country.
Shalene, you want to go next? Tell us a little bit about, just like where we're at today and where we still have to go. What do you think?
Well, I'm primarily filled with empathy for the regulators because I think this period is the hardest. I definitely remember from my time in Massachusetts that there was extraordinary pressure to speed up, even though it felt like we were going at warp speed, writing rules and moving forward with implementation. But secondly, I would say this is a frustrating time for anybody who cares about social justice and racial equity, because the top thing that you will hear from advocates who care about those things is, whatever you do, please don't start by saying we're going to implement sales. We're going to allow the existing operators to start sales, and then we'll worry about the social equity and justice pieces later. And this is really when you find out just because something is written in the law doesn't mean that it's going to happen. And this is when you find out where the priorities really lie in different states. And when I was a regulator, this was a mistake that we made. We started out with priority, we thought, for both social equity and existing operators, ended up being only existing operators because they had so many advantages. And then in the meantime, those social equity operators that by definition have the most disadvantages were left far behind. And so it kind of feels like that's happening yet again. It feels like Groundhog Day is really tough to watch. And I'll add that when it comes to the taxes that are being collected, fortunately, I think that criminal justice reform hopefully will be done sooner than later, but it can kind of be done effectively anytime. But when it comes to industry participation, it is irresponsible to wait, because the longer you wait to spend social equity funds on something like grants and loans to social equity participants, the less effective those funds will be, because they can't go far when you're entering a market that is already entrenched and dominated by certain operators. And I think it's similar with job programs, when people are already taking those jobs and they're already gaining experience. And so it's tough to balance all of these different areas, but I think at the least I would love to just see a timeline or a goal for when we can expect the social equity pieces of the law to come into place.
Yeah, I think we're definitely going to talk a little bit more about that bit here in just a little bit. So definitely more on that. Kat, do you want to give us some of your thoughts just on where we're at today?
Yeah, sure. I think in general, I am pleased to see the state of Ohio join other states in allowing for adult use cannabis, that we're not categorically a prohibitionist state anymore. I do think that that's critically important, in part because this is a voter initiative passed by about 57% of the voters. And I know that this is something politically that was rather contentious in Ohio prior to the passage of adult use legalization. I know that there were lots of legislators in Ohio that were opposed to legalization, opposed to the campaign itself. And despite that opposition, Ohio still has an adult use cannabis program. And so I do think that is progress. But I share Shalene's sentiment and having frustration with what seems like the prioritization of business opportunity for existing operators, while there is simultaneously seemingly no action on the components of the social equity program. And it's important to note that this was not like a side project of the initiative itself. There are only 4 express purposes in the initiative. One of those express purposes essentially was to create a regulated adult use market to limit the transportation of cannabis out of state. And the last 2 were really about funding social equity and improving social equity. And so half of the initiative itself and its express purpose is about reinvesting into communities. And I know that we use this term equity, and a lot of times we're talking about market equity and opportunity to participate in the market itself. But the reality is that the way that the social equity provisions were written into issue 2, equity extends far beyond licensing opportunities in the industry. There are provisions in issue 2 that are supposed to fund criminal justice reform, fund things like education and legal aid. And we know that there are communities all throughout Ohio who are in need. And so I think that there is an equal need for prioritization of all of these other provisions of issue 2 that have not been equally prioritized to date.
No, I think that's a good overview. Andrew, now I'd like to flip it to you. Just from the regulatory perspective, you want to give us some thoughts just on where we stand today, maybe what's already been done, and then after that, I'm going to ask you a little bit about just how the rulemaking process works. But just give me your thoughts on just where we're at today, maybe what's already been done, and how everyone's thinking about future.
Yeah, for sure. I think as the regulator that's sort of on this panel, our goals are maybe a little bit different than a lot of places. And one of the things that we look at is the metrics that we judge success by is, are we meeting the deadlines that are explicitly outlined in the statutes that we are meant to enforce? And I think that based on that type of metric, we really did what we were supposed to do. We provided rules on time, provided applications on time. We began adult use sales earlier than I think was even projected or was required from that standpoint. And then the other piece of that is, are we enacting the statute as it was kind of meant to be done? And I think that from that did, everything we could to do that. Location of the new licenses that are coming online, sort of equal playing field and the availability for all of the licensees that are in the marketplace and have these licenses to get access to those items. And also to ensure that the products that we are producing, that we are still sort of maintaining the medical requirements when it comes to product quality, testing, making sure that the items that do get out into the marketplace are safe, tested, as they have always kind of meant to be. So by that standpoint, I think we're really proud of the work that we've already put together. We know that there's a long way to go on a lot of these pieces. The statute is not fully implemented yet, and we are continuing to kind of work and make sure that those pieces are done. Not to jump ahead too far, but you mentioned the rulemaking process. The rulemaking process in Ohio goes through a lot of stages. There's various steps that sort of need to be done, and we took the strategy pretty early on that we need to carve this up. We can't reasonably meet the deadlines that are in the statute unless we are able to successfully figure out where the priorities are going to lie. So the first rules that we wrote were specific to the licensing process, were specific to the application process, were specific to getting those parts across the line first. The second set of rules that we put together were having to do with the structure, the implementation of security, structural quality requirements of the actual facilities themselves. And the next few rules packages that we're targeting have a lot more to do with the operations side. They have to do with new product types, new product testing, as well as packaging and labeling, advertising rules to meet what the statute has kind of put together for us. So we've been moving these packages through at various stages with a very kind of explicit goal of we put these in different packages in order to make sure that we are meeting the statutory requirements that are put in front of us. So I think that we're happy with what we've done. I think that, anytime you look back, you could find a lot of things that you would do differently, but it was a difficult task that was kind of laid in front of us. I'm glad that some people have been on the regulatory side. You know how difficult it can be to get your rules packages together to meet all of those particular deadlines, and we worked pretty hard to make sure that we were doing that. So that was what we were proud of, and we've got more work to do for sure.
Is there anything else you want to, or that you could add, just in terms of helping people understand like why this process can take some time? I mean, I think reasonably speaking, we would understand that putting a lot of these rules together will take some time. But at the same time, I do think some people just look at issue 2 passing in 2023 and wonder like why is this taking so long? Andrew, is there anything else you just want to add, just in terms of like how regulators are being thoughtful about this process, just maybe the layers of approvals that we have to go through, because these laws have to go through a JCAR process, right? It's not like DCC just says, okay, we're going to do this, and you can snap your fingers and get it done, right?
Yeah, that's exactly right. The rulemaking process doesn't even start at JCAR; it starts even before that. So any rule that we are going to implement, we can just use the applications as sort of an example, and what we did with that. It starts essentially with a draft that goes out to the public at large. We call it early stakeholder feedback, but it's really open to anybody that is able to see it. Our website has these are the proposed rules. This is the stage that they're in, and it's at that point that we put our first thoughts kind of out into the ether. And those are usually already pretty well baked. We sort of have to have a fulsome idea of what these rules are going to be, at least as they relate to the individual topics that they're talking about. So before we even put something out into the public for feedback, we need to have an overall structure of what this program is going to look like. So, in December, when this becomes an effective statute and hasn't been modified by the legislature, we began, here's how we're going to design the application process. That's the first thing through the gate. So we spent a month kind of putting together our thoughts on it. And in January, we put out into, the world, here's the application process, is what we're going to do and how we're going to approach it. And we take a couple of weeks to collect that feedback and then make modifications. Once those modifications are done, we have to send it to another entity. It's called the Common Sense Initiative. It's a part of the Lieutenant Governor's office, and their responsibility is to scan the regulations for any impacts that would be made on businesses. So if you write a regulation that says, there's a fee for having to apply, right? You need to justify that fee, right? We need to say, here's why we are doing that, to the Common Sense Initiative. The Common Sense Initiative will come back and say, here's some recommendations, or this package is cleared for approval, and then you can submit it into the JCAR process. So that whole process, even there's the early parts before you get to JCAR, can take 30, 60 days for any particular set of rules or any particular set that you have. And that's not even counting the complexity that goes into each crafting of all of these things. Whenever you update rules for structure or security or floor plans or layout or testing or any of these, it requires sort of a very wholesome approach, because our role is not to, do the industry favors and make things simpler. Our role is to protect the public and to make sure that they are taken into consideration what they're doing and what they are putting themselves into as well. So you got 30 to 60 days on the front end before it even gets to JCAR. And then once it's in JCAR, and JCAR is the Joint Committee on Agency Rules and Regulations. It's a joint committee within the legislature, the Ohio State House, that looks at any rules that are promoted and scans to see, all right, are they meeting the statutory purpose? Are they exceeding the statutory authority that has been granted to them? Are they sort of out over their skis on any of this? And once that process begins, it's a minimum of 75 days before any rules can take effect. So between the drafting, the CSI process, and JCAR, you already have nearly 4 or 5 months that is just built-in time that it takes to write any of these rules. So when we're able to roll things out in June, it really is we accelerated that process very quickly and got through those stages. With the rest of the rules that we need to go through, there's more complexity and more layers that are built in. So it takes a little bit more time to kind of get through those procedures. That's a design of the system that Ohio has. It's meant to ensure that regulations are not overly burdensome, that they're not impacting businesses, they're not adding on additional layers, or that they're not exceeding the statutory authority that is granted. If we were to write a rule that either didn't allow certain groups of people to make purchases, or like said, oh, 21 is what the statute says, but we're going to restrict it to people that are under 25, that would be shot down by JCAR saying you've exceeded your statutory authority. So we need to be really careful on those lines, because getting sent back from JCAR resets your cycle. It sends you all the way back to the beginning. So a lot of care, a lot of thought, and a lot of craft goes into all of those elements before we can promulgate the rules, because we don't want to get reset. We don't want to get sent back to the beginning on it.
I think that's a lot of good insight. Shalene, let me ask you, as a former regulator, when we're kind of thinking big picture so far, just about where we stand on the policy front, what we've done so far, what there's left to do. You and Pat both kind of referenced a little bit of frustration in terms of, where we're at now. It seems like, again, a lot's been done, but there's still a lot to do. Is it common for the process to take this long in other states? I guess the question is Ohio moving any slower than other states? Are we moving faster? Are we about on par with where others are at? Can you give us any insight to that?
It looks to me like it's moving faster. I know it may not feel that way for people in Ohio, but I think it's moving very fast and clearly thoughtfully. And I'd also add just that we all have a tendency to complain when we're watching these things, myself included. But it's really important to remember that, when you don't see something being sent back to JCAR, that's the way it's been explained, when you don't see lawsuits filed down the line, when you don't see recalls happening, the good regulation is really resulting in things that don't happen, and don't necessarily get acknowledged. So it's very important to recognize that, regardless of the speed. But that said, I think it's moving faster. But it's also important to note that I think this time early on, it's very common for people to obsess over the speed and the prices, because that's all you're seeing, and then the rate at which maybe new stores are opening or new dual use stores are opening. But down the line, those aren't necessarily the most important things for the long term. And so it's worth thinking, is it worth, if we save a few months right now, but we're excluding different communities, or we're making some kind of long-term bad decision, it's worth weighing those things.
Tom, I think I have a sense of maybe where you stand on this front in terms of where we're at today and where we're going, but from an industry perspective. And again, we're definitely going to come back to social equity. But how do industry operators feel about where we're at today? Are folks satisfied? Are folks frustrated because there's still some more rules to be put in place? I know I get a sense that a lot of people are so interested in rules for pre-roll products. They're interested, Andrew referenced this, but lightening some regulations in the advertising front. What's the industry perspective in terms of where we're at today? Are people pretty satisfied? Is there frustration? Maybe it's somewhere in the middle.
It's a great question, Jeremy. I think it's a relatively long answer. And as you know, I've got the Irish gift of gab. So I will try to sort of condense this a little bit. I think the industry is, they understand where we are at in the process, right? As Andrew mentioned, a year ago at this time, I thought we were looking at adult use sales starting at best in December of this year, right? We beat that by 4 months. So from the industry perspective, there's a lot of gratitude for the folks at the division, not just for sort of prioritizing from a timing perspective, tranches of rules, as opposed to saying we're going to wait and we're going to launch the whole program all at once when the cake's fully baked, when all of the rules are fully written. Like, the division got creative in how it implemented and launched adult use sales, and that creativity and the speed at which they did that. There's a lot of gratitude in the space, and I will say, speed to launch of adult use sales is itself a consumer safety benefit, because that means you now have alternatives to the illicit market, right? You have alternatives to going to the gas station to buy intoxicating hemp products. It means you don't have to drive up to Michigan. So launching adult use sales quickly gave a safer, more regulated, tested, and taxed alternative to some of those other avenues to buy cannabis products. Obviously, as with any business owner, you're right, they move at the speed of light. Policy takes a little bit longer. That's a feature, not a bug, of the rulemaking process, right? Administrative regulations have the force of law. And that means that once they're final, we have to comply with them. And everybody always wants the government to move really quickly when they're doing stuff that they like. But the second they do something they don't like, everybody freaks out and says, whoa, 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 you got to slow down. And that's why during these rulemaking processes, right, like you start with feedback, you go to, through this review process so that people have an opportunity to provide feedback and comments on these rules. And again, the division has been very receptive to those comments sort of throughout this process. So I think the industry is, obviously they want to move faster, but there's also a ton of optimism in the space right now. I'm out at a conference in Las Vegas right now. The Marijuana Business Conference is one of these big industry conferences. And you hear people from Colorado and California and Oregon and some of these other markets that are overly saturated, where they have not done as good a job to stand up a functional industry. And they have been saying to me, like, wow, you guys got to be thrilled with how things are going in Ohio. I mean, hearing us talk about the stuff that's going on in California, right, where taxes are too high, so they can't compete with the illicit market. People are going out of business. And when the market fails, that hurts everybody across the board. So I think deservedly, there's a lot of optimism from Ohio operators right now.
That's interesting that you're hearing from other folks who are saying, "Oh, wow, you must be pretty happy with where Ohio is." Is Ohio like maybe not putting words in your mouth, but is Ohio kind of a leader in terms of policy and the speed at which we're getting it together? It seems like maybe we are.
I certainly think so. I know Shalene commented, and obviously she has a much better idea from a timeline to launch than I do. But we did look at how long did some states take and how long did we take. There were a couple of states that launched an adult use program in 90 days, but they had a different framework than we had and how they launched that program and the avenues they had available to them. But you look at some other states, it took them a year or more before they had adult use sales begin. So Ohio is definitely a leader from an implementation standpoint. But then also, Ohio is not flyover country, right? We're the 7th largest state in the country by population. We're the 7th largest state by GDP. We have a robust economy. So it shouldn't really surprise anybody that our cannabis market will also be one of the top markets in the country as well.
So Kat, a question for you as we're looking at, moving forward, wearing your hat with the Drug Policy Alliance. What are your thoughts on, considering where we're at today and what we have left to do, what some of our priorities should be? And how do we sort of balance, the industry interests with kind of the broader public interest, with social equity and things of that sort?
Yeah, well, I think part of the challenge and really the opportunity that the state of Ohio has with implementing issue 2 is that, yes, regulators are tasked with standing up these first-time adult use markets, and that's a challenge in of itself. But the government has multiple responsibilities here, again, that extend far beyond the commercial market. And so I think that what I'd like to see the state of Ohio do is to continue to implement its cannabis program in ways that focus more on people and how people are impacted by the ongoing cannabis policies that exist. And I think that through the structure of the existing cannabis social equity and jobs program, there's infrastructure and foundation to do that particular work. The cannabis social equity and jobs program that exists in Ohio, I mentioned previously, there's supposed to be, I believe, 36% of the tax revenue that's been generated going to community reinvestment at large. And this community reinvestment fund essentially is not only funding technical assistance and financial assistance for folks to be able to participate in the market, but is also supposed to be funding things like addressing the social and economic impacts of cannabis criminalization and funding and studying things like expungement and criminal justice reform. And so I think that particularly now that we know that there are dollars rolling in, I'd be interested in seeing the state of Ohio prioritize and put together a plan for what the implementation of the cannabis social equity and jobs program will look like. And similarly, I don't expect the cannabis social equity and jobs program to be launched overnight. I know that these are things that take time, intention, and resources. And that's why I think it's important now for these things to start to be implemented and engaged in a transparent way so that stakeholders across the state of Ohio can begin to prepare and engage. There are folks all across the state of Ohio who are really interested in the implementation of these non-market pieces of criminal justice reform that were promised in issue 2. And I think that there's a real opportunity to start to seed these types of reforms through the cannabis tax revenues that have come in. I think I saw something a couple of weeks ago that said that the state of Ohio had raised close to $141 million in recreational sales to date. So there should be about $50 million already on the table to fund some of these community reinvestment measures. And I think that that's going to be particularly important. The other piece that I think is going to be important, I know that Ohio State University's Drug Enforcement and Policy Center has been doing a lot of excellent work in collecting and tracking data. I think that the state of Ohio has a role to do this as well. But there are lots of ways that cannabis policy will continue to impact Ohioans, whether it's understanding how cannabis policy impacts housing or employment or education or access to healthcare. And I think that these are issues that the state of Ohio should be prioritizing simultaneously as it's moving forward with its commercial market.
Andrew, I feel like this would be a good place to maybe put it to you. Andrew, could you give us a sense just of, what are the priorities at the regulatory level? We're obviously talking a lot here about kind of balancing the industry interests, kind of the broader public interests, criminal justice reform. Obviously, we're going to talk a little more about the social equity and jobs program. Can you give us a sense just how the regulatory body thinks about these priorities? Is one thing in front of another? And can you give us a sense of when we might see some traction with the social equity and jobs program?
I'll do my best. And one of the things I should mention, I'm a Division of Cannabis Control attorney, and as a result, the Department of Development has been tasked with the social equity program, the standing up of that program. I really don't want to speak. That's
a key point for sure.
That's something that I don't want to, either bind them in a particular way or sort of explain for them what's going on with those pieces. But I can do my best as far as the priorities that we're looking at. The first priority that we have kind of in the new year is the finalization of all of the adult use rules. Right now we have Rules Package 6 and Package 7 that are still working their way through the system. Rules Package 6 is on its way to CSI. Rules Package 7 is still in the early stakeholder feedback frame, and this is a large overhaul of the existing rules that are being operated under right now. So we are modifying or enhancing things when it comes to advertising, packaging and labeling, product registrations. We're trying to streamline some of those processes to make it easier for new products to find their way to the marketplace. And then we are also updating with a very large overhaul of the testing structure, the testing of cannabis. Again, there's some streamlines that are being implemented, but a lot of research has been done in the 5 or 7 years since the first rules packages were put together that says, no, there's this better way to conduct sampling to determine for potency. There's a more effective way to test for microbials or to test for heavy metals. So we're asking all of our testing labs to start getting up to speed on those two pieces. So our main priority is the finalization of those rules packages that sort of will build the program overall. After that, the next stage for us is going to be to start to implement other pieces of the statute that are under our control. One of those things is new licenses and whether or not new licenses are available. So the statute, the initiated statute, issue 2, put connected.
Yeah, you're still there. We lost you for just a second.
Okay. All right. I've snapped back. All right. I'm here. Hopefully you can all hear me. If somebody can't hear me, start raising hell. But the next stage for us is sort of the new licenses and what's going to happen with those. Issue 2 said that there's a 2-year stop on any new entrants to the marketplace, except for the 90 social equity licenses that are set aside. That's the only exception to these. So there are new license types that we're going to need to navigate and new pieces that we're going to have to put together. And that's sort of where a lot of our focus is going to go after we get the initial rules put together. And then the other side of it is it's the normal compliance behavior that you would expect from a regulator. Are there violations of either advertising or other rules that need to be addressed? Is there safety or health concerns related to these? Are there recalls that need to happen? Those types of things. So the normal regulatory drumbeat has to continue and has continued, since this has started. But those are kind of the main priorities that we have: is finalizing the rules, looking into what the new licenses will look like, where they need to go, and how they're going to be stood up. And then the last piece is making sure that we're sort of continuing the mission of compliance and regulation.
Is there a sense of when folks could start applying for those social equity licenses? I'm understanding where there's still some work to do there. Are we talking about the end of next year, middle of next year? Is it just we don't know enough to know?
It's really hard for me to say. In the contact we have had with the Department of Development, I know that they are trying to put pieces of this together and design what that program would look like, but I don't have enough information about the details of what that would be to know what their timing ideas are. That's something that you sort of have to connect with them and see where their heads are at on it.
No, I respect that. Julie, let me ask you this as a former regulator yourself, and with us focusing a bit on the social equity piece of this, let's talk a little bit about how we do this right. What are some of the key things to keep in mind when it comes to the social equity and jobs program? Because right now we have a mandate that some of the tax revenue towards standing this up, but I've seen some headlines myself about some of these programs just not going quite to plan in other markets. Right? I think there was a headline I just saw this past week about a gentleman in New York who was kind of the face of the social equity program, and now he's at risk of losing his business. What are some of the lessons to be learned or cues that Ohio should be taking when it comes to standing up the social equity and jobs program in particular? And maybe you can tie that in with some of the issues that we've seen in other markets.
Let me come back to New York. That's an important point. But thank you. That's a great question, Jeremy. So first, I want to just clarify for everyone that we're usually talking about 3 different things. And the DEPC has several excellent reports that break down social equity and point this out. But we're usually talking about criminal justice, community reinvestment, and then industry participation, which can be jobs, licenses, or entrepreneurship training. I think that the most difficult to implement has been the industry participation. And again, a lot of that has to do with timing, because if you let other companies, large companies, medical companies, national companies, dominate the market first, it becomes nearly impossible for disadvantaged people to benefit economically. So that's the first thing. If that has already happened, which happened in my state and appears to be happening in Ohio, there's still creative things you can do, but I would still emphasize timing is really of the essence. I'll give you an example. So in Massachusetts, we also ended up implementing phased regulations, which I think turned out to be the right thing. So we started with, similar to what Andrew pointed out, the licensing, the opening of sales, and then moved on through the consumer safety related portions. And then we save delivery and social consumption for later. When we decided to save it for later, we said that the social equity operators would get exclusive access to those licenses to make up for it, which sounds to me kind of similar to what was just laid out about how when the social equity or when the next licenses are approved, it will just be social equity. Okay, but here's what can go wrong, because what I just described was initially written in and passed as a draft by our commission in 2017. The social consumption, does anybody want to guess how many of those are open now? 0. And tomorrow, the commission is presenting the social consumption regulations that are very similar to what I wrote back in 2017. So when you don't have a sense of urgency, when you don't have deadlines, you can just completely lose track, no matter how much good intentions are put into exclusivity for social equity operators. So timing is everything. I would also say, I think we know at this point that just granting licenses doesn't do anything. Maybe early on when licenses were very limited, but now I think it's a good thing. They're generally, as a trend, easier to come by just the license itself. And ideally, you're going to have a competitive, thriving market. And so in that case, you want to make sure that social equity operators have more. From the industry participation perspective, you want to make sure that they have access to grants and loans. You want to make sure that they have business training, technical assistance, fee waivers, or at least fee reductions. And then most importantly, the tracking of the data, as Kat mentioned. So I've been very pleased to see that not only do you have the DEPC in Ohio, which is a huge advantage, but that there's also taxes being collected and funds being set aside for that tracking and tweaking of the social equity program. Because the one thing we know for sure is no matter how hard you try, you're going to need to listen to people and to tweak down the line. So that'd be my advice.
No, that's great input. And I feel like maybe just driving the point home on something you're saying, when we think about equity in this sense, it doesn't mean just making licenses available to, people from disadvantaged groups in the past. It's making sure that they have the resources and the backing to make it, right? You don't want to just give a license to somebody who might not have the experiences or the experience and the resources to make it work. And I think that that's probably some of what you're referencing too, in terms of making sure that we have the resources in place to make sure that these folks can excel in the future and they don't just get a license and run into trouble. Kat, do you have anything? I saw you nodding while Shalene was talking. Do you have any thoughts? I guess the original question for her was more about how do we do this right? Are there lessons to be learned from other states? Any thoughts on what Shalene said or anything like that?
I often nod when Shalene is talking, just for the record. But I think that there are a couple of things that I think Ohio can do really intentionally. One is actually making sure that there's accountability to make sure that those tax dollars go where they're supposed to go. That's critically important. It seems like there still may be some discretion with the Department of Development and the eligibility criteria that it creates, for example, to determine who actually is able to participate and apply for these 90 licenses that will be available. As I understand, there are supposed to be 40 cultivation licenses specifically and 50 retail licenses. So I think that making sure that folks are well aware of when these opportunities become available, that there are resources in advance of the application process becoming available. That's critically important. I think that in a lot of these jurisdictions, the application process is open and then the resources become available. But the reality is that people need assistance both before, during, and after the application process. Operators will likely need assistance once they're operational. And so I think that these equity programs really have to be designed to meet folks where they are and get them through the licensing process and allow them to be successful in operation. But there are some market dynamics by design that are going to make it difficult for equity and minority entrepreneurs to be successful in Ohio. One of these market dynamics in reality is the fact that the existing operators were granted, first access to participate in the market and will have a period of time in which there is no competition. I think another thing that's important for folks to recognize with Ohio's market, part of the reason why I was able to get up to speed so quickly is that it essentially allowed folks who had existing medical licenses to get those adult use licenses. But it didn't just do that. It allowed, and Tom, I know you're more of an expert on the specifics here, but it allowed existing operators to get more licenses. And so, as I understand, issue 2 allowed certain folks who only had one medical retail license to turn that one medical resale license into 3 retail licenses in the adult use market. And so Ohio has created a system where the haves are already going to have more before the have-nots have any. And that's just one example. Another example, talked about these cultivation licenses that are available. There are 40 cultivation licenses that are available for social equity applicants. So I understand the canopy cap or the limit on square footage for those particular social equity applicants is 500 square feet. Or maybe is it 5,000 square feet, Tom? Okay, 5,000 square feet. Well, the level 1 cultivators are existing operators who are allowed to have up to 25,000 square feet of cultivation. And so it's difficult for me sometimes to look at, and not just Ohio's program, but other programs, and say we should actually be calling this an equity program. If we're saying that equity entrepreneurs only get 5,000 square footage of cultivation space, where existing operators get 25,000, and just the ratio of retail licenses to for equity applicants to non-equity applicants. To be frank, folks are already entering into a market where other operators have advantage, and I think that has to be accounted for as well. And so I think that this is part of the reality as we have been in communication with folks who are building these programs and have designed these programs ourselves, to be frank and saying, this is not a lottery ticket. You are signing up to participate in a process that is and can be rife with challenges. And I think that the mandate with these equity programs is to really try and reduce barriers as they exist for operators as they're experiencing them.
Would mind jumping in there? Do you have any, I mean, as a big force behind issue 2 and, getting that social equity and jobs program sort of built into the law. Do you have any thoughts, on what Shalene or Kat were saying, and or just any thoughts on how Ohio does this right and how we can make it work?
Jeremy, you cut out at the beginning. Was that a question for me?
Yes, I'm sorry, Tom. I was asking if you would mind weighing in a little bit on just how we make the social equity and jobs program work. How do we make it successful?
Yeah, happy to address it. And I forget if it was Shalene or Kat who mentioned the sort of 4 core priorities, policy priorities of issue 2. And there's no doubt that social equity was certainly one of them. And, I also agree, look, equity is about both representation and also restoration, right? So it's both participation in the industry as well as funding these sort of important equity initiatives. And we tried to do that as much as we could under issue 2. Remember that issue 2 is a ballot initiative. So you can only do so much given Ohio's single subject rule and this sort of just political realities of running a ballot campaign like that in a statewide campaign. You can only be really so specific before the specificity becomes like a cudgel or a sword that gets used against you in a campaign. But let's talk, generally about the social equity program. And Andrew's 100% right. Right now, the ball is squarely in the court of the Department of Development. I haven't heard of where things stand over there. I know that Commerce and the Division of Cannabis Control has done what it can do as far as social equity licensing goes. They promulgated a rule that says, hey, look, as soon as Department of Development launches this program and can certify folks, we can start an application period. And they now have the legal authority to do that. That was one of the very first rules that the division put into place. So from a licensing standpoint, as soon as that program is up and running, those licenses, that application process will be able to kick off. On the funding piece, remember that the way that sales taxes in Ohio get collected, they're sort of distributed every quarter in arrears. So we just had the first quarter of sales in the adult use program. Money will just now start moving. The way it gets collected, there's a 10% tax at the point of sale, and it all goes into one bucket at the state. And then that bucket gets split up between, 36% to the social equity and jobs program, 25% to substance abuse addiction, 36% to the local host community fund, and then the remainder goes to the division. So those funds will just start being available for those purposes. Kat is absolutely right. Accountability is key here to make sure that the tax revenue is used in the way that it was intended under issue 2. And there are sort of broad parameters about how that money gets used. Investment in communities that have been disproportionately impacted by marijuana prohibition, right? Direct investment. It's a quote from the language, and that was an intentional clause in issue 2, direct investment into those communities, funding and studying criminal justice reform, bail reform, all of those important things, financial and technical assistance to social equity license applicants. The one thing that I've learned over the last several years, kind of working in this space, both during the campaign, but also, going through legislative fights, it seems like every year there's a new reform or corrections bill in our legislature to reform the marijuana industry. Policy is really hard. I think other people on this Zoom call kind of knew that way better than I did. And you constantly have to make kind of judgment calls and priorities. And so to me, speed to market was imperative because we wanted, again, to provide that alternative to the illicit market, but also so that we could start generating tax revenue to fund the sort of restorative aspect of the social equity program. What we didn't want, and what I don't think Ohio voters would have supported, candidly, would have been an initiative that says, hey, in 3 years, we're going to have an adult use program, but we got to do all this rulemaking, we got to get all these programs stood up, et cetera. We kind of had to take the world as we found it. And unfortunately, under the medical program, there really was not a social equity licensing framework. The Social Equity and Jobs Fund, while most of issue 2 builds off of an existing framework, that Social Equity and Jobs program is brand new. And so we didn't want to delay the launch of the program to build that aspect. There are provisions in issue 2 where the division has an enormous amount of discretion. Kat mentioned cultivation area caps. Those caps at the discretion of the superintendent of the Division of Cannabis Control can be lifted. So the goal here really is to have a social equity program where our social equity licensees can be competitive with existing operators. And I can tell you, like, the existing operators would be a little surprised to hear that there's not any competition in Ohio's market. Like, if you ask them, the goal is to ensure that all of the licensees can be competitive, can be successful, because you also have to, at the same time, where you want participation in the industry, you don't want oversaturation. The superintendent at the division, Jim Canepa, has said, before, we don't want to be like Michigan where there's a 19% failure rate, right? Like, it doesn't benefit anybody to have licensees closing their doors, going into receiverships, et cetera. So it's a balancing act. And it's going to take some time to kind of figure this out. But we absolutely need accountability. Totally agree. Social equity was a key component of issue 2. It's important that we know where that tax revenue is spent to make sure it's meeting the goals of the Social Equity and Jobs program and the statutory requirements. And it would be great to have, a round of social equity license applications, but unfortunately, we're kind of waiting on the Department of Development to launch that program and to certify participants so that the division can then go forward with its licensing process.
So maybe one more thing for you here. To what extent are there concerns for, you touched on this a little bit, to what extent are there concerns for lawmakers to change aspects of the adult use law now? I feel like we saw some, chatter in the State House about altering the law after issue 2 was passed. There seemed to be some interest in doing that earlier this year. That sort of seemed to fizzle out. The General Assembly obviously is going to conclude at the end of this year. So if there's anything that lawmakers wanted to put out there, we would imagine we'd see it early next year, right? Do you have any sense, Tom, of like what the appetite is in the State House to alter the law that's in place now, and what impacts we can maybe see from that?
Well, I stopped trying to predict what happens in the General Assembly a long time ago. But what I will say is that if you go back and look at a lot of the debate following the passage of issue 2, some of the proposals over this past spring, they largely centered around, oh my gosh, we have no idea how any of this stuff is going to work. Well, thankfully, the division now has rules in place, and we have a program that has been running for 4 months that has been relatively quiet from a compliance standpoint, right? The boogeymen have not showed up as we thought they never would. So we know how packaging is going to work, right? We know how advertising is going to work. We know testing is going to work. We know how preventing sales to kids is going to work. And so my suspicion is that those concerns are now kind of off the table, right? So to the extent we see any modifications to what voters passed, I think we're really talking tinkering around the edges. The cat's not going back in the bag. Ohio has a legal adult use program. That program is here to stick around. We'll see obviously what happens in the General Assembly, but I think the market is in a really good place. The division has a very stringent set of regulations with more on the way to synthesize both the medical and adult use programs together under one whole regulatory framework. And that makes it easier for policymakers to say, okay, you know what, it's actually working okay. And that's similar to, candidly, also what we see at the local level, right? With local moratoriums, when city councils and trustees pass these bans because oh my gosh, we don't know what this is going to look like. Well, then they go tour a facility, they see, how the regulations work. After a couple of months, they see that it's fine. And in fact, it's a net benefit in their communities. So it's all about education, and it's about teaching people and showing them that we know how to do this in Ohio. We know how to do it well. We know how to do it safely.
Julie, let me ask you, do you have any sense of, or maybe a better question is there much concern with sort of lawmakers tinkering with the law today? And I'd be curious too, as kind of a part 2 to that, with your experience as a regulator, if that happens in other states. Like we have something the voters approved, now we have politicians saying, okay, hold on, here's how I think we're going to reshape it. Do you have any sense of, like, is that anything that concerns you? Should we be worried about that? You have any thoughts on that?
I mean, I think it depends on your legislature. So I'd defer to, everyone based in Ohio to say what the concerns are. But in general, yes, it's very common. I should acknowledge too, earlier when I said that I thought the speed was faster, I didn't measure it or do any research. I was just answering based on vibes. I think Tom would even know better than me, but I'm glad that we have like the same impression of it. And that is because in a lot of states, if it passes in November, there's some tinkering that has to happen, or that usually does happen by the legislature. And so seeing sales by August was really quick. But at the same time, even if it does delay things, I think it's generally a good idea to have a representative government take a look. I know in Massachusetts, I was one of the authors of the original ballot initiative, and I totally welcomed the rewrite by our legislature. I think it helped a lot. They made our regulating agency independent. They added a lot more equity provisions, and then they changed it again. When we saw that municipalities were not acting right, they changed a lot of the accountability, and now they're probably going to change it even a third time. And I think that's generally a good thing. Could I talk about New York really quick? I wanted to mention that earlier.
Go ahead.
I saw that headline too that you asked about that said the face of something now his business isn't doing well. I've been amazed because New York is the only state where we did actually see a clear alternative to this problem I've been describing, where they let the larger operators move first. They were very intentional about not doing that. They did not let the existing medical operators go first. It did delay things a little bit. Not only did it delay things, we saw lawsuits like we've never seen before. We saw press, negative press, like a whole blitz, including articles like that, just to showcase New York as a failure. And then we saw political pressure causing the regulators to have staffing changes, people getting fired. All of that now in 2024, recent statistics show that 80% of the retailers in New York are independently owned by people with cannabis convictions. 45% of the businesses in New York are minority owned, 40% are women owned. Sorry, I got that backwards. 45% are women owned, 40% are minority owned. Just puts all the other states to shame. And so now I think, a few years ago when we were saying letting the larger operator go first doesn't work, now we can say doing the opposite does work.
Great points. And I don't know if this is one that you could touch on too much, but the extent to which the regulatory agency is sort of impacted by any changes the lawmakers could make. Is this anything that would, concerns you folks when it comes to promulgating rules? And I guess I ask that because we're talking a lot here about setting up these programs right, doing them as quickly as possible. I think one might imagine that if we do have lawmakers tinkering with the law that's in place, that maybe that just slows things down. Is this anything that tends to be of a concern to DCC, or you guys just have your focus elsewhere?
It's a great question. It really is. Because I think early on, especially between November of last year and December of last year, where the statute or the referendum had passed, but it actually hadn't become effective. We heard all sorts of ideas about what they're going to do, what they're going to fix, what they're going to change. And at that stage, I think we were a little bit worried, are we going to try to build something right now and then have it just like pulled out straight from under us? And that's always a little bit of a concern, but the way that we've approached this, and I think it's the only way that a regulator can, is we have to operate on the statute that's in front of us. And if the legislature comes in and changes a bunch of things on us, our job is to implement the statutes as they are written and as they are signed into law. And if that requires us to like restructure or redo things, we'll do that. But we didn't allow it to impact the way that we were building the program. Because, the conversations about what to change and how to do it extended all the way, even up to now, but all the way through, June, July, August, as we are putting these things together. A week before we launched applications, we heard, oh, well, they might change everything on you. And you can't allow that to be a focus or a way that you sort of implement it. Like, oh, if we only write it this way, or if we wait on this in particular, it might change. You sort of have to just keep driving forward. And I think that that's how we would approach this as well. Whether there's something that's done in the month of December or early next year that modifies things, we're going to continue to stick to the blueprint that we already have in front of us and continue to implement it as quickly and as efficiently as possible. If there are changes that come through the legislature, I think we'll have to explain, here's why we're shifting course. It's because this new statute came in and it overrode what we were trying to do. It put us back to the beginning, but we have to just stay on course with what we have in front of us. And I think we've tried to do a really good job of that because, Tom can tell you, I'm sure everybody knows, there's all the rumors that swirl around this. And as Tom said, you stop trying to predict what the legislature is going to do about any individual topic a long time ago. We really have to put the blinders on and just say, if it's given to us in this way, we are going to implement it in the way that it is written. And we're going to do the very best job with that we can. We're not going to allow the politics that swirl around it to impact the way that we're implementing the program, because the voters voted for this. This is what they gave to us, and we need to follow that as if it was anybody else.
I could just ask you, just pivoting a little bit, we've talked about a few specific things. We talked a lot about the social equity and jobs program, and to kind of pan out a little bit and think about 2025. Andrew touched a little bit on some of the rule packages that are in kind of working its way through the system now. Taking those into consideration or not, you give us just kind of a perspective from your end in terms of what some of the other priorities are from a regulatory front that maybe we haven't talked about. I think I mentioned the pre-rolls earlier. There, from an industry perspective, that's probably something that a lot of operators want, because I understand that that's like a third of the market in some other states. The advertising restrictions, maybe that's a concern. From an industry perspective, what are operators sort of looking for in the near term?
Yeah, we do hear pre-rolls, a pretty consistent drumbeat about we need to get pre-rolls, we need to have those up and running. And the unique part of Ohio's system is because there was a medical program first, there's a statutory ban on combustion as a method of administering marijuana in the medical program. That doesn't exist on the adult use side. So the way that we had framed it and what we've sort of tried to tell everybody is while we still are operating under the medical rules until the full rule packages are adopted, you're stuck with this sort of limitation, right? And that also extends, pre-rolls are sort of the normal thing that people want to talk about, but it also extends to other product categories as well. And one of the things that the initiated statute did was it raised the THC content cap for concentrates, moving them from 70% under the medical program to 90% under the adult use program. Those products are not available yet because the new rules haven't been adopted. The main thing for all of those is, rules package 6, which is on its way to CSI, has all of these concepts in it. Right, it's the next thing that's going to come through, and within a couple of months, I'm pretty certain that it will be implemented. As long as JCAR doesn't throw us off. And then the package that follows that is the testing package, the testing of all of these particular things. And for concentrates, there's not a whole.
I think maybe
testing, but when you are introducing a new, so we have to design a system around how we're safe, tested, meet the standards that are set, so that somebody that uses a product that is bought straight off the shelf doesn't end up with a bunch of contaminants in it as well, from a slightly different vector. So pre-rolls are on the way. They're
I'm tempted to joke that there's somebody really out there trying to make sure Ohio doesn't get pre-rolls, so Andrew gets cut off every time you start talking about it. But Jeremy, you're doing a great job keeping up with some.
I'm sorry.
Go ahead, Andrew. I'll let you finish up. I wanted to make sure everybody knew we had about 10 minutes left, so we get to some closing remarks and wrap things up with what's been a spectacular conversation so far.
Sure. I'll cut myself off to this. Pre-rolls are on the way. All the new product categories are on the way. They're in the next rules packages that are being finalized, and they should be implemented relatively soon thereafter. And that, that is the implementation of all the things that are listed in the initiated statute. That includes advertising. There's an update to the advertising rules. There's some updates that are going to be surrounding packaging and labeling that kind of go along with that. So you're going to see a lot of the, the reins that were put in sort of loosened a little bit, and there's going to be more freedom given to the operators because there's a distinction between the medical program and an adult use program.
Thank you very much for explaining all that. By way of maybe some final thoughts, maybe Kat, Jolene, and Tom, maybe we can go in that order. I'm just curious if you folks have any final thoughts or takeaways, for anyone who's paying attention to this, about what we should be expecting in the coming year, what you're hoping for in the coming year. Maybe a prediction about where you, or a wish of where you'd like Ohio to be by this time next year. Any of those things, you don't have to answer all that stuff, but just some things to consider by way of some final comments. Kat, you want to go first?
Sure, thanks, Jeremy. And I want to thank the Center for organizing this and hopefully continuing to put on educational meetings and things for the public to learn more about what's happening in Ohio. I think my hopes for Ohio's program is that it's implemented equitably, that we'll actually see the manifestation of the Cannabis Social Equity and Jobs Program. We can see dollars coming from cannabis tax revenue to fund criminal justice reform and to help get minority and equity entrepreneurs off the ground. I think the other piece of this is Ohio has an opportunity, because it's the 24th state, to learn from other jurisdictions as it moves forward with this program. And I think one of the most important lessons learned really is about just government accountability generally, making sure that there's transparency in the implementation of the program. And I guess part of what I'm also hopeful to see in Ohio are people in Ohio, community-based organizations in Ohio getting involved with the implementation so that we can make sure that there is accountability. I know, for example, with the Cannabis Social Equity and Jobs Program, there's supposed to be an advisory council. And so I think that there are lots of opportunities for folks who are interested in tracking and engaging with this issue, but there's a lot of opportunity for growth and improvement. And as a Buckeye myself, I'm very interested in making sure that Ohio continues to do this the right way.
Jolene, for you, any final thoughts, final takeaways, hopes for the coming year, predictions for where we might be at this time next year? What do you think?
I love Ohio in general and its place in cannabis. I think that there's a couple of really important historical roles that Ohio has played in cannabis. One being that Kat and I often get credit for being the first to implement equity programs, but Ohio was actually the first to try with the racial quota system with its medical program. And yes, it was struck down, but they deserve credit for trying first. And we learned a lot from that case. So they deserve credit there. Also, the people of Ohio really bucked a trend in 2015 by rejecting the ballot initiative that would create a monopoly. That just happened again in Florida, or an oligopoly. So I really appreciate both of those things. And I think that Ohio is going to be a leader now in implementation as well, especially when it comes to collecting data. And I'm really looking forward to seeing how research implements affects what happens here. Just a real quick, a prediction for the future. I think the era of legalization that started in the early 2000s is kind of the one characterized by a diverse group of industry and advocates and scholars all kind of coming together. I think it's ending, unfortunately. I think we're starting to see the beginning of a backlash. I think we really need to listen to people about how they're experiencing legalization and what needs to change. And I think Ohio could play an important role in that.
Thank you. Tom, how about you? Any final thoughts, key takeaways, hopes or predictions for the coming years? What do you think?
Yes, well, I'll give you a hope. I've said a lot of nice things about the government on this webinar. It's too much. So my hope in 2025 is that the feds get the hell out of the way on cannabis and let the states continue to lead on this issue, because that will also help drive a lot of the important considerations, to sort of raise all boats throughout the industry. So my hope and my wish for 2025 is that we actually see final, at least rescheduling of marijuana under federal law, if not, removal of marijuana from the list of controlled substances entirely, the enactment of something like the States Act, co-sponsored by Ohio's own Dave Joyce, or any of the other number of reform initiatives that have been presented at the federal level.
Andrew, the last one, and I'll refine it a little bit more for you if I could. As somebody, working in the regulatory side of things, how about a prediction on where we will be at this time next year, in whatever terms it makes sense for you? Maybe a sense of where we would be on the policy front, or something that you want to be able to say about the program at this time next year.
Sure. I think my hope for next year is that all of the new dispensary licenses we have, both the social equity and the ones that have sort of been through the licensing process already, are up and operational, right? They've gotten themselves into sites that they're happy with, and that we have, a lot more access that's available. One of the things that we talk about a lot in terms of combating the black market and allowing for opportunity is you need to have a lot of locations covered. That's one of the reasons why we implemented sort of 1 mile buffers around dispensaries and tried to push people out into the different spaces. So I'm hoping that all of the licenses that are available, both in the social equity and in the program as it is, are up and operational. We can see sort of what a fully saturated market looks like. Saturated isn't really the right word, but a sort of all of the licenses are operational at that particular time. So that would be my kind of hope. I think if we could see that by December of next year, I think that would have been a pretty successful year from our standpoint, if all of these pieces kind of coming together. Beyond that, I think, I'm really hopeful that my staff gets a little bit more sleep this year. We've been really burning the candle on both ends, and I really appreciate everybody. I mean, it's really nice to hear from the industry and from everybody that's outside saying we have a lot of empathy. We understand what you guys are going through, because a lot of times it doesn't feel that way. Like I said, there's always kind of this push to get things out the door and through. We burned a lot of hours, we put in a lot of time to get things where they are, and it's going to take a lot more when we get there. But if by December of next year things have sort of calmed down sufficiently that we don't need to continue taking comp time, I'll consider that a success.
Excellent. Doug, I'd flip it back to you after just saying thanks to the Drug Enforcement Policy Center for having us all on to chat today.
I appreciate that, and I want to say thanks to you, Jeremy, and to everybody involved in the webinar and all the attendees as well. I'll add to a year from now prediction is that I'll certainly want to make sure we do an event like this again to see where we are in another year, and I know all the folks involved here will help us make it a good year by some metric, if not necessarily every single one that everybody hopes to see happen. And again, just incredibly grateful for the work that you all are doing in all your spaces, and want to also encourage everybody attending to remember the Drug Enforcement and Policy Center is going to continue to try to do its work. Thanks for all the nice shout outs along the way. We're going to do what we can to both keep an eye on this and to deepen the discussion. I think, Had, you particularly mentioned that I think there's still a lot of misunderstanding both in the state and around the country. And Shalene, I especially think your point about kind of listening to folks in this space, not only is so important strategically, but what we hope we're able to do through the center and help channel the voices of many of you working here and all those in communities that care about these issues. So with that, thank you again very much for participating. I learned a lot. I trust everybody else did as well. And I hope I see all of you before this time next year. And please do reach out, both panelists and attendees, to folks at the center, because we're always eager to hear what issues you think are important, and we'll try to prioritize those that the community wants to hear more about and be part of that process. Thanks again. Appreciate it. Have a good year. All the holiday cheer and all that goes with it as well. And stay safe out there. And thanks again for participating. We'll call this a day.
Thanks again, everyone.
Thank you so much.
Thank you for attending Implementing Issue 2, Criminal Justice Reform After Marijuana Legalization. The event is hosted by the Drug Enforcement and Policy Center at the Ohio State University Moritz College of Law. Before we begin, we have just a few notes we'd like to share with you. First, we want to draw your attention to the Q&A function at the bottom of the Zoom window. The chat is disabled, but you may submit questions at any time. Please note, however, that there is typically limited time available for Q&A during the webinar. Second, automatic closed captioning has been enabled for the event. To change how you view the transcription or to hide it, we'll click Show Caption in the menu at the bottom of the Zoom window. Finally, this event is being recorded. The recording will be made available on our YouTube channel as soon as possible following the event. A link will be shared with all registrants via email as soon as it is available. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the discussion. Doug?
Thank you, Holly, and thanks to all of you joining us online, and thanks in advance to our panelists who are going to be talking about the, I think, evergreen issue of the relationship between marijuana reform and criminal justice reform. And introduce myself, I am Doug Berman, a professor here at the Ohio State University Moritz College of Law, and also the director of the Drug Enforcement and Policy Center. And in many respects, I started the center because I found this story of how marijuana reform will or will not end up impacting broader criminal justice reform movements so interesting and so challenging and so dynamic. And that's been something that our center has worked on in a variety of ways for a number of years. And at the same time, marijuana reform was coming to, in a sense, our back door. As some of you are probably familiar with, last November, Ohio voters enacted with a fairly significant yes vote, 57%, for cannabis legalization, full legalization in the state. We've had a legislatively created medical marijuana program for a number of years, but now we are a full adult use state. That law became effective in December. However, as the proponents of the initiative explained, they chose not to include any significant criminal justice reform in the initiative, even though a number of other states have included that in legislation or initiative efforts. They said concerned about a single subject rule problems. That's Ohio's law that says a law can only be on one subject. Debatable whether this is not obviously all part of one subject, thinking about legalization of what had been criminalized and doing broader reforms, but the concern was that it might not be viewed that way. And so as a result, we got enactment of a law, issue 2, that has, in a sense, some recommendations and some directives and some tax revenues devoted to looking at criminal justice issues, but not a tangible set of criminal justice reform proposals, notwithstanding that that's become a quite integral part of reform efforts. And here I want to flag a recent paper that very recent, literally just came out yesterday, that our center has done, particularly thanks to DEPC's Jan Hernova and Dexter Ridgway, where they've produced a paper that's called Mapping Cannabis Social Equity, Understanding How Ohio Compares to Other States' Post-Legalization Policies to Redress Past Harms. That paper looks at social equity issues in cannabis reform more broadly than just, and thanks to Holly for putting the link in the chat, that looks to social equity issues more broadly than just criminal justice reform, but record sealing, record relief, expungement, and a range of issues, resentencing connected to criminal justice reform have been also a really robust part of cannabis reform and regulation in recent years, and that's one part of their paper. And we thought it would be valuable to bring some experts together to talk about this story with some of the national landscape in place, but then also to really try to drill into the specifics in Ohio, both the potential for, the likelihood for getting some follow-up legislation that includes direct criminal justice reform, and some of the implementation challenges and issues that these efforts necessarily create. So with that background and sort of table setting, I want to introduce very quickly our 4 panelists. The way we talked about operationalizing our conversation is, after my introduction of all 4, I'll tap on one of them to do somewhere in the neighborhood of 5 to 8 minutes of opening remarks to discuss their perspective on these sets of issues, and then we'll follow up with some conversation. I'll have some questions. I believe that you can bring some questions into the Q&A that I'll try to integrate into our conversation, and I am very confident we'll all be more informed by the end, though I'm also very confident we won't have everything figured out for sure. So with that, let me introduce our 4 panelists who I'm grateful are joining us today. We have Adrian Roca, I'm introducing them in the order that they're going to speak, from the Last Prisoner Project. We have Daniel Dube from the Adams Project. We have Louis Tobin from the Ohio Prosecuting Attorneys Association, and we have Representative Juanita Brandt from the Ohio General Assembly. I gave just the very basic introduction of who's speaking because I hope they'll talk a little bit about their background and how they come at this issue of the intersection of cannabis, marijuana reform, and criminal justice reform as part of their opening remarks. And so with that, I now am going to tap Adrian from Last Prisoner Project. They'll also encourage all the panelists to turn their cameras on so that we can now get the opening remarks and then start a broader conversation. Thank you very much again, panelists, and Adrian, the floor is yours.
Well, thank you so much, Doug, for that introduction, and great appreciation to the Drug Enforcement Policy Center at the Ohio State, I believe I articulated that correctly, for inviting us to be a part of this panel today. As Doug mentioned, my name is Adrian Rocha. I'm the policy manager for the Last Prisoner Project. We're a national nonprofit that works specifically at the intersection of drug policy and criminal justice reform. So our lens has really been on emphasizing the idea of retroactive relief for individuals. So as a state legalizes, the concept should be that justice isn't merely achieved in building a marketplace for cannabis, but in undoing what has caused or what the harms that prohibition caused as part of that process. So I just want to provide a sort of general overview of how we approach this conversation and where Ohio fits in it. So to date, 24 states have enacted cannabis-specific record clearance laws as part of their legalization, and 10 states have enacted cannabis-specific resentencing laws. So we have a really great report that's available on our website that I'll plug here for folks to check out. The voters of Ohio actually made our report outdated by 2 months afterwards when they voted to legalize issue 2 on that. So apologies for that asterisk. We will update that. Importantly, these criminal justice policies have become incredibly more commonplace in recent legislation. In fact, since 2018, 100% of the 13 states that have legalized cannabis have included record clearance policies. And since 2021, they've all been state initiated. And I'm sure we'll spend some time on the concept of what state initiated resentence or record clearance means. While resentencing policies have been a little bit slower to take hold nationally, they're also growing in importance and recognition and have been included in at least half the legalization bills since 2020. That's all to say that Ohio is a bit of an outlier in that issue 2 did not contain either of these provisions for reasons that Doug mentioned, part of the single issue concept in the ballot initiative there. Nevertheless, anytime a state considers legalizing adult use cannabis, it represents a significant step in the right direction by ending these types of prohibition policies that have derailed countless lives for a plant that was once listed in the Sears Roebuck catalog. So what we really want to see is that any path towards legalization post issue 2 that seeks to build a new marketplace must also commit to dismantling the injustices perpetuated by prohibition policies. Ohio must ensure both that state-initiated record clearance and resentencing or individuals who are currently serving for cannabis-related sentences have an opportunity to see their sentences reconsidered in light of legalization. So in sum, I would really say that issue 2 has made prohibition a part of Ohio's past, but addressing the harms perpetuated that policy have not been corrected or ameliorated.
Thank you, Adrian, and very efficient. I appreciate that as well. So we'll have all that much more time for questions and follow up. But now we'll turn to Daniel Dew of the Adams Project.
Thank you so much. Thank you to DEPC for putting this on and talking about this really important issue. I'm with the Adams Project. Previously, I was with the Buckeye Institute. I chaired the Ohio State Bar Association's Criminal Justice Task Force. And at the Adams Project, we really look at criminal justice issues through a conservative lens, making sure that there's accountability, there's due process, that we're supporting law enforcement, and that there's rehabilitation. And obviously, this falls under the rehabilitation portion of our portfolio. And so Ohio actually has a pretty good history with record sealing as far as which offenses are eligible. Ever since I've been involved with working with Ohio legislators, there's been a real focus on how do we help these people? How do we get people back to work? If you look at recidivism, one of the best indicators of whether somebody's going to recidivate is if they have a job. We think about putting people on probation and things, but actually a job is the best probation you can get. It's something that people have to show up for regularly. They have to be in a condition to work. And so the record sealing is really about making sure that people aren't unfairly limited in job prospects, where they can live and such things. I remember years ago, a close friend of mine was just getting ready to graduate. He was getting a degree that would allow him to work in a power plant, and he was newly married. His wife was newly pregnant, and he came to me, pulled me aside with tears in his eyes, saying, "I just found out that I'm not going to be able to get a job because it turned out that he had a marijuana possession record from a few years before that." And luckily, I was able to work to help him out. We had a friend that had filed in courts before, and so we were able to figure it out and get his record sealed, and so he was able to get a job. But a lot of people aren't so lucky. So back in 2018, Ohio passed Senate Bill 66, which did a great job of expanding which offenses were eligible for record sealing. It made it so that more offenses could be sealed. As far as numbers of previous convictions, it set good timelines for so many years after the conviction that they were able to receive relief. And then in just this last session, there was Senate Bill 288 that again that was part of a larger criminal justice package, looking at record sealing, and eliminated some of even the higher limits that SB 66 had pushed for record sealing. So I think that Ohio is actually in a pretty good place with the number of records that are eligible for sealing, with what offenses and everything. The problem is it's a hard process to go through. When I was working with my friend, even though I was an attorney and had filed in different contexts, it took some real work to make sure that I used the magic words on our application, dotted our I's, crossed all of our T's to make it work. And so I think that's the real barrier here is how do we make this process easier for people so that they're not limited where they can work, where they can live, especially in light of the fact that Ohio no longer considers marijuana possession a crime.
Wonderful. Thank you, Daniel. I appreciate that. And, both you and Adrian have started to frame an issue that we'll certainly follow up on, which is, especially when we're focused on record relief, expungement, sealing, whichever term or remedy is being used, there's an eligibility question, who's eligible to get this relief, and then there's that process question, and then the practicality of, does the process enable folks to do it? And one fairly recent development in Ohio, and maybe Lou, don't want to force you to talk about this. I want you to talk about what you want to talk about, but Ohio has been trying out the idea of prosecutor initiated record sealing and expungement, which hadn't been available until a relatively recent bill. But even before that, my understanding of Ohio's process has always been that prosecutors would have an opportunity to weigh in on a record sealing application or the process regardless. And so, very grateful to have you here, Lou, to sort of talk about from a prosecutor's perspective, both the broader story in Ohio with respect to record relief processes, and then especially how we should be responding to the legalization of marijuana and its intersection with these issues. So without further ado, go ahead, Lou.
Thank you. And thanks to Professor Berman and the Ohio State Law School for including us in this conversation. Always appreciate being invited, and I think probably providing a bit of a counter point of view to some of the other panelists on here. And just so everybody knows a little bit about our association, we are a statewide association for county elected prosecutors in Ohio. All 88 elected county prosecutors are members of the association, and there are about 1,500 or so assistant prosecutors who are also considered ancillary members. We come at these issues obviously from a law enforcement perspective and a public safety perspective. And I think one of the things that I would push back on just a little bit immediately that Dan said, that we've decriminalized the possession of marijuana. We've decriminalized possession of small amounts of marijuana. The way that issue 2 operates, it basically creates a zone of immunity as long as you're engaged in certain behaviors that are outlined in the statutory language of issue 2. And that means you can possess up to 2.5 ounces of marijuana. People who fall outside that zone of immunity are still going to be in violation of Chapter 2925 and potentially subject to criminal drug possession charges and criminal drug trafficking charges. So, issue 2 didn't create some free market marijuana paradise in Ohio. It created a limited marketplace where people can buy, possess, and use small amounts of marijuana. I do agree with Dan that I think Ohio has already gone, quite frankly, from our perspective, I think has gone overboard in terms of what we allow for record sealing and record expungement. Record sealing and record expungement used to be relief for first and maybe second time offenders who had made mistakes and who deserved an opportunity for a second chance. And I think, quite frankly, we supported giving people second chances. Now, after Senate Bill 66 and Senate Bill 288, people can seal an unlimited number of misdemeanors, an unlimited number of felony 4 and felony 5 nonviolent, non-sex offense crimes. They can seal up to 2 felony 3 offenses. I haven't studied what other states have done. Maybe Dan or Adrian can comment on this more, but my sense is that Ohio probably already has one of the most liberal, if not the most liberal, record sealing, record expungement schemes in the United States. The issue that presents for prosecutors is that we have people who come back in front of us charged with new offenses. We know they've been there before. We know what they've been convicted of before, but now their records have been sealed. And, maybe a year later, they're going to have records of this new conviction sealed too. And so I think we've just gotten a little bit away from what the original policy goals of record sealing were, to provide people who had made a mistake with a second chance. The other thing I would push back on a little bit is this idea that we need more record sealing or sentencing relief because of issue 2. One of our current record sealing law allows people who are convicted of a minor misdemeanor to apply for record sealing and record expungement 6 months after the end of their sentence. So somebody who's convicted of possession of up to 2.5 ounces of marijuana is already going to be able to have their record sealed or expunged after 6 months. So I think the idea that we need to do something additional because of issue 2 is just not necessary. I don't want to take up too much more time, Doug, but you'd asked me to talk about some of the challenges for prosecutors because of issue 2. You want me to do that now, or?
Yeah, sure. We've got time, and certainly focus on the process, because I think that's exactly where whatever the lay of the land ends up being in response to issue 2, prosecutors are going to have a voice in general and a voice in individual cases, and curious or eager to hear your take on how it creates challenges potentially for your association.
Okay. Yeah, so I think that the challenges that prosecutors face because of issue 2 are the thing that's most important to us is the black market and keeping the black market under control. There are going to be problems with road safety and highway safety. This is more of a public health issue, but we're also concerned with underage use and accidental ingestion by children, and then just general drug interdiction efforts. And maybe Representative Brent might talk about what's going on in the legislature too, but they're kind of competing views right now between the House and the Senate about what they need to change as a result of issue 2, how much they need to change, and the urgency of that. The Senate has passed a series of changes that, quite frankly, I think we are largely supportive of. We think the Senate did a good job of kind of respecting the fact that voters voted to make it possible for people to possess, use, and purchase small amounts of marijuana. And I think some of these other ancillary issues in issue 2, I think while voters might have liked those things, I think at the end of the day, they were voting to legalize the possession of small amounts of marijuana. And so I think the Senate kind of did a good job of reeling in some of these ancillary issues in issue 2 while keeping the heart of the issue intact. The House, I think, has a little bit of a different view. I think they're more reluctant to make changes to what people voted on, and I think they don't feel quite the sense of urgency. I think just in terms of our primary concern, which is keeping the black market under control, we would agree with the Senate and the governor that there is more urgency here. I think we would like to see the House take action on something sooner rather than later. The black market, I think other states that have legalized marijuana have experienced a growth in the black market and a thriving black market. And really the driving forces behind that are, one, that the black market is always going to outprice a regulated market. I think there are going to be a lot of people who say, look, I can go to a dispensary and I can buy an ounce of marijuana for $100, or I can go to this guy I know down the street and I can buy an ounce of marijuana for $50, and they're going to go to the guy down the street. And it also just prevents huge problems for not only marijuana interdiction, but drug interdiction in general, because you've got, and in particular in issue 2, you're allowed to grow 6 plants if you're one adult. If you've got 2 adults in a household, you're allowed to grow up to 12 plants. You're allowed to transfer those plants. You're allowed to buy up to 2.5 ounces per day. So you can buy 2.5 ounces today, tomorrow, Friday, Saturday, and Sunday, and you can transfer those or stockpile those too. So those are just some of the things that we think need to be reeled in, because we want to respect what the voters did, but we have a responsibility to larger public safety as well.
Very good, Lou. I appreciate that, and thanks for expounding on a number of those points. And I'll actually quote for sort of a broader conversation in a minute some of the language from issue 2, and then the ongoing debate that surrounds both record sealing and then some broader issues related to criminal justice. But first, I want to make sure Representative Juanita Brent gets her chance to talk about what she's seeing and the work that she's doing in this context. We just heard from Lou Tobin about ongoing debate within the General Assembly. The Senate's already passed reforms. My understanding is not just you, but many members of the House aren't so keen on what has been suggested from the Senate, but I think that included at least some expungement provisions as well. And so it did hit on some of the topics we're focused on here. But my sense is you've really been a leader, Representative Brent, on a range of social equity issues, and have spoken out about how important it is to lean into these issues as the General Assembly considers its response to the passage of issue 2. And so with that background, eager to give you an opportunity to talk about the work that you're doing, and also perhaps giving us a little bit of a forecast of when we might expect the House to move forward on some of these fronts, because there's this ongoing debate in the state as well about not just what the reforms should be from the General Assembly, but what the pace needs to be. And so with that, thank you again for joining us and taking time to share your important perspective. And so the floor is now yours.
Okay. Thank you so much, Professor, and for the Ohio State University, for building a Zoom, this space of convenience that we can all be able to share and learn more about what adult use cannabis will be here. Well, what adult use cannabis is now and what it will be going on in the near future. For those who don't know, I'm originally born and raised right here in the Cleveland area, represent part of Cleveland in the northeast portion of the state. And the entire time I've been here in the General Assembly, I've introduced multiple bills that have been about expanding the use of cannabis. I have been a huge proponent because we cannot keep criminalizing a plant. And so I always want to start off with, that's where my stance set, that this is a plant. And at one time you could just see cannabis just being grown anywhere, like it would just grow. Hence the slang word of the word weed, because if weeds grow anywhere, same thing with cannabis, they just grow. And so we are at a place right now where issue 2 has passed, and the people have said that they agreed to the terms of that. Now, what most people don't realize is that because of that, some things have become completely legal. Like if somebody wanted to go outside and go smoke, you can go legally smoke, technically. There's no place to buy cannabis. There's no way to grow adult use cannabis. So people can only buy medical use. And I'm only saying that just to lay the foundation of certain things because some people don't even realize what's going on. What we're dealing with now is that even though the people have spoken with more than 50% of the votes of what the terms are, the General Assembly, which is what I belong to, the House and the Senate, is making these new rules on what they think is best for the people. And so what we have originally with House Bill 86, that bill actually started out as a liquor bill. It was a bill that I and many of my other colleagues voted for. When it got over to the Senate, it was like a bait and switch. You voted for a liquor bill when it came out of the House, it went over to the Senate, and then they added all these things for cannabis. Hence, you're seeing what's happening with House Bill 86, which has it doesn't have social equity. So even when we talk about criminal justice has to do also with social equity. It's rectifying some things that we have not really taken care of that, but it also includes expungement. So House Bill 86 includes expungement. The House version, which a lot of my colleagues on the House side contributed to, which is House Bill 354, which also includes social equity in expungement, and it also allows home grow. House Bill 86, which is the Senate version, does not allow home grow. And I'm going to bring it to a point why all of this has to do with criminal justice. First, when we talk about expungement, the details of how we do expungement is very important. Legal Aid made a wonderful pride that if we are going to be doing expungement, they need to be able to receive some of that money because there's going to be a surcharge of people who are going to need legal services to have their expungement taken care of. That is not addressed in House Bill 86. House Bill 86 does allow expungement, but it does not allocate money particularly to services such as legal aid within the state of Ohio. We have to address that. We also have to address how expungements are going to be done. So when we talk about expungement, is it going to have to go through a process where people are going to have to literally go to the courts, or is it going to be an automatic expungement? These are the type of questions that the General Assembly has to answer. We have to make sure that that people feel seen in a process of government, making sure that, and I personally am advocating as a state representative for automatic expungement, that people do not have to go through a rigid process of getting their things expunged because we want people into this new marketplace. Imagine being the neighborhood guy who's been selling cannabis your whole life. You know this plant like the back of your hand, and all of a sudden, because of prior crime, you're not able to be in this process. We need to get those people up and working. They are the subject matter experts in our community. If you knew somebody that was back in the day selling it, we need them up and working. We need them having their things expunged, but we do not need the systems to be a barrier. Also, when it comes to House Bill 354, it allows home grow. And the reason why this is so important that we discuss what happens with home grow, it was an issue too. And that was another key reason why we had so many younger people who were very pro issue too, because they wanted to be able to have home grow. House Bill 354 allows home grow. If that is not done in some form or fashion of home grow within the state of Ohio, you're going to be recriminalizing people for just something else. Because I do know for sure people are going to get the seeds they need in other parts and other states, and they're going to bring it to the state of Ohio. So instead of us trying to, stop this, we need to figure out how we can monopolize off of this new tax market within the state of Ohio and help people come up with healthy, safe ways to do home grow. And this is one thing I was telling somebody. My friends were telling me like, oh, I'm so excited about home grow. And then another lady at my church said she's scared about home grow because she's scared her neighbors are going to be doing home grow. I said, ma'am, how many people you know grow tomatoes? How many people you know grow potatoes? Everyone has access to seeds here, and we're an agriculture state, but you don't see every neighbor around you growing stuff. So I really doubt that it's going to be a surplus as many people as people think that's going to be growing cannabis. Because one thing we know is not easy. It's not easy to grow. So those are some of those pressing things that we are having to address. And it all has to do with the criminal justice system of making sure that people feel seen and that the process is working for the people. The moment we go against issue 2 as a General Assembly, all of us have a primary in March. And if we go against the people in the state of Ohio, I don't expect any of us to get reelected because we are not going for what the people want. And I know sometimes people feel like they know best when it comes to people, but the people who know best is the people who got me here elected. And the people who voted for that said that they want those type of provisions within that. Just wrapping up with my statement, we have to use issue 2 as the base, the foundation for what we do. We cannot do anything against what issue 2 is. And I will say within the House, we are being very respectful and mindful of what the people want. The people know best. So even if we feel like something else is different, and I don't always agree with everything, but the people know best. Every state House seat, every Senate seat, except for 2, passed issue 2. We have 99 House seats in the state of Ohio. Everyone except for 2 House seats passed it with more than 50% in their House district. So what does that say to us? That if we go against issue 2, we are going against the same people that elected us to office. My name is Juanita O'Brien. Thank you so much for letting me make these opening remarks.
Thank you so much, Juanita. Representative Brent, and I want to really focus a little bit for the time being, get us started with a real drill down into some of the record relief expungement issues that a number of you touched upon in our conversation, but that I think is perhaps particularly useful to kind of unpack a little bit more. And I'm going to sort of pose this question to you, Adrian, first, but then open it up to others to sort of speak to. Both because I think you probably have a sense of the national perspective, and especially with Representative Brent mentioning that she's advocating for automatic expungement, or what I think you call state-initiated expungement. And that's, I think, I know Lou Tobin's right to say that Ohio has fairly broad record relief provisions. I'm looking at the Collateral Consequences Resource Center's most recent 50-state comparison, and brag on their work because they really do incredible work on record relief and the consequences of convictions. And they have Ohio categorized among 17 states with broader felony and misdemeanor relief. But then you go to the states that have provided for automatic record sealing, and Ohio's not there. And there's only 9 states that have done that. A lot have done it in conjunction with marijuana reform. And so that's become kind of the leading edge of efforts to do automatic expungement, or what you call state initiated. I'd both kind of like you to speak to that vision, and where I sense that advocates are eager to push reform, particularly in the cannabis space after legalization, is to do automatic, and maybe even just explain what that means and how that functions. And I know on top of that, and I want to plug some more of our center's work, Yana Herdnova in particular produced a report a little less than a year ago called "Is Expanding Eligibility Enough? Improving Record Sealing Access and Transparency in Ohio Courts," that emphasized a topic that actually has been highlighted by research around the country and other states as well, that we have what's often called a low uptake rate, that even if you have broad eligibility, absent having some particular mechanisms to ensure people take advantage of these tools, a relatively often a very small percentage of folks actually benefit from having the possibility of their records sealed. And so my sense is automatic expungement, automatic record sealing has been an effort to address that. Can you speak about those trends generally, what you've seen in other states? And then I think the last question, it's a long question, I know, but hopefully everybody else is taking notes as well. Does that solve all the problems? I've heard stories. There was actually a recent commentary I saw that said it's one thing to automatically seal a record or expunge it, but people don't know that they've gotten this relief, or maybe they don't believe it. An awful lot of the challenge here is people don't trust the system. And so even if they get a notice, oh, your record's been expunged, maybe they still have to report or feel they have to report on a job application that they have this past conviction, so on and so forth. And so, not just the question of the move from petition-based automatic sealing efforts, but whether that's even enough to really have an impact with these kinds of reforms.
Yeah, I'm going to try and hit all those points in the most efficient way I can. I think you're setting up a really important distinction here, and I would agree with Lou in the work of Collateral Consequences Center that you actually decided that in terms of its peer states and nationally, Ohio does actually have some of the most robust access to eligibility in terms of who's actually able to seek an expungement or sealing, depending on the variations in state law in Ohio. But there's a very critical distinction between eligibility and relief. And we've seen multiple states, and this is true for Ohio as well, the uptake gap, as you said, Doug, right? As you increase in eligibility, it actually doesn't increase the amount of petitions that are filed oftentimes. So the key research on this is actually done from the University of Michigan in the state of Michigan, which analyzed of all the people who have met eligibility criteria, right? So this isn't only just the waiting period, right? So the amount of time that the person's been conviction free, you paid your fines, all those sorts of things. How many of those people actually get expungements? And we've seen in that research that it's less than 6.5% of individuals, right? So if you're increasing the funnel of individuals who might be eligible, it doesn't actually increase who gets through that funnel. And I think that's where automation, specifically state initiated, the concept being that the state has some sort of onus or responsibility to initiate that criteria for individuals, right? So conducting that first sort of step of are you eligible, and then granting that relief is really a great sort of leveler in that aspect, because it does actually ensure not only that that person's eligible, but they're getting relief. And so what we really want to see is the migration to a system where people aren't opting into, or specifically, where relief is mandatory as opposed to optional for individuals, and the notification becomes the problem. And we found ways to solve for this. One of the bills that we passed earlier in Last Prisoner Project is in 2021, we introduced AB 1706 in California. So California was one of the states that did do state-initiated expungement for individuals with cannabis offenses. What we did is augment that law to ensure that there's data transparency reporting requirements, and those are posted monthly on California's Department of Justice website. So you can track in real time how close each county is getting towards drawing down on the eligibility criteria. And we're seeing that eligibility pool narrows with every report as the state gets better about implementing this process. And the other thing about that is notification campaigns. So ensuring that government agencies have money to implement programs so that individuals and communities are aware of the fact that they've already gotten this relief, right? So the idea is that we're moving away from the concept that people might be eligible for a system that they don't even know about, to a system where they're already given that relief and they may not know about it, right? And that's really what we want to see with automatic expungements, tied with the idea of notification, so that an individual can confidently go into a job application or a housing application or applying for a Pell Grant and confidently check that box and say, no, I've never been convicted of a felony or a criminal record for cannabis. So there's a couple things I want to touch on specific to Ohio here, which is the updates made to the system in SB 288. I think there's a lot of great language in there, right? But there is still some language in there that would pose an undue burden for individuals who now have what I would consider outdated records, right? And so what we're really seeking in Ohio is parity for those individuals who have records who would no longer generate a criminal record moving forward. And there's some language about this in that bill, right? That low-level records for cannabis convictions, all that sort of stuff, should not generate a criminal record. that's a really great start. Although, as DEPC's works pointed out, there's not a lot of evidence about what the efficacy of a policy like that is. We do know expungements work. And so there's a way to already lean on systems that can already exist by connecting the thresholds that can be broken down by building an automated system to move around those processes. So I think that's one of the things that we'd really like to see in Ohio is cannabis convictions being that building block that can lend itself to a larger system to include other offenses that could also become eligible for a state-initiated system.
Thank you, Adrian. And I'll now turn to our Ohio experts and particularly open it up, but especially Daniel and Lou. Eager to hear your perspective on conversations about automatic sealing or expungement, given that Ohio has this non-unified court system. We have often struggled to statewide anything, let alone something that has a range of intricacies to it. We've seen in a number of other states that have automated record sealing and expungement. Not just the devil's in the detail, but it often requires a very significant investment of resources to kind of make it happen, especially if it's going to come with an information campaign. And so just love both of you to talk about, kind of what you see both as the possibility and the potential pitfalls of a move towards an automated process. And then Representative Brandt, I'll certainly, have you chime in because I'm sure you've thought about these things as you've been advocating for an automated process in this context.
I'll go first, Dan, and maybe you can follow up. But I've got serious concerns with the idea of automated record expungement and even state-initiated record expungement. We were not fans of the language that was included in Senate Bill 288 that created prosecutor-initiated expungement. And there are a couple of reasons for that. One, prosecutors simply do not have the resources or the time, quite frankly, to go sifting through old records to determine who's eligible for this and submit those applications to the court. Prosecutors statewide are dealing with, and these are just felony cases, almost 100,000 cases a year, I think we're up to. And we just do not have the staff and the resources to go sifting through those records, particularly if you're looking back over a certain amount of time to determine who should have their records expunged. Secondly, I think there's value in having people come forward and saying that they want their records expunged. We shouldn't require prosecutors and courts to use their time for people who might not care. I think we can make that easier for people. We can streamline it, but we want them to come forward and we want them to demonstrate that this is important enough to them for prosecutors and courts to use their time to expunge or to seal the records. Three, I have issues with automatic expungement because I think there's value to having hearings on these things. Judges are not infallible. I think prosecutors will tell you that even today, they have hearings on applications for sealing or expungement where the prosecutor will point out something in the person's background that indicates that they're not eligible to have that record expunged or sealed. You lose that if you do away with the hearing. And I think you're going to wind up with records that are expunged mistakenly. You could wind up with records where there was a victim expunged mistakenly. There are problems under Marcy's law regarding that. And so, there's just value to having a hearing and to having some of that stuff fleshed out in an open setting in court.
And I want to make one more plug, Dan, before I kick it to you, that for some research that our center has done last August, we released a report called Prosecutor-Initiated Relief in Ohio, a survey of prosecutorial plans to seal and expunge low-level controlled substance offenses. And it was basically an effort to figure out, as you were suggesting, Lou, whether prosecutors would be interested in the opportunity that Senate Bill 288 presented for them to initiate. And we found in a survey of local prosecutors that only about 12% of respondent prosecutors indicated they were going to pursue prosecuted or willing to pursue prosecutor-initiated sealing, and the explanation for why others weren't were largely commonly not having the staffing resources to do this, lacking of financial resources to do this, lacking the data needed to do it effectively, and then also believing the system that's in place for defendant-initiated sealing was sufficient. And so, just to put a little extra data on your commentary there, very much seems to reflect what our survey respondents said concerning why the prosecutor-initiated approach was unlikely to be used significantly. All right.
If I could just add one thing to that, Doug, before you go to Dan, only about half of my members, half of county prosecutors, even have misdemeanor jurisdiction. So a lot of these, in a lot of counties, that the prosecutor-initiated process would be handled by a municipal prosecutor who handles municipal cases there.
Yeah, so I'll just add a few thoughts. First, Ohio is not the only state without a unified court system that has moved to the clean slate model of legislation with automatic sealings. And I think that one of the ways that you could possibly do that is have set it up so that the Bureau of Criminal Investigations, BCI, within the Attorney General's office, could on a regular basis send to the courts those offenses that are eligible for sealing. As Lou noted, though, it will take additional time for prosecutors and judges, but that's not. I don't think that means that we shouldn't do it. If it takes more resources to get more Ohioans back to work, then that's something that the General Assembly should definitely look into. And I, whether there's value in people stepping forward, I think that's I think that's a good point that Lou has made. The problem is it's just so difficult to do. Like I said, I've done these before, and even as an attorney, it's something that I've got to spend time on and think about because it's not something that I do regularly. And so, I know that we're not talking about certificate of qualification for employment, but Ohio has this other program. The General Assembly is always trying to give these additional opportunities. And if you look at that program, so basically what it does is it creates an exemption for disqualification for occupational licensing. So even somebody with a criminal record can still get occupational licensing. It's a great program, but if you look at where it's utilized, it's around a few law schools in Ohio where they have student groups who are helping people with that. So they're great programs, and it's fantastic that we're doing that. But as Adrian noted, making sure that it's accessible to people is really important. And it's difficult to see how to do it in another way other than making the process automated in some way.
Thank you, Daniel. And Representative Brent, I'm sure you've given considerable thought to these issues. One point that was brought up in the Q&A that I wanted to just sort of flag is that there have been some private groups, Code for America, I think most notably, that have been actively involved in trying to help states deal with automatic expungement. I know they've done a lot of work in California. I don't know if that's a group you've interacted with at all, or whether in addition to hearing your take on advocating for automated processes here, what your sense of the role not just of government is, but of outside agencies. I'll throw in research universities and the like, because it does seem at times to be an all hands on deck type of endeavor. And so sort of with that, I'd like to give you a chance to talk more about your advocacy for the automatic process and your vision of how that can work in Ohio.
Thank you. I just want to clarify some things for those who are hearing terminology being put out. One particular thing is when you talk about Marsy's Law, particularly Marsy's Law is dealing with the victim's right to be present and heard. We're talking about cannabis convictions that are talking about dealing with a plant. Talking about a victim and a plant is two different things. If you're selling something, if that's for a different charge, then that's totally different. So I'm not a lawyer. Lou is, he's a prosecutor. So I'm not trying to undercut him, but we're talking about cannabis convictions. If there's a situation when it comes to a victim, then that's a different type of crime from my understanding. Lou, get me together if that's not the case. Don't get me together right now because I'm not done talking and I let you talk. So that's one. So particularly when it comes to Marcy Law. If that's the case, then that should be present. Those are those exceptions. Those are always exceptions. There's always exceptions to people who have to deal with situations of getting things expunged or sealed within their situation. Also, too, when our prosecutor also talked about his support of House Bill 86, which is the Senate version of adult use cannabis, a lot of that money that's being put for taxes in particular are going for law enforcement training. If we know we need more staff hire, more help when it comes to our prosecutor's office to do expungement, then our money needs to be reallocated to help with our process for our prosecutors to make sure we can have more expungement. If this is what the people want, then we need to adjust where the money is going to give people what they want. And the people say that they want expungement. People say that they want all of those type of things. People want government to be accessible and to be easy. To have people to take off of work, use the bus system, which we don't properly fund, because in the nation, we are 45th in the nation when it comes to funding public transportation. So you're expecting people to get to court off of a bus system that's not even being properly funded within our state. So that's one thing, because I don't hear anybody advocating for public transit, but you want people to have to physically go into court. Two, particularly when it comes to all of that, we are dealing with people who already have a current conviction from a job. They probably working like an hourly job or some type of job where it's going to be hard to get off, and we don't have automatic access to people having paid time off just to go to court. There are states that are allowing people to do it. If you have to go to court, you automatically get the time to be able to do that. Ohio's not one of them. So that's already those different type of barriers that people are dealing with here within the state of Ohio just to get access to go to court. I mean, it's not easy. And let's not even talk about the unaffordable childcare that you might have to take your child into childcare. And we as a state have not addressed childcare when it comes to all of that. All of those things come as a barrier when it comes to people just getting to court. Two, House Bill 86, which the prosecutor is championing for, is not giving money to our legal aid. If somebody's going to court, they're going to need a lawyer. You're going to need some type of legal representation because other things may come up. You don't know how to get through the process. How can we work for the people? It's always an excuse on what we can't do. But what we can do is reallocate this money and make sure that people have access to it instead of giving all this money to police training. It blows my mind, particularly how much money they want to put towards police training within the state, particularly for House Bill 86, which came out of the Senate. to me, it's ridiculous. People have told us time and time again when issue 2 was passed what they want. All we're doing right now is going against the people's will. And I don't know how to, Lou, were you elected? Yes or no? Were you elected to office? No. So you weren't elected to office. I was elected to office. So I'm not about to go against the people, the state of Ohio. And it's easy for somebody to come up with rules when they were not elected by the people who put this in place. And that's for issue 2. We have to stand by the voters in the state of Ohio. Hold on, Lou. I see you getting etchy. And I let you talk. You interrupted Dan. You're not going to interrupt me. So you're going to wait. Thank you. So also, there's a value of people coming in that care. Anybody that's been convicted, you can't tell me somebody does not care about their conviction. It's almost like a slap in the face to say that people don't care because they received a conviction within itself, and the value of having hearings. Like you said, our courtrooms are already inundated with a lot of court cases. It's hard to even get a basic traffic stop ticket because you got to wait because of what's going on within our communities. Now you want to add on something more to these convictions when our judges are already telling you they're inundated with all types of trials, court cases. Our local public defenders are swamped, so are our prosecutors. Give them the money so they can be able to get this done. Let's allocate, Lou, let's work on this. You and I are going to work on this because I'm going to follow up with you. We're going to work on allocating this money in House Bill 354 because y'all weren't trying to do that in House Bill 86 with the Senate. We're going to work on making sure the money goes to support the necessary staff we need to have so this can get done. If it's a staffing issue and we need money, we need more people, to allocate some money so we can hire some people. It's a lot of young people who are, done with they pass the bar and they need a job at the prosecutor's office. They're in their first year after they pass the bar. Let's hire those people so we can get it done. Let's not make excuses. Let's make goals and make decisions to take care of Ohio's people. I'm done, Lou.
Okay. Well, first of all, I 100% would love to work with you on that, Representative Brent. Just a couple of things. My point about victims is only this, is that, sometimes a marijuana conviction is tied to some other sort of conviction. It could be tied to child endangerment, to domestic violence, to some type of assault. And what I don't want is for a judge to mistakenly expunge a marijuana conviction and these other convictions that are tied to the marijuana conviction behind closed doors. I want that to be done in open court where any issues can be brought out. But in terms of funding for prosecutors' offices, one of the things that I have asked for that the Senate did not include in House Bill 86 is help for prosecutors' offices just in general staffing needs. We desperately need money for victims advocates programs in prosecutors' offices. We desperately need money to help us hire assistant prosecutors. So to the extent we can work together on that, Representative Brent, I'm 100% on board.
Now, what I'm support for real quick, thank you, Professor, is giving money to things that's not related to cannabis. So I know people get real excited because they like it's new money. I'm treating this like it's old money. If we get taxes off of anything else, we're not using it for everything underneath the stars. If we have to use money towards legal aid with our prosecutor's office to help people and everything else, we need to intentionally make sure all of this money is going towards cannabis and cannabis alone, not helping victims of other things, which, hey, I've been in that situation myself. We do need more people in that space. But we need to first make sure that we are addressing what we are starting with, and that's adult use cannabis and everything that is involved with that too. So thank you.
And so thank both of you, very respectful and engaged dialogue, which is exactly what we welcome and want to make sure we do here. And in fact, that conversation, especially about funding, I think is a perfect bridge to the sort of somewhat broader question I want to engage, that I want to stay kind of leaning on the criminal justice piece. But I think particularly Representative Brent, a lot of your earlier comments kind of highlighted how challenging it can be, and even Lou, some of your comments as well, to sort of segregate the criminal justice side from the everything else about regulations and everything else that we're doing in the cannabis space. They necessarily fold into each other and overlap. And against that backdrop, I want to remind folks, and this is currently the law in the state of Ohio, and one of the commenters highlighted that we're dealing with the text of issue 2 in part because the General Assembly wasn't able to move forward with reforms as this was in front of them for more than a year. And as the will of the people has been suggesting affinity for cannabis reforms, ultimately we get this written proposal that's the only thing that voters can vote on, and they vote in favor. A big part of that proposal involved the allocation of tax revenue, specifically more than a third of the expected funding to the Social Equity and Jobs Fund. And though, again, I don't want to talk about, though it certainly is worthy of discussion, the full range of social equity issues that necessarily engages, I want to read the exact language of what I see as sort of the main criminal justice piece of the instructions for the allocation of those resources. Specifically, it says, study and fund judicial and criminal justice reform, including bail, parole, sentencing reform, expungement and sealings of records, which we focused on, legal aid, and community policing related to marijuana. And to me, I was struck when I first read that language in issue 2 as a proposal. It seems to cover the entire criminal justice system, right? We're not just talking about how to deal with past records. It's looking at something that we have seen, an array of areas where even once you've legalized cannabis, you may have a judge at sentencing saying, I'm not going to let you use cannabis on community release, or that bail or parole might be impacted by a past conviction, even one that might be subject to some kind of record relief. The legal aid part, of course, funding for the lawyers to be involved in this kind of work can be so essential. And I'll, at the risk of being a broken record, plug another study that we've done at the Drug Enforcement and Policy Center. We estimated, the tax revenue that would likely flow from adult use legalization with just the tax rates that were set in the initiative, and our numbers came up once all the stores are up and running to a conservative estimate of $250 million per year. A third of that would be a pretty darn significant amount. There are other things listed as priorities to spend that money on as part of the Social Equity and Jobs Fund. But I guess I would just sort of like to hear from any and everybody, what other aspects of criminal justice reform related to cannabis. And again, maybe it's funding to prosecutors. I don't see that on the list, Lou. I'm sorry, but nevertheless, it might rightly be part of. It does actually say study and fund judicial and criminal justice reform. Certainly, our non-unified court system could use some resources in a variety of ways. And so I guess maybe I'll frame it this way. I've come to you with the bank full and the checks blank, but we have to devote it to something that's consistent with this language of judicial and criminal justice reform, including bail, parole, sentencing reform, expungement, legal aid, and community policing related to marijuana. Where are you going to use those dollars? Where do you think we may have gaps, either in Ohio or, Adrian, if you want to speak to this sort of nationwide, that we're underfunding or just failing to pay attention to in the cannabis reform space, that this kind of expansive language might give us an opportunity to look at and address? And I actually have a little bit of an answer to that as well, but I'll save that for the end until others jump in.
Sure, I think I'll start there, and I think it's an acknowledgement of where Ohio enters the conversation in this already, right? So as you said, the language in issue 2 says to study and fund these things. The reality is that there are 24 states that have already studied and funded these things and have empirical data about how well these sort of criminal justice and criminal legal reforms are working in conjunction with legalization. So there are lessons to be learned for Ohio in those specific examples. And I think Lou actually acknowledged, at least tacitly, one of the ways that cannabis sort of ripples through the criminal legal system, right? Which is that it is often the seed that allows the carceral system to sprout up around individuals. So in the example that you brought up a little bit earlier, right, is an individual who has cannabis that also gets ensnared with a child endangerment size. Part of what we do at LPP is actually represent constituents who are going through the legal system. And this is the thing that we see commonly, which is why we push for sentence modification, which is inherently involving sort of judicial discretion to make those sorts of decisions on individuals, because we can see how a cannabis, what starts off as a sort of simple cannabis conviction can ripple and really affect an individual's life because it's compounded by additional charges that get onto them. So I'll just briefly say this happened to one of our constituents in a different state who had cannabis in their house, but it was within the or it was in a school zone area. So then the child endangerment hit, all sorts of things. And so those were where we actually do believe judicial discretion should play a role, because it's the only way to untangle sort of all the ways that these layers stack on top of one another. So that's one thing right there. I do think that there are other lessons that can be learned from this, especially in a non-unified court system. As Daniel said, states have been able to do this in non-unified ways, especially around cannabis. Illinois is one of the states that does not have a unified court system that has been able to actually implement a state-initiated process for specifically cannabis records, and that's resulted in about 700,000 convictions cleared. The other way to think about this is, yes, it's going to take revenue to generate these sorts of systems that provide the relief incorporated in state-initiated sentences. They also generate revenue for states. Empirical data from recent studies demonstrate that after 5 years from getting record clearance, individuals are less likely to recidivate and they're more likely to be employed. This was actually one of the main reasons that Utah became the second state to actually adopt automatic record clearance, because the Chamber of Commerce saw it for what it is, which is an economic development engine for individuals to actually re-enter the workforce or go back to college to earn that advanced degree that allows them to make more money and contribute more taxes to society. So there are ways to implement these programs that are not only compatible with public safety, they're actually implementing and encouraging greater returns on investment for individuals who actually enact these. And then the last thing I'll say really quickly is to invoke the national dialogue, and what that might mean for Ohio, as Doug said, is there are other sort of tangential reforms that necessarily involve cannabis or other drugs that should also be on the table. And so one of the things that we're seeing at the national level is the conversation around rescheduling cannabis to Schedule 3, right? That's where it is, and we've written extensively about how we can do this. And I think one thing that should be considered on the table, or at least two things that should be on the table for Ohio, is technical violations for individuals who are on parole probation. We've seen other states that have legalized cannabis actually tackle this and say, if you have a valid medical license, perhaps you should not be recidivated on parole or probation if you're using it within the confines of legal law. So that's one thing I would consider. Two, as states are sort of gearing up to initialize a legalized market, especially over a long duration of time, I would encourage the state of Ohio to enact laws that protect individuals who are stuck in the gray market. So you have individuals who are entrepreneurial and want to get into the marketplace as soon as possible. They are starting to stock products so that on day one of launch, they are actually able to meet consumer demands. They are in violation of the law, as we said, right? Every state that has legalized cannabis maintains penalties for cannabis. And sometimes you might unintentionally break that law by making sure that your product is stocked for consumers to use. And you are now over the legal limit of what's considered a felony possession of individuals. So I would encourage the state of Ohio to consider protections for those individuals that so long as you have a license to operate as a potential distributor in the state of Ohio, you are exempted from those unintentional penalties as they're happening in production or in ramp up to legalization market.
Other thoughts about broader criminal justice?
Yeah, I can go. I think that the unified court system is so important. It's something that would be so useful for all the things that we do in the criminal justice system. Professor Berman, as you know, it's hard to get data on criminal justice issues, and it's because we have 88 different counties and they're using 20 some odd different systems, and it's actually a public safety problem, because you can have somebody who is out on bail or on probation in one county, and they get picked up by police in another county. And because our systems don't talk to each other, they may not know that this person has a warrant out for their arrest somewhere else. We just don't talk to each other. And then when we're talking about changing the criminal justice system, we're going off the best guesses that we can make, and we're going off of anecdotes, which is not great. Go to any hearing at the State House where they're talking about particularly increasing penalties, and you'll hear this really horrific story, which is terrible. And so we try to increase these penalties based off of that one story, but we don't really talk about how it was the subject of a plea bargain and the person did get out sooner than they probably should have, and things like that. But we're not able to collect all the data to understand which communities these policies are impacting the most, or which crimes are being committed, how are they being charged differently and sentenced differently in different communities, and what is the outcome of that. And so I think that just for everything that we do, getting a unified court system and data collection is so important.
I just want to piggyback on that really quickly. So Daniel's absolutely right. And I think that's the opportunity that cannabis presents to Ohio. I guarantee you there's a cannabis charge in all of 88 counties of Ohio. It is a through line that's going to be consistent through all data points across the system. So what would it look like to then leverage that system to build these unified court systems and then expand on it so that you do have access to these more robust data sets? So one thing I'll say very quickly is that in our implementation work with other states, what we've learned, and I understand, is that agencies are concerned with compliance. Give me the law, and how do I make sure to check all those boxes to ensure that we are compliant with the law? They're not necessarily focused on ensuring greatest eligibility or making sure that individuals actually take use of that. That's one of the things that automatic record clearance could actually improve. And what we're doing is simplifying that process by following the through line that cannabis creates across all those 88 counties to say, where is that data actually existing and it's just in a silo? And how do we build those connections to have a unified roadmap that draws towards the common goal of making sure that individuals not only are eligible for the relief, but they're gaining that relief?
I'll just say, if you came to me with this pot of money and asked me what I could spend it on, I'm not sure that what I would spend it on falls directly within the guidelines of what was in issue 2. I do like the idea of spending money on law enforcement training. I think we can all agree that we want well-trained law enforcement in the state of Ohio. I think this is a great opportunity to use some of those tax dollars to make sure that we've got the best trained law enforcement in the state of Ohio. Obviously, I do like the idea of providing some funding to prosecutors' offices to hire staff. There's going to be increased responsibilities placed on what are already understaffed prosecutors' offices across the state of Ohio. And the last thing that I would plug, and this is kind of a niche issue, but it goes back to my concerns about an expanding black market, is that we've got a bunch of canines in the state of Ohio now that are trained to hit on marijuana, and some of them might be able to be retrained. There's a little bit of a dispute right now about the viability of the canines that are already trained on marijuana and whether they can continue to be useful without being retrained. I think they need retrained, or that we're going to need new canines across the state of Ohio. And marijuana, some amount of marijuana is legal, fine, but we still want to conduct successful drug interdiction efforts on other drugs, marijuana or heroin, cocaine, certainly fentanyl, and we're going to have to fund new canines across the state of Ohio to do that. I would like to see a portion of the tax dollars for marijuana go to buy new canines.
Well, I will not be the one that tries to undercut a Jobs for Dogs program. So, it sounds good to me. Go ahead, Representative Brand. I don't know if you want to speak to that. You actually get to decide where money goes, or at least with your colleagues get to do that. So maybe speak to this, and then I tease the idea that I have a thought. Daniel kind of got me started on that, but go ahead, and then I'll chime in, and then we'll have time for some final comments.
Thank you. So one thing, and I was just listening to everyone, and I was taking down notes and making sure we have to take in the data as we are going through this process. I know one of the questions that came in the chat about how we expand this is about the difference between having a unified court system and not having a unified court system. I think we are a big state that's big on local control. The moment you start talking about unified court systems, you take away the possibility of local control, and then everything goes up to a higher system of who the judges have to, kind of like what they call the administrative judge. There will be a different form of what an administrative judge will look like. You will have a state form of it. And depending on how you feel about our states, you may or may not like having a unified court system, or you may like it when it comes to us particularly having an easier process to do expungement. So that's a bigger question about having a unified court system or not. I don't think talking about cannabis is the time to determine if we want to become a unified court system. So it's not to take away from the questions that are in the chat right now, but I think that's a bigger question that I don't think Ohio is ready to have. If you ever want to see a fight, talk about the court system. You'll see a fight right there if we're going to do that or not. But data is a necessity. And so, but even when you do data, it takes money to collect data. It takes money to keep the data, to have the resources to also make sure there's a report. Anytime there's a report that's sent out with data, it has to go to the General Assembly as well as to the governor. Who's going to put out the report? You got to pay somebody. You need money for that. So all of these things cost dollars. Also, particularly when it comes to, police training. I'm still trying to figure out where does that come into all of this. I know House Bill 86, which is a bill I would have not voted for if it came over to the House. It's giving, $80 million for jail construction. I'm confused on that. Also giving $15 million for a drug task force. I mean, it's if we know cannabis is being legalized. I mean, so some of these things when it comes to just what House Bill 86 in particular wants to do for the tax revenue is stuff that I'm kind of almost cringing on. There's some good things in there. It's $15 million in there for marijuana expungement. But to talk also just to get away from the tax revenue for a hot second, to talk about our canines, yes, we are going to have a problem here within the state of Ohio. We have 298 dogs that will need to be replaced because of issues 2's passing. Don't ask me how I know. Shout out to Representative Brennan, who has a bill that's about to be coming out. And it's going to take us about $6 million to replace all these dogs. It's $15,000 to $20,000 to replace one canine here within the state of Ohio. So we have to come up with a plan because a lot of our municipalities will not be able to sustain that cost if they only have one dog within their unit or 2 dogs. That's a hard hit on our local municipalities. So since we know we're going to have about $200 million, having money for canines should also be part of this tax revenue for this new booming side of things going forward, since there are going to be municipalities that are going to be losing a dog. So between that and actually trying to grow the necessary amount of dogs, 298 dogs is a lot of dogs that we need within the next year to help replace all the dogs that are going to have to be retired within the state. And that is about $6 million total on the low end, just like we need at least $6 million for that to occur here within the state of Ohio. We have to address that. That has not been addressed within House Bill 86 or House Bill 354. And that wasn't addressed either with issue 2 about that direct money for canines. But we know when one cause, it causes another effect within that too. Also too, and it keeps on coming out with the statement of the black market. For one, I hate for us to even bring that up when we say the black market, because it's always going to exist. There are people right now who are secretly selling their tomatoes. There's people who are secretly selling their corn. So, and I know we're talking about cannabis and somebody's like, why does she keep on bringing about other produce? Because there's always going to be a black market for something. Those people are going to exist regardless if the government has it perfectly set up or not, and it's going to expand. And there's been a market, and I'm just going to say there's been an illegal market of this going on for decades. But the ones who've been disproportionately been affected by that have been people of color within our state. So how do we help our state deal with that, about giving back to the communities who have lost tax bases of people who've been convicted by crimes? That's what we have to really be concerned about within our criminal justice system as it expands. So one of the things, and I talked about this at my press conference of Cannabis for the People, is making sure that communities that have lost a tax base of people who've been convicted by cannabis crimes are being poured back into. And so I would say, no, if you look at House Bill 86 or House Bill 354, neither one of those bills address that, about communities that have been disproportionately affected by loss of tax revenue because of people who receive cannabis convictions. And that's how you have to look at it. If your community has 100 people, the next person's community has 100 people, but the people in my community have had 25 people who have all been convicted of a cannabis crime and have had to go serve time, that's a lack of tax dollars that we have lost within our community. We need some money to pour back into those communities that disproportionately lost tax revenue because of the people who have committed those actions. So we got to figure out how can we make a full circle of all of that.
Thank you so much, Representative Brand. That's a perfect way for me to jump in with to note the fact that the current language in Ohio law, because of issue 2, also calls for the Job and Equities Fund to study and propose policy reforms to address the social and economic impacts of the enforcement of marijuana laws, exactly what you were sort of talking about in terms of the economic impact. And yet, as you mentioned, and as I think has been discussed throughout, collecting data, doing this analysis is not cheap. And I say this with my own bias. I teased it before. I think Ohio is often somewhat teased as always being good at being the 20th something state to do something. You know, we're pretty good followers. We're not always at the last, but we're rarely at the beginning. But I do think when it comes to data collection around cannabis and cannabis related topics, we're at a moment where we really could be leaders, because especially in the criminal justice realm, now I'm on my high horse. You know, we have some decent but not great data on arrests. We have almost no data on convictions. We have no data on sentences. We have no data on the intersection between cannabis arrests and other offenses, convictions, so on. The case processing that cannabis has been a part of for so long, not only with respect to other drugs, but other crimes. Another topic that I saw came up in the chat was, you know, how are clearance rates impacted with police no longer needing to arrest for cannabis offenses, but then, you know, having other responsibilities and challenges in this space. All really important topics that is why we could have gone another 5 or 6 hours for sure on this, but we are already out of time. And I hope all of you felt as though you got to speak your piece and get those first thoughts out there. This is recorded, and we will be cleaning up the transcript to post it on the Drug Enforcement and Policy Center website in the coming days. And I just hope all the participants will do a virtual clap to thank our panelists for sharing their wisdom here. I also hope we can have all of you back, whether it's, you know, after the General Assembly doesn't pass something or does pass something in this space. There's going to be more to talk about. And so, again, incredibly grateful for your time and energy and insight today. And thanks everybody for participating in the panel and listening in. I'm going to call us closed, only 2 minutes over time. And again, I look forward to just saying see you later rather than goodbye.
Thank you for attending Implementing Issue 2, Ohio Dives into Adult Use Marijuana. The event is hosted by the Drug Enforcement and Policy Center at The Ohio State University Lawrence College of Law. Before we begin, we have a few notes that we'd like to share with you. First, we want to draw your attention to the Q&A function at the bottom of the Zoom window. The chat is disabled, but you may submit questions at any time. Please note, however, that there is limited time available for Q&A during the webinar. Second, automatic closed captioning has been enabled for this event. To change how you view the transcription or to hide it, click Show Caption in the menu at the bottom of your Zoom window. Finally, this event is being recorded. The recording will be made available on our YouTube channel as soon as possible following the event. A link will be shared with all registrants via email as soon as it is available. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the discussion. Doug?
Thank you so much, Holly, and thanks to everybody at the Drug Enforcement and Policy Center for helping us coordinate this webinar. Incredibly excited to have a chance to speak with 3 really informed panelists to provide an set of insights and perspectives on how Issue 2, which was the ballot initiative that was passed by voters here in Ohio by a 57% positive vote to legalize recreational use, adult use cannabis in the state, how that's going, how it's being implemented. It seems like a long time ago, but it really wasn't that long ago, just 8 months ago, when the voters put the implementation on the front burner with passage. And we've had months of rulemaking. There's been lots of folks, probably particularly some here listening in on how the Department of Cannabis Control within the Department of Commerce, Division of Cannabis Control, has been putting together the rules. We're now at the state where we have a number of provisional licenses for adult use industry players to move forward, but they're just provisional. We're still waiting for the official start of sales in the state, but every indication suggests they're very close. And so it seemed like to us at the Drug Enforcement and Policy Center, where we've been tracking the law and developments in this area very closely, to talk to some thoughtful folks with different perspectives, both on how we got here and where we may be going. And so I'm going to very briefly introduce our 3 panelists. They can hopefully turn on their camera for a moment, and then have each of them give kind of a not quite opening statement, but a little discussion of their perspectives, and then we're going to get into questions. And before I do the introductions, I want to remind everybody, as Holly mentioned, you can use the Q&A to bring up some questions. I'll try my best as a moderator to kind of channel some of those and direct to the panelists some of the questions that come in that way. I've got a list of about a dozen questions already as well, so there's lots to cover. I'm sure we can't cover it all, but I'm incredibly grateful for our panelists. And so let me get to them. I'll introduce them very briefly. They can say more about their background and focus in this space. First, we have Thomas Herron. He's a partner and the cannabis practice chair at Franz Ward. I also believe your official title was spokesperson for Issue 2. Among other things, you can tell me whether we still call it Issue 2 now that we're kind of at this stage, but he's going to talk about some of his experiences and vision of how this is moving forward. Then we're going to turn to Megan Henry. She's a reporter for the Ohio Capitol Journal, is doing terrific work, kind of following and tracking how implementation is going, and excited to hear her take on where we are and where we may be headed in the state. And then last but certainly not least, Shalene Title, who's a distinguished cannabis policy practitioner in residence for us here at the Drug Enforcement and Policy Center at The Ohio State University. She's also the founder and director of the Parabola Center for Law and Policy that works in this space. And so she's going to help give us something of a national perspective as well on where Ohio sort of fits into the broader landscape of cannabis reform that is ever ever dynamic. And so with that, Tom, I'll start with you, and you helped get issue 2 passed by the voters. How are you assessing where we are, how we got here, and where we're headed now, 8 months after the vote?
So first, let me just say thank you, Professor Berman, and to the Drug Enforcement Policy Center for having me here today and for putting on this webinar. I'm very encouraged by where we are at in the process right now. If you had asked me 12 months ago, and I think people were asking me 12 months ago, and what I said is we should expect to have first sales in October, November, December of 2024. So we are several months ahead of schedule. I know everybody always wants things to happen faster than they're happening, but I think people need to appreciate all of the hard work that the Division of Cannabis Control has been engaging in for the last several months. I mean, they're working tirelessly to implement the initiated statute. We're months ahead of schedule. We have licenses rolling out for dual use licensure at existing locations. Right now, you can track the issuance of the new dispensary licenses and the new sites that are being approved in real time by the Division of Cannabis Control. I didn't think that would happen at the earliest until September 7th. Under the initiated statute. So I'm very happy with where we're at in the process. I think we're ahead of schedule. The division has been really thoughtful about consumer safety, both from a timing perspective, right? It's a matter of consumer safety to provide access to consumers so they don't have to go to the illicit market or they don't have to go to the gas stations to buy products. But they're also focused on consumer safety from an overall operational and security and process regulation standpoint as well. These licenses that will be opening up here in a matter of weeks will operate under the existing medical marijuana regulatory framework. So we will have, we're only weeks away from having tested, taxed, and regulated adult use products here in Ohio.
And I'll do one follow-up before turning to Megan, and this may be a little bit too flattering, or at least frames my own understanding, especially because I had the good fortune to have you come and speak to some of my classes in the past about your work kind of on the campaign and in this space. And you never struck me as a big government guy, and yet here you are saying how all these regulations are going great, and we should all be sort of excited about how this is all working out. Now, part of that, I assume, is a function of the fact that the model that you helped speak for and that the voters passed sort of stays in place. That there haven't been, though there have been many proposals to change the regulatory structure. Is it that wow, it worked out that the regulatory structure that was in the initiative just was so pitch perfect that it's all worked out terrifically? Is it just that there's been buy-in by the regulators here in Ohio? I think certainly I get that sense that unlike in some other states where a voter initiative then meets some resistance internally from the rulemakers, that there's been much more of a, I don't know if it's a collaboration or just a sense of we should move this forward as quickly as we can. But just speak a little bit to why you think this is going so well, and if that's as likely to continue once we get past the sort of preparation stage and into the actual sales and industry development.
Yeah, believe me, nobody's more surprised than I am that I'm saying nice things about regulators. I kind of cut my teeth not just criticizing them, but suing them all the time. And but one of the best parts about the initiated statute is that we built on an existing regulatory framework, right? We had regulators who knew how to issue licenses, who knew how to roll out programs, who knew how to craft these regulations based on operations that we've had here for the last 6 or 7 years. So that certainly helps with a quick rollout to the program. But also, like, the staff at the division, from the leadership on down, from Superintendent Canepa all the way down, the legal team, the licensing team, the regulatory, the inspectors, we really have had buy-in from a standpoint of getting licenses up and running, being thoughtful about the process that this has rolled out. I talk to folks at the division just about every day. They are working their tails off to implement this program. And so much of it is behind the scenes that, like, whenever I see reports about why is it taking so long, like, even I cringe because I know what is on their plate and how much they are doing and how quickly and tirelessly they are working. So I think the answer to your question, Professor, is it's sort of all of the above. I think that the structure of the initiated statute helped with this quick rollout. But again, from the superintendent on down, everybody at the division has been really working hard, since December or January.
Thank you so much. Well, Megan, not all sunshine and roses, but my sense is, a positive perspective on things as they've been developing. And I know you've been reporting effectively, on a variety of issues in this space. Is that everybody's perspective? Boy, this is just going great. Or do you see some other kind of views about, what's working well, what's not working well, what folks are concerned about, both, kind of at the industry level and the regulated players, but also, maybe would-be consumers or, folks in the medical industry already and medical patients? Love to hear your perspective on kind of where we are and where you think we're headed.
Yes, Wes. Well, first off, thank you so much for having me on the panel. Looking forward to the conversation this afternoon. And yes, definitely, as Tom was saying, ahead of schedule. when the issue 2 passed last November, yes, we were hearing reports that it would be well into 2024 until sales would take place. So it does seem to be ahead of schedule. Now, earlier this year, we were reporting that sales might happen in June. June is come and gone. You have to have that first sale of adult use. So that's still the $1 million question of when the sales will start, although we are getting very close, it seems. There was a push back in December, which I'm sure we'll get into more throughout this discussion with lawmakers trying to tweak what was passed to try to expedite the start of sales and have them begin sooner rather than later. But that would have changed some of how the tax rates and the home grow and the THC levels would all be affected. That was basically, it's gridlocked in the state house, and it doesn't seem like that was moving anywhere at this point. So there have been some attempts to try to quicken the sales. Yes, consumers very excited. There's been quite an appetite for the adult sales to start. So I think that has definitely helped speed up things. And like Tom was saying, with having the medical marijuana program already in place and having dispensaries and cultivators already in Ohio also helps, I think, as well, just with getting this up to speed quicker than expected initially.
And I assume this is more of a question for the regulators than it is for you, Megan, but I'm wondering if you're finding anything out at this point while we're at this stage. Is there an effort, as maybe some of the slowdown, a hope that the statewide sales could happen, sort of at the same time, so that instead of it being a handful of dispensaries that are up and running, and Tom, you may know something about this as well, and a concern that lots of people would flock to, a handful of the dispensaries that are the first ones to get their official certificates of operation. Instead, they're sort of doing groundwork now to make it possible that there'll be, a wider set of stores that are open and that there's enough product. I know some other states, maybe Shalene, you'll talk to this, some other states have had shortages early on. And so is it your sense that part of what's hopefully going on for the better is an effort to continue a smooth rollout?
Yes, my sense is when talking to the Division of Cannabis Control so far is they have said that there's not going to be necessarily like one day where a bunch of stores or all the stores are open at once for the adult use sales. It's going to be some kind of here and there. I'm not sure how many it will be at a time. It could be a handful, could just be 1 or 2. So it's kind of a wait and see, but it sounds like there won't be, so far what I'm hearing at least, and that could change, of course, is it'll just kind of happen gradually as the certificates of operation are rolled out, which could lead to a shortage potentially, like you were mentioning. So it's kind of also something we'll just kind of wait and see with that, but more to report on.
Absolutely. And Shalene, I'm going to turn to you now because you had experience as a regulator in Massachusetts as that state was sort of seeking to get these dynamics in line effectively. And I won't make you speak to what went well or what went poorly in Massachusetts, but very eager to get your kind of view of what do you think Ohio is doing well? What's your sense? It does seem like from a national perspective, it's a fairly quick timeline, but is that kind of the wrong way to look at it now because we have such a mature kind of universe of experiences that it shouldn't be surprising that Commerce and other regulators could kind of get their act together somewhat faster because they're not inventing the wheel or even needing to reinvent the wheel, both because in Ohio we were building off the medical program, but also because so many other states have sort of navigated this space.
Right. Well, first of all, thanks for having me here. I always appreciate how credible and interesting and thoughtful everyone that the DEPC includes is. And when there's something big that happens like rescheduling, like the 2 sources I look at are Congressional Research Service and DEPC. So I'll be back here in 2 weeks watching. So I want to echo the, I guess, encouragement not to focus so strongly on when sales will start. I know that is natural. I know when I was a regulator, that's all anybody wanted to talk about. But it's harmful, actually. I will say in 2021, after my term ended, I wrote a paper on social equity with the DPC. And one of the first things I said was the unreasonableness of the timelines that we put on regulators gets translated into shortcuts. And those shortcuts tend to favor the better resourced operators and set back social equity efforts. After that, there was a report that came out that I often cite that Virginia did. There was a group of Black activists in Virginia that pushed their government to put together a report to look at how long would it actually take to set up a fair and equitable market. And so to their credit, they partnered with the RAND Corporation, did an excellent report. And that report suggested that if Virginia wanted to set up a fair market, it should license gradually over 3 to 5 years. And to be very clear, they did not mean medical operators immediately and social equity in 5 years. They were pointing out that that's how long it takes to set up an equitable market. And I think anyone who's been a regulator would agree with that. And so especially a few years out and having watched this process roll out in so many other states, is just becoming clearer and clearer. It's like 100 years were spent under prohibition, and now we're making decisions that another 100 years will have a gigantic impact on consumers, safety, workers, and equity. And so the thing to be focusing on is in between. Is it 1 year? Is it 8 months? Is it 6 months? Is it 12 months? It's perverse to be focusing on that and not the long-term impacts. And so I think that if we can focus, this is what we tell. So I run Parabola Center, as Doug mentioned. This is a group of women of color attorneys who have been through this process and are trying to advise people to get involved primarily in the federal legalization discussion, but also in newer states. And the first piece of advice we give them is, please do not let medical operators start first, even though that is how you are very likely being pressured to do, because you're going to end up with a first mover advantage that hurts equity that you may never be able to make up. And I experienced that in Massachusetts. Many other states have experienced it. And sure enough, my understanding is, even though we're trying to address it in some ways, that's what we're doing in Ohio as well. So we're kind of starting from behind already. That's my biggest criticism. But I think now, if we could at least take the pressure off the timeline, that's probably the best way. And I'll join Tom's cringe prevention efforts by saying, when you talk about this program, don't ask when do sales start, ask more substantive questions about consumer safety and the market structure that's being set up for the long term.
Those are such great themes, Shalene, and I want to, in fact, I'm going to make sure we spend a good bit of time talking on social equity more generally, because I suspect Tom, who was involved in moving issue 2 forward, is interested in addressing the social equity and jobs piece of the initiative that voters passed that seemed to be an important part and that doesn't seem to have kind of gotten out of the starting gates yet. And before we get to that, though, and it's really because, even as somebody who follows this field, I sometimes struggle to figure out, well, what are they doing there in commerce? Like, what takes so long? Why is this so complicated? Why is this so hard? And I guess I'll start with you, Tom, and then I'll come back to Shalene and Megan. If you want to jump in, please do. Like, can you just even talk about some of the intricacies of the rules? And, to the extent you might want to speak to Shalene's concern that prioritizing the medical providers, already start shaping the industry in certain ways, and that we're likely to see that, whatever follow-up we might see. But I also assume it was partially a function of the fact that those folks have dealt with a lot of these rules and these intricacies. And I think you may better than I could even prime it to say, what are some of the little nuts and bolts, whether it's for the consumer benefit, whether it's for workers' benefits, whether it's for the industry as a whole, that it's so important, as Shalene's emphasizing, that we focus on like making sure the regulatory space in the industry is moving forward in a positive way, rather than worrying so much about, do sales start on August 1st or September 1st or even, October or November 1st?
Yeah, so I'll give 2 sort of concrete examples of sort of behind the scenes or tricky things that, it seems to me the division has had to deal with over the last couple of months. When you are licensing an existing dispensary to sell for both medical and adult use purposes, here in Ohio, we have, since the inception of the program, had a seed to sale inventory tracking system set up. The state has contracted with a third-party service provider known as Metric to help track all of those sales from the time a plant is grown at a cultivator and it's either 12 inches in height or the stem splits. It gets tagged with an RFID tag, and that plant is tracked through the entire cultivation process to being a processed product ultimately sold at a dispensary. In addition to that, every medical sale is also tracked through the prescription monitoring system. And so the state had to invest significant resources making sure that Metric worked with the prescription monitoring system, which also worked with the operator's internal inventory tracking program. Well, now you're going to have a situation where that dispensary is selling the same products to a medical consumer and to an adult use consumer. And so you have to make sure that Metric works and the inventory tracking system works to track those sales independent of who they're sold to. That's a lot of back-end stuff that you have to navigate. And that takes time because you've got, hundreds of licensees with their own different point of sale systems, with their own processes. And so even that can be a big problem that the division has had to work through. The second example I'll give, which I know the DEPC has spent a lot of time talking about, are local moratoriums. There's a process under Revised Code Chapter 3780, the adult use section of the code enacted as part of Issue 2, that lays out a process if a locality wants to enact a moratorium when they have existing dispensaries. Well, when you're issuing all of these licenses, those moratoriums impact how those licensees can operate, how they can operate, whether the municipality will acknowledge or agree with what the statute says or how it should be interpreted. So there really are just logistical issues that operators and the regulators have to deal with. There's a different process it's under Chapter 3780 of the Revised Code that deals with employee licensing, because in the medical program, every employee has to get background checked and separately badged by the division. So there's a different process in the adult use market. Again, if you're working at the same facility, How do you merge those two licensing frameworks? At the same time, when the Department of Commerce was also taking over regulatory authority from the Board of Pharmacy over dispensaries. And the Board of Pharmacy had its own employee licensing framework. So there have been a lot of hurdles that the division has had to overcome, and they have overcome them over the last 6 or 7 months that, yeah, to your point, Professor, like the general public doesn't see because they're not in the nitty gritty of the licensing process.
That was all very, very helpful. And maybe, and thank you for the plug for the work we've done at the Drug Enforcement and Policy Center, just trying to track which localities have imposed moratoria. And Megan, maybe you want to speak if you've done any reporting on that or have a sense of how that's unfolded. But Tom, just clarify my understanding, even if a locality imposes a moratorium, the existing businesses can stay operational. It's just they can't expand and take advantage of other opportunities that issue 2 provided for a recreational use approach, whereas in other places where there weren't existing businesses, a moratorium may mean something else. And so even in the space of a local moratorium, what's been going on there in the past, and then of course, presumably these localities can change the rules midstream or after the fact. And so I myself have occasionally sat down and tried to map this out literally and figuratively, and it's just, it gets very complicated very quickly.
Yes, so the process that's contemplated under Chapter 3780 of the revised code, and I won't get too far into the weeds, it effectively says if you're an existing dispensary and the locality wants to impose a moratorium on adult use sales, you have the opportunity to put that issue before voters. And during the pendency of that referendum process, you do get to open to service the adult use market. Some localities have pushed back on that. And so there are a lot of disputes in pockets throughout the state about what exactly the statute means, how exactly does it work. But certainly the intent was the voters voted for adult use sales, and the voters, we think should get what they voted for. And there's a process laid out under Chapter 3780 where if you're an existing dispensary, even if that locality imposed a moratorium back in February, you still are able to open. And if they pass it again after you get licensed, then you have an opportunity to put the issue before voters.
Thank you, Tom and Megan. I don't know if you've been covering, this issue closely. Again, we've been lucky to have researchers at the Drug Enforcement Policy Center tracking, and you can find on our website our latest report of just what localities have imposed some form of moratoria. But does that add to the complication, Megan, of even sort of following what's happening out there and the ability to sort of, tell people and tell readers about, just what they can expect in their town, in their county, and throughout the state going forward?
Yeah, definitely. I think that can play a role in it. I mean, it's such a fluid thing, and it's confusing. It's not super straightforward, as Tom explains. I think that can cause some confusion with citizens as to what exactly is allowed in my community, in my municipality. So it looks like there are nearly 60 across the state, and really kind of all over the map of Ohio, it looks like. But yeah, I think just some of the because there are so many layers to it and hoops to kind of jump through, I think that kind of can add to some of the confusion for just regular Ohioans.
Absolutely. So, Shalene, I'm going to turn to you, especially because I'm going to start leading us into the social equity story. Is there I don't want to quite say a silver lining because every locality has to figure out what it cares about, but if moratoria are, slowing the process down, making this be a kind of more deliberative, and maybe there's a locality that's eager to, see, what the rules are going to be for the state, how other regions are going to end up implementing and what the market looks like. Does that give a locality even more kind of opportunity to do equity if that's what they're committed to? Again, I don't get a sense based on the pattern of the local moratoria that they're driven by equity concerns, but is there at least a sense, or has your experience working in Massachusetts or elsewhere, that having more local control can be a good end towards moving the industry in the directions that you think are important? Or is this necessarily, going to have to be a statewide story? And then we'll get back to Tom to talk about what he thought the statewide story was supposed to be with issue 2 for the Social Equity and Jobs Fund, but just kind of your take on local control and where it fits into some of these broader issues.
Yeah, well, I mean, I think the question of whether it's a good thing will depend on what the municipalities in Ohio want to do and whether that time is used effectively. I think that I've spoken about this, that I thought the biggest mistake in Massachusetts after letting the medical operators go first was that local control, there's too much of it because they had to essentially get licensed at both the local and state level, but also just that the localities didn't have enough guidance from the state or from the statute. And so they ended up, given that, we have city councilors who just don't have time. They're not thinking about this 24 hours a day like the rest of us are. They have to kind of listen to whoever's coming, giving them ordinances, giving them language, and then giving them, PowerPoints of like fancy facilities they might have in other states. And so that's how you end up with cities that license larger operators, and they don't have the resources to give the smaller operators what they need to succeed. So what I would suggest is if there is some time that's being built in now because of local moratoriums or other reasons, that the state puts together guidance And really, a model ordinance would be ideal. It took us 5 years in Massachusetts, but we finally passed a law that requires municipalities to be equitable in the same way that the state is required to, and then require the agency to give them a model ordinance. And then finally, and perhaps most importantly, to review the agreements between the business and the locality, because before we were seeing a lot of bribery hidden in those contracts.
Yeah, we could do an whole other hour on the challenge the local officials face and the way in which those challenges map out into sometimes less than ideal behavior. I'll put it that way. But that maybe is actually a very good segue to give Tom a chance to talk about both his understanding of the provisions of issue 2 that were about the Social Equity and Jobs Fund and the way he thought that was going to operate. And I've certainly gotten a sense, and there's some questions in the Q&A that kind of, that seems to be a piece that hasn't been addressed, or at least isn't as fundamental to what's been going on to date. Love to have you just sort of talk about your own expectations with the language that's currently in the statute, and then also kind of follow up, I think, Shalene's terrific insight, which is, would one of the ways for whoever's focused on equity issues under the statutory language to really be working with localities to try to make sure that that's kind of a focal point for these energies. Again, I know there's other mandates that are in the statute itself. So if you could just sort of speak in general to what you thought issue 2 required or requires going forward, where you think we are with that, and then also, how much maybe opportunity there is for creativity as we move forward and see Ohio's industry and landscape advance.
So the 2 largest pieces that touch on social equity under the initiated statute, the first is obviously the funding of the Social Equity and Jobs Program Fund, right? 36% of all revenue generated by the 10% tax at the point of sale on adult use products goes into this new Social Equity Fund, which by statute is to be used on a number of equitable causes, some of which are aimed towards participation and representation in the industry to make sure that social equity applicants, are able to participate, and that fees and those sorts of things and the financial aspect are not barriers to participation in the industry, but also, direct investment in areas of the state that have been hit disproportionately hard by marijuana prohibition, funding and studying criminal justice reform, bail reform, those sorts of restorative efforts. The second piece is on, again, more of this representation perspective, in that the Department of Development under the statute is charged with creating this Social Equity and Jobs Program to certify participants such that the state will be in a position to issue 50 new dispensary licenses and 40 new cultivation licenses with a preference towards social equity program participants. And so where we're at from a process standpoint is we are waiting on the Department of Development to establish that program. The Division of Cannabis Control obviously can't issue licenses with a preference to participants in a program that has not been created yet.
And so, at the risk of trying to figure out what may be hard to figure out, why hasn't that program been created? What is it? Is it your sense that until we saw sales start and the market move forward, the Department of Development was disinclined to start producing it? Was it the fact that there was pretty significant debate about either eliminating or changing the terms of the social equity piece of the initiative in the General Assembly? Is it sort of all of the above? It's a busy summer. Do tell. Is there inadequate staffing? I've heard you talk about how challenging the Department of Commerce has things in the Division of Cannabis Control because they just don't have unlimited staff and they have a lot to do. What piece of it explains why we're not getting, it seems now 8 months on, any movement on that front?
I don't have a good answer to that question, Professor. I don't know. I have not interacted with the Department of Development on this topic in particular. We've been really focused on the rollout of the rules and the licensure process, from a more general standpoint. So I think I'd have to defer that question to the Department of Development.
Megan, do you have any insight, or is this the interesting missing piece that just everyone's been distracted, understandably so, with what Commerce is up to, and so this component of reform and development has just not been done by the Department of Development?
Yeah, I think it's an interesting question. I definitely just seen a lot less chatter and a lot less tension, at least in the media standpoint, when it comes to the social equity piece. A lot of it's been focused on, what's happening when it comes to sales and the steps that people are going through to get to that point where we can have our first sale. So that has kind of been like a missing piece, I would say, in the conversation. I think too, we're probably gonna talk about this in a little later, maybe in our conversation, but I think expungement is a huge part of it as well. And social equity was definitely talked about with lawmakers when they were trying to tweak this to expedite sales. So I definitely think that although it hasn't gotten as much attention as when the sales are going to start, I think it is an important piece that will be looked at more and more once sales have started and are rolled out.
I appreciate you bringing that up, Megan, because yeah, that's been my sense, and we've seen this both in the debate right after the initiative passed, and then in continuing debate about possible reform by the General Assembly. It seems like there's pretty bipartisan interest in creating an expungement or some other additional resources that's focused on record relief, which is great, but sometimes that's been coupled with an effort to limit or change, the revenue stream or other components of a broader social equity effort. And so I think that's one of the challenges, particularly for advocates for social equity, and in sort of both understanding the legal and political lay of the land kind of at this particular moment. I will definitely get to in a few minutes kind of what we can expect the General Assembly to jump in on in the future. But Shalene, again, I'm inclined to turn to you as the expert, not just on social equity, but on kind of feeling these politics out well. Is it sensible for advocates, concerned about the broad range of equity issues to say, let's start, sending letters to the Department of Development and say, get with it, come on, move faster, because, darn it, this is getting left behind? Or is there a sense that, if it really is a 3 to 5 year, sort of runway needed to do equity really effectively, that maybe a focus on, getting the legislature to do expungement or other components of maybe a community investment, as opposed to really focusing on, the industry itself for social equity? Your thoughts on kind of, what particularly Ohioans who I know care about these issues, but maybe uncertain in a dynamic and somewhat opaque world, where they should focus their time and energy to make sure those interests are considered.
Yeah, that's an important and practical question. And I would suggest, yes, I think you should absolutely make a fuss and call the department, make a public fuss, and point out that, this is the reason, or a big part of the reason why this law passed in the first place. We can't abandon it, in favor of sales once it has passed. And I think it's worth explicitly recognizing that there are financial reasons why there is such a fuss about why wind sales are going to start. Like, obviously customers want that, but also there is a strong incentive for companies that have put a lot of money into this effort. They need their doors to open, they need the revenue to come in, they're worried about their stock price. And so that's real, but that's also separated from what the people of Ohio are likely most interested in. And according to our research, Americans are most worried about ending arrests, and in social equity defined as repairing the harms. And so I do think it's important that they make that clear to the department. There's some good reasons why probably it's taking a while. And of course, I haven't been in touch with them either, but my guess would be collecting the data. Is if anybody has tried to get criminal justice data, or arrest data, how tough that is from different localities. And so if they're trying to identify different communities that have been harmed, that can take years. There's always missing pieces. And then also there's a lot more data now about what's working in other states than there was 5 years ago. And I think it's a great thing, but it's also probably confusing to regulators, not just in terms of social equity and expungement, but also, testing standards, potency. Now, instead of copying and pasting what other states are doing, you have a lot to evaluate. That's going to take longer. But all of that said, expungement does not take the time that licensing takes. And so if everybody can band together and say, let's work on expungement as our first priority right now, I think that's going to be great for everyone.
You mentioned something, Shalene, I want to follow up briefly, partially because I think I saw an email today or something, a new report out of Illinois, where Illinois was sort of bragging that they've got the most socially equitable industry in the country. Are there particular states in your work that you think about that, again, whether it's specifically for the Ohio regulators or for advocates who want to say, to the Department of Development or whatever else, these are the states to look to, these are the programs that have been most efficacious? Maybe it's also in working with localities. Is there a convenient, I know we've sort of tried to do this with the center to some degree, of sort of best practices, or at least the right places to look for as an industry matures and develops in a state, which states have been doing, better jobs on some of these issues?
I think that I have to read what Illinois just put out, but I think there's only one state right now that has worked with licensing and market structure effectively, and that's New York. 125 out of 133 of their currently operating licensees are people who have been harmed by the war on drugs. And that's just a complete 180 from every other state that's been struggling. And I actually think that's related to a lot of the pushback that they're getting, frankly. But then who's done well on expungement is an entirely different question. And I know you're an expert on that. That might be worth you mentioning as well.
I appreciate that, Shalene. You mentioned it very briefly, but I think it's such an interesting, in some sense, depressing reality that, here's the state that's done great on social equity, and that's the state that's often used by industry players and others as, look how terrible they've done licensing, and, aren't they awful, and what takes them so long, and why is this so hard? And so that's where I think even as you get political buy-in to doing equitable work, that doesn't make the tension go away in terms of the relationship between some industry players and regulators and the broader community. I think it's an ongoing challenge, and that's why it's such an important issue to continue focusing on. And so I think we've got our, not quite marching orders, but essentially we've got to make sure these issues remain front and center, especially in light of the requirements of the statute. One question that came in, I think it's important one and valuable to talk to, and eager to get everybody's sort of take on the medical industry, right? In many respects, we've talked a little bit already about how the adult use industry in Ohio is going to be starting with only dual use dispensaries and really built upon the regulatory structure there. But my sense is nationwide, my sense is there's an expectation to some degree here in Ohio that once the adult use market gets going, the medical market, if not disappearing, would decline significantly. And there are obviously a set of industry players who would be just fine with that. There may be a set of consumers who are just fine with that. I know, among other things, the cost of getting a medical recommendation, or I guess being registered in the state, went down to a cent in a recognition that in an adult use world, the medical regulations and rules and fees look a lot different. And so just would like kind of a quick take on what folks are expecting with the medical market and whether that's something that should be of concern for sort of advocates and researchers, or it's just, the market's going to do what the market's going to do. And no matter how hard we try, the folks are going to gravitate towards whatever part of the market makes sense to them. I'll start with you on that.
So the way that the division is regulating the adult use marijuana program, as you mentioned, Professor, we're starting with dual use dispensaries. It hazard a guess to say that every single dispensary that will come online over the course of the next year will be a dual use dispensary, meaning they're going to serve both adult use and medical patients. To be a dual use dispensary, you have to agree to stay a dual use dispensary for several years. And that comes with some requirements, right? You have to silo a certain amount of inventory to ensure that you can meet anticipated demand for medical patients and put other processes in place to ensure that medical patients continue to have access to medical marijuana products. And that was done so that we don't see medical patients get left behind. So I think what you'll see from the industry standpoint is the ability to service whatever the demand is ultimately for medical patients here in Ohio. If medical patients make the decision that they would prefer to not be a medical patient, they'll just buy adult use marijuana products. The industry will be able to adapt. But if patients say, no, you know what, I do want to be able to still talk to my doctor. Maybe I have some employment protections with my employer if I maintain my my patient card. So I want to keep that recommendation. Then I think you'll see the industry respond and still continue to be able to serve the existing medical industry. To be able to serve existing medical patients. And the move to Schedule 3 or potential move to Schedule 3 makes that question all the more interesting, which I know we'll talk about here in a little bit.
Yeah, I'm definitely going to get to rescheduling writ large, but I do think that's one of the ones that's necessarily a part of any conversation of predicting where the medical industry in Ohio or anywhere else may be headed. Megan, do you have a sense? I don't know if you followed kind of the medical story. We've at the Drug Enforcement Policy Center has done a annual patient survey, and we're asking a few questions about how patients or would-be patients are reacting to the coming availability of adult use. And so we'll be interested in reporting on that in the months ahead. But it's certainly something that has changed the dynamic of both access and market use in other states. Do you have a feel, Megan, about what folks are saying out there?
Yeah, absolutely. Yeah, I was a reporter previously at the Columbus Dispatch when medical marijuana sales first began in Ohio. And so I covered that back when that happened. And so now it's interesting to be reporting on the adult sales when that will start for the Ohio Capital Journal. But I think people like options. And so I think to Tom's point, I think some people who currently are on medical use marijuana will just use adult use, but some people will want to have the option and continue to use medical. So I think people will like having kind of the option. And like Tom was saying, since a dual use facilities will have to still provide medical, some people might just want to keep the status quo. So I think it'll be interesting to see. I do think there will be some folks that will just say, oh, it'll be easier to just do adult use than to get a recommendation from my doctor. So people might go that route, but we'll have to see what the data shows and what consumers choose to do ultimately.
I saw you nodding your head, Shalene. I don't know if you had a take on this. I'm sure you worked through this in Massachusetts and other places as well.
Yeah, I think this is one of the things that has actually changed significantly because it wasn't an issue for me 5 years ago. Our medical program was fine then, but now the numbers of patients has dropped dramatically. And I would say in my conversations with regulators, this is probably their number 2 concern after intoxicating hemp, because I think people are really worried about what's going to happen to their state program. And at the risk of repeating myself, this is something where it just can't be driven by industry, because I think if our values are that patients should have access, and that even patients who can't afford it should have access, and that patients should have access to strains that are maybe not the most profitable, then that is very different, from what the market is going to choose. And so I think we have to look at what our patients need and maybe make some changes to save these programs from disappearing.
Yeah, and I'll chime in as the kind of law professor for at least a minute. And I think a huge part of this, both in Ohio and nationwide, is going to be whether over time there are more legal protections for medical users that are distinct from, we know that sometimes the tax reality is different, and that's going to be true here in Ohio as well. But I think, and you mentioned this a little bit, Tom, whether it's I've got more employee protections as a medical user than I might as an adult user, maybe these are issues that get to childcare or other things as well, where status as a medical user just in law formally is different. And again, this is where you mentioned briefly, and we're not going to do it all today. We're doing another panel for the Drug Enforcement and Policy Center in a couple of weeks focusing on rescheduling at the federal level, but definitely my expectation is if rescheduling goes through, and so at the federal level, we have Schedule 3, which means there's legal medical uses that can very much change the legal landscape, so that there will be more folks who are using medically being able to make claims. Maybe it's under a variety of disability laws or in other ways to protect rights, but rights that will only be protected if you're a medical user and not just for recreational use. I think those are topics to keep an eye on, and we'll certainly be keeping an eye on it at the center. All right, I want to shift to kind of what's in the not too distant future, because I think there are some clear possibilities once we get past this November election. My understanding, Megan, you may know better than I do, there actually are no legislative sessions scheduled here in Ohio until we get through the election. And so there's not going to be any more talk, or at least action on possible legislative reforms to the initiative until we get to what's often called the lame duck period. But my instinct is that will be a period where there'll be this talk again. And assuming we have sales that have started and we're starting to watch the industry unfold a little bit, that may be even more of a fuel, especially if, and Tom, you mentioned this and I want to emphasize it, the money starts coming in terms of resources, from the special tax and other economic development that comes with it. The legislative reform could take all sorts of forms. Maybe there are folks who want to restrict the program more, but it may be, I think, more likely that it becomes much more real. They are much more eager at that point to redirect the tax resources relative to what the initiative put in place. And so I'm curious, especially for our local folks, whether they're looking to that lame duck period as a time when we might see some reform, particularly focused on tax revenue, and that might also be the time at which getting expungement or some other social equity as part of that is going to be a possibility. Are you hearing anything along those lines, Megan? Are you nervous, Tom, that at some point they're going to mess with this formula that's in place? Go ahead, Megan.
So yes, the lawmakers are not expected to come back until after the November election, like you mentioned, and so it's highly unlikely that between now and then that any action would be taken from the legislator standpoint when it comes to marijuana. But yes, we will be entering lame duck, which is the time right before the end of the current General Assembly, and then in January, a new General Assembly will start. General Assembly is gone for 2 years, and so any bill, no matter how close it was to passing, if it is not ultimately passed by the end of General Assembly during that lame duck period, would have to be reintroduced and start all over again for the next General Assembly, which is why there is such a rush during lame duck to pass bills, especially bills that are close to passing. And so yes, I do think that the tax revenue, the THC levels, home grow will all be things that could potentially be woven into bills and passed. Advertisement for marijuana has also been a hotly debated topic that's come up quite a bit. Lawmakers have also hit up on where marijuana can be smoked and making sure that children aren't walking in a park and smelling marijuana or seeing marijuana advertisements. So those have been some hot button issues for lawmakers that Republicans have brought up. So there has been definitely there's tensions in the House and the Senate, which for reasons that I don't have time to get into, that are at play here that have caused some bills to pass in the Senate, but maybe not really see much action over in the House, and vice versa, the House and the Senate. So that could also just come into play, some politics that aren't even related to marijuana as much. But yeah, definitely could be some changes, potential, or some changes that we might see during lame duck. But also too, next summer will be the budget cycle, and that sometimes is where we see legislation pass through the budget that might otherwise take a longer time to pass through as a bill.
Yeah, I really appreciate that, and they emphasize the budget point, because I've certainly been talking about and thinking about, and I'll turn to you in a minute, Tom, the reality that it seems like there's two windows. There's that lame duck window, which will be the outgoing legislature and things that they want to get done, and there's always a lot of legislative activity, as you mentioned, and this, I think, would be among the things kind of on their plate to at least seriously consider. And then there's the budget bill, which doesn't become official, if I've got this right, until the end of June, but that it's very common, because it has to get passed, that there'll be things included in there, and that further modification or changes joined into the budget bill could certainly happen. And it certainly would make sense, especially if we're talking about tax allocation, to think that that's a setting when they're thinking about dollars and cents, that they might be thinking about changing some of the allocations that issue 2 put forward. I'm wondering if you want to speak to, in this context, particularly the intoxicating hemp issue. Again, we could readily have 4 more seminars about just what intoxicating hemp is and how it impacts the cannabis marketplace. But I know Governor DeWine and some of his folks have been particularly vocal on saying that that's a key regulatory point of emphasis. And to some extent, and I'll let Tom speak to this too, that there are cannabis industry folks who like that idea. They don't like the idea that some hemp products have less regulations and can evade restrictions that traditional cannabis products have. And so would you expect that also to come up in lame duck or in the budget bill? And will this be all one gigantic bill, or does it seem more likely that there's no way they could all agree on everything? And so we'd expect more kind of partial bills to move their way through?
Yeah, definitely. Governor DeWine has definitely made calls for intoxicating hemp there to be stricter regulations and more crackdown on that. There hasn't been as much. I haven't seen as much of an appetite for that so far for state lawmakers, but there has been just so much that they've been trying to pass. And so I definitely think that could come up during lame duck. I don't know. I don't know if it would come up in. They could try to put it in all in one bill and make it into like a mega bill, so to speak. That could be a strategy. Sometimes they like to use the word, the vehicle to get this to pass. That could be the vehicle for it to pass, or they could maybe parse it out into more digestible chunks into other bills. So we'll have to see what the vehicle they choose to try to pass some of these
Very
changes.
good. Thank you, Megan. Tom, I assume your goal would be to have no vehicle moving along because you like where things stand, although that may not be true on the intoxicating hemp side of things, but your own take on kind of what we should expect from the General Assembly, whether lame duck, whether in the budget bill discussions or even beyond, as we see all the hard work of issue 2 and all the regulatory effect kind of move forward. Maybe a better way to even ask this is, are there particular things you worry about that would be, more likely to get the General Assembly to go beyond what's been kind of debate, but not action, into action?
Well, look, I'm an Irish Catholic lawyer. I worry about everything. It's just sort of my nature. What I will say is that by the time the legislature comes back into session, we will have a fully fleshed out regulatory program in the adult use market. So, issue 2, the initiated statute already provides for a prohibition on public consumption of marijuana products. So that's already taken care of in what the voters passed in November. The statute already provides and requires the Division of Cannabis Control to promulgate a number of different types of regulations about product advertising, testing, packaging, all of those sorts of things. So to the extent there are concerns about those issues, by the time the legislature comes back into session, they will already be addressed by the Division of Cannabis Control and will be effective law at that point. So, one thing I've learned over the last 2 years is that it's a fool's errand to predict what the General Assembly will do, let alone in a lame duck session. But I think the entire dynamic for the discussion about the adult use market will be dramatically different from where it's been over the last 6 or 7 months, because we will be able to point to exactly how this program is regulated, the exact way that they're treating advertising, the exact way they're protecting children with packaging and labeling requirements, et cetera.
Yeah, one thing that one of the Q&A questions sort of got to, potency has been a point of complication. There was a lot of uncertainty about what the language in the initiative actually sort of called for. And more broadly, I know the public health community is concerned about the potency of products, and I guess that's where I sort of wonder is is there an expectation that once the industry is up and going and the dispensaries are open, consumers will be able to get a wide range of potency products and get well educated about that so that they can be responsible consumers, or there are these concerns that the market's inclined to only cater to high potency users and to develop products that are riskiest. And I think your point is an extraordinarily important one, which is it's much easier to regulate once you see what's going on sensibly than to anticipate all the things that can go wrong if they're not actually doing that. But potency has been something that I certainly see from public health researchers and others, that there's a continued concern about and continued fear that the industry doesn't regulate itself very well in that space. And I'm wondering if you just want to speak to that briefly.
Yeah, absolutely. So just to be clear, there is no minimum potency under the adult use program. There are some types of products that are higher potency. Those are products that tend to be purchased by people who really need high potency products, right? People who have chronic or terminal conditions where they need a high potency product. But the vast majority of products that will be sold, certainly in the consumable market, will be much lower. And to that end, the division is considering promulgating rules right now as part of their rulemaking process, where edible products will be capped at 10 milligrams of THC per serving, and I think it's 100 milligrams per package. That's similar to the rules that Michigan has in place for their market. So you have to walk a line between certainly the consumer safety standpoint, which the division is really doing pretty thoughtfully, but also ensuring that the industry here in Ohio can compete with our neighboring states and with the illicit market. Because remember, one of the goals of any adult use market is to bring consumers into the regulated, tested, and taxed legal market so that they're not purchasing unregulated products that still are high potency, but they're also unregulated in the illicit market.
So Shalene, as we're starting to wrap up, and again, turning to you as sort of our national expert, are there things we've seen nationwide, there are particular problems or I know there are certain aspects of the industry that you're troubled by that you wish would sometimes trigger a legislative response, or at least, get regulation to move a particular direction? Or maybe that's even a good way to pose this is, if you were advising the Ohio General Assembly as they're now had debated but couldn't get anything done, didn't agree on further refinement going forward, what they should be watching for, as dispensary sales start, as the industry starts to unfold. I know what should be the focal point. We'll get back to expungement in a minute. We'll talk a little bit more criminal justice reform, always my favorite. But as a former regulator and an advisor and advocate towards policymakers, what do you keep an eye on right now, looking forward, to the next 6 months, the next year, for sensible ways to create a program for possible reform?
Well, this past weekend, we just held the anti-monopoly crash course and leadership training in Providence. And what we were trying to do is look forward, maybe a bit more than a year, maybe 5-10 years to federal legalization, because it is coming, and it is really important that states have that in mind as they build their programs, especially related to the discussion we just had about potency. I think that in general, the industry has been pretty responsible. I think it's in their best interest to be responsible, not to to at least minimize the harm that they're causing, and also to make sure that when it comes to not serving children, not getting around those rules, that they've been pretty compliant. However, we also know that the tobacco and alcohol industry has not been responsible. And once we have federal legalization, they already are planning now through fund groups to come in and start acquiring companies. And so I think it's really important as we look ahead that we're looking at things like potency, but that we're also looking at regulatory capture concerns and making sure that we won't have businesses that are so big that they'll be able to immediately circumvent the programs that we have now and the guidelines and restrictions. Because I think now we're kind of relying on the industry to be responsible, but we won't be able to do that 5 or 10 years down the line as we see more consolidation.
Very good, very helpful. Now I'm going to sort of self-servingly turn to and maybe Megan, you'll enjoy this too, because I'll focus on Tom and Shalene particularly. What are some other metrics that researchers and/or reporters ought to be sort of looking at? My sense is, and this is not meant as a criticism, but the industry is very good at sort of keeping track of who's buying what product, right, and of doing things, as is true for any industry, sort of tracking their market and how they're doing as an industry. But the broader community concerns. We've seen public health folks obviously try to study some public health impacts. That's challenging, especially in the short term, for a variety of complicated reasons. As a criminal justice researcher, I'm certainly thinking about looking at arrest rates, looking at whether we get expungements and what those look like, what kind of resources are devoted to that. But I guess I just sort of like to open it up of what are the dogs that might be barking that we're not listening for, or components of, you say, Tom, you worry about everything that's useful, but are there, parts of your worrying that you're worried people aren't paying attention to this component of the story, good or bad, things that, it's understandable that industry players, even researchers, sort of, kind of take the low-hanging fruit of what's out there and what to pay attention to. One thing that I'll kind of lean into, it's something that I think we've been seeing in the academic discourse about this, is the way culture is shifting around marijuana use, and how important it is to kind of build as much healthy culture as you can, right? You can even go at the industry level, start low and, go slow, or whatever, versions of that, where there's an understanding that it's important to get beyond, what the government's doing, what the regulators are doing, what the industry is doing. It's going to be about individual behavior and about helping people be responsible users. But are there components of those stories that you think, the more you think about it and look at it, the more you realize more people need to think about and look at that part of the equation, so that us at the center, Megan in her reporting, can make sure we don't miss that part. That's a really hard and vague question, but that's why I'm asking it. Tom, what do you think?
Man, that's a great question. I think one of the biggest things to watch is access for consumers, and are we successful in transitioning folks from buying in Michigan to the legal market? Are we successful in bringing them from the illicit market into Ohio's legal regulated market? The DEPC has done a tremendous job over the last several years with these patient surveys, sort of identifying why our medical program has had half of the number of patients that you would expect in a state of 11.5 million people, and identified a number of areas, right? Not enough dispensaries, products cost too much, they're too far away from each other, whatever those issues are. But something that gets lost sometimes in some of those reasons, the industry gets criticized. Oh, prices are too high. It's the big bad operators. But there's not always an understanding of, well, what are the costs that those operators have to incur in order to participate in this market, right? 280, right? I can't take standard business deductions. Well, that has a real impact on prices for consumers. I have to pay $100,000 every single year just to renew my cultivator license, or I got to pay $70,000 every 2 years just to renew my dispensary license. Every advertising that has to get pre-approved is a new fee. Every employee is a new fee. We got to have storage costs for surveillance, but all of those costs are in the background that ultimately have to get passed on to the consumer in some way, shape, or form. So the one thing that I would suggest, keeping an eye on are, okay, this program's up, it's running. How can we ensure that we can, as an industry, accommodate consumers enough so that they're not still feeling like they have to go to Michigan, or they're not still feeling like they have to buy products at a gas station or in the illicit market?
Thank you. Very, very helpful. Okay, Shalene, you've gotten a chance to think of the answer to my vague and hard question.
Well, I guess I would want to defer to the public health community because they say a lot that our research is not keeping up with the products. And I think that is so true. Even where we do have limited data, where there have been emergency room calls, there's not good data about what products those were and where they came from. And I think in general, if we just knew more information about the products, the mode of consumption, and like you said, if we could at least just keep up with the industry, we could have better regulations. I definitely worry about advertising, especially if 280E gets reversed, which of course it should because it's an unfair rule. Companies will be able to deduct their advertising and marketing expenses, and that could cause a lot of problems given what products are likely to advertise most. The other piece I want to emphasize is worker surveys. I don't think there's enough information about what workers are going through, and when we do have surveys, it's usually owners or consumers. And my impression of Ohio is that there's a pretty strong labor movement, so maybe this is something that Ohio would lead in. I would love to see that data. And sadly, being in Massachusetts, I was a regulator in the state where a worker died because of worker conditions. And I'm always thinking about what we might have done differently, and maybe some more data and information could have prevented it.
No, thank you. And it's sad to hear that story. But yeah, we've been thinking as a center about, kind of who's working at dispensaries and where does that fit into sort of a broader set of kind of economic development realities. And there's some economists and some others who've been doing sort of research just about, whether and how cannabis reform sort of changes the economic landscape in a variety of ways. I think those are also really hard but really important questions that I appreciate you particularly focusing on the worker piece of it, because I think there's a lot to that as well. Megan, I don't want to give you cut you out from the opportunity to answer the hard and vague question, but maybe I'll sort of start wrapping us up by saying, like, what are you planning? I don't know if you get to decide exactly what your pitch agenda is, but as you're looking forward to, we've already joked a little bit and half seriously, half depressingly. Well, of course, there's going to be coverage of when the store starts selling product, but I'm wondering what other stories you're planning to cover and how you look at reporting in this space in the months and years to come.
Yeah, definitely focusing initially on sales, but I think a lot of what has come from this conversation has been enlightening, and I want to follow up on. I want to really look into the expungement and the efforts with that. Just talking to consumers, both people who are medical use. Are they going to continue down that path? Are they going to do adults and then adult users, and just their thoughts on how the program is going, how the rollout is, how sales, their perspective on how things are going. And also, I want to do look at the social equity component of issue 2 as well once sales are being rolled out. And of course, I'll be watching closely during lame duck. There's lots of things I'll be keeping an eye on, and my team as well. I'll be keeping an eye on. So lots to cover. So this is giving me some great ideas for stories to look into.
Wonderful, thank you. And I guess I teased expungement a fair amount. It's useful to sort of circle back here as we wind up. Emphasize that our center, the Drug Enforcement and Policy Center, has done a lot of work on all sorts of record relief, and that includes a service project called Opportunity Port that helps people get access to legal help to seal their records under existing Ohio law. One of the interesting dynamics of that is the extent to which Ohio's got fairly robust petition-based record relief mechanisms, but we know, and this has been a universal story, not just in the cannabis space, but across the board, that's necessarily going to be limited in use because of the costs and the hassles that come up with doing a petition-based work rather than the automatic general approach. But that's also being studied. If you tell people you've gotten your record expunged or sealed, but they don't really know, and also there's a challenge with people with multiple records. Maybe they have a cannabis offense and they have a bunch of other offenses. It can sometimes be better to have a chance to do a petition-based system, be connected with legal help, and get all of that done rather than have something done automatically and then not have access to further relief. And so that's one of the challenges that we're studying and following. I will say, and this is my pitch, and again, credit to issue 2, though we'll see if the Department of Development channels those resources. Ultimately, on all those fronts, it's a resource issue. It's getting information out to people to know that they have the possibility of getting some record relief, helping them get that. And then it's also helping them utilize that effectively, helping them understand whether it's they're seeking employment, they're seeking housing, they're seeking schooling opportunities, that they have additional abilities to do that because of record relief. That's just a lot of work. It's really hard and costly. And so I'm hopeful the Department of Development, as it gets those funds in, as I expect them to be flowing, we'll be investing in that space effectively to help Ohioans. And that's where I know we'll be looking. I also want to make that pitch generally, and I'll give everybody the sort of last word. The Drug Enforcement and Policy Center is obviously going to keep following these topics going forward, and we're always eager to hear from policymakers, to hear from advocates, to hear from interested reporters and the community at large about what topics they think merit more attention and focus. And so the kind of last pitch, I already sort of did it before, but Shalene, Tom, Megan, a last word and or a last recommendation. What should the next panel be about? What should the next report be about? What do you think we ought to be making sure we don't leave behind in our conversations as we get on the, it seems, precipice of actual sales here in Ohio in an adult use cannabis market? Go ahead, Shalene.
I just wanted to acknowledge the Supernova Women group that did a social equity impact report. They found that every dollar spent on social equity programs had a $1.20 return, but when it was a direct reinvestment piece, it jumped up to $4.56 in return. So that might go way farther. And my understanding from surveys is that there's a bipartisan support for that type of reinvestment, and the majority of Republicans support it. I also wanted to say there's 6 days left to submit your public comment to the DEA about rescheduling. I'm part of a coalition, decriminalizemarijuana.com, where we have a tool. And there was also a great panel by my colleague, Kat Packer at the Drug Enforcement and Policy Center to talk about rescheduling. So you can watch that to prepare your comments as well.
Thank you so much. Great plug. Everybody's feel free to plug. Tom, I don't know if you've got the future issue 5 in the works, but you can feel free to plug and or just tell us what we should be working on.
This is going to sound like a little bit of brown nosing, but honestly, just keep doing from the DEPC standpoint, keep doing the things that you guys are doing. I mean, I'll echo what Shalene said earlier. I view in my practice, I view the DEPC as, one of the most credible sources of information about this industry, about the myriad of policy issues that are important to the industry and important to people here in Ohio and throughout the country. And you guys are an incredible resource on any number of topics, both the criminal justice reform, but also the marijuana policy piece of this. So just really thankful, Professor Berman, for your work, and Yana and Holly and your team of law students and everything that you guys are doing to give real trustworthy, actionable data and insights to help guide a lot of these really tricky and important policy conversations.
Well, thank you so much. And I'm going to be self-serving and allow that to be the last word unless Megan wants to jump in with something else. But I'm incredibly grateful to all of you, not just the whole DEPC team to help get this platform up and running so effectively, but for all the great insights, Shalene, Megan, and Tom, you've shared today. I am certain this conversation doesn't end right now, and it's going to continue. And I'm looking forward to being able to call on you to continue to help inform us and the community at large on where we are and where we're headed here in Ohio and nationwide on these important topics. So thank you so much. Appreciate it. Have a good afternoon, everybody. Thank you all for attending, and we'll see you in a couple weeks, hopefully, for the rescheduling event.
Welcome, everyone. My name is Bill Froelich, and I'm the director of the Divided Community Project, and I'm delighted to welcome so many of you here today from across the country. I saw friends from Cleveland, I saw friends from Hawaii, and many places in between. The Divided Community Project, it supports communities that are seeking to identify and address issues tearing at their respective social fabrics. We're modeled in a way after CRS, and one of our colleagues here on the screen, Grant Blum, was our first director and a former director of CRS. The Divided Community Project believes that many organizations and communities have the capacity to address civil rights, peacemaking, and conflict resolution, to address issues tearing at community social fabrics, not just in the V of civil litigation, but to communities as a whole. And we think there are layers in which folks can approach community-wide conflict, from CRS, as Grand Lum has done in the past, from statewide offices, on a local level through cities or